ओके कैसे हो सब लोग? कम ऑन, तो आप सबका स्वागत है टू द फाइनल राउंड्स ऑफ द 7th यस मूट कोर्ट कंपटीशन 2026। आज हम लोग अपने 7th एडिशन ऑफ मूट कोर्ट कंपटीशन के फाइनल राउंड में, जहां पे प्रिलिमिनरी राउंड में अपने कोर्ट रूम से जो भी दो बेस्ट स्पीकर्स थे वो एक नए केस के साथ आज अपना रिसर्च और अपना मेडल प्रूव करेंगे। एंड बाय द एंड ऑफ द डे वील नो कि कौन सा वो ऐसा स्टूडेंट है जो 7th यस मूट कोर्ट कंपटीशन में अपना मेडल प्रूव करके बेस्ट मूटर अवार्ड लेके जाता है। ठीक है, आज हमारे यहाँ पे 14 बच्चे हैं, जो 14 बच्चे एक क्रिमिनल केस है उस क्रिमिनल केस को आर्ग्यू करने वाले हैं। बहुत ही इंटरेस्टिंग सा केस है, जिसने भी ड्राफ्ट किया बहुत ही दिमाग लगा के ड्राफ्ट किया केस को। तो सबसे पहले ह्यूज राउंड ऑफ अप्लॉज फॉर द ड्राफ्ट। ठीक है, तो बेसिकली एक क्रिमिनल केस है। क्रिमिनल केस के ऊपर ये सारे के सारे हमारे 14 स्टूडेंट्स आज आर्ग्यू करने वाले हैं, जिसमें से इन लोगों को 5 अवार्ड्स आज दिए जाएंगे। पहला ऑफ कोर्स द विनर, देन यू विल हैव द फर्स्ट रनर अप, द सेकंड रनर अप, द बेस्ट स्पीकर एंड द बेस्ट रिसर्चर। इसके अलावा आज जो अपना फेलिसिटेशन सेरेमनी होगा उसमें यू विल आल्सो गेट योर आर्टिकल राइटिंग के अवार्ड्स एज वेल एज योर बेस्ट स्पीकर अवार्ड जो प्रिलिमिनरी राउंड में मिला था। तो पहले हम लोग अपने सारे के सारे 14 कंटेस्टेंट्स को सुनेंगे, विल गेट द रिजल्ट्स फाइनलाइज्ड एंड देन फेलिसिटेशन सेरेमनी में आप सबको आपके अवार्ड्स मिल जाएंगे। ठीक है, आज के इन स्टूडेंट्स को जज करने के लिए हमारे पास एक बहुत ही एस्टीम्ड पैनल है, जिस पैनल में बहुत सारे अलग अलग फील्ड के जो एक्सपर्ट जजेस है वो लोग आपको जज करने के लिए आए हैं। सो पहला आई विल इंट्रोड्यूस द पैनल टू यू ऑल। सबसे पहले वी हैव एडवोकेट विशिष्टा नायक मैम, हु इज गोना जज यू ऑल फॉर टुडेस कॉम्पिटिशन। Thank you ma'am for taking out time from your lectures and agreeing to judge our kids. Thank you. ठीक है, next we have CS Suchi Goyal ma'am, who's gonna be a part of the panel of judges for today. Thank you so much ma'am for being here. And a new addition to our panel of judges is CS Vicky sir, Vicky Gyanchandani sir, who's gonna be here to judge you all today. विकी सर जितना ज्यादा आप लोगों को सीधे दिखते हैं वो उतने सीधे है नहीं, तो आई थिंक ही इज द वन जिससे आपको डरना चाहिए। एंड ऑफ कोर्स विद देम आई एम गोना बी द पार्ट ऑफ द पैनल ऑफ द जजेस। बीच में अराउंड 11 o'clock विकास सर एंड चिराग सर आल्सो गोना जॉइन अस, बट प्राइमरली फ्रॉम द वेरी बिगनिंग। सो बेसिकली आपका टुवर्ड्स द एंड या टुवर्ड्स द मिड 6 पैनल का जजेस 6 जजेस का पैनल रहने वाला है, जहां पे B4 आर गोना स्टार्ट अभी से एंड देन दोस पीपल आर गोना जॉइन अस लेटर। डन? एनी क्वेश्चंस? अच्छा, जैसे इस कस्टमरी हम आपको रूल समझा देते हैं, तो जितने भी पार्टिसिपेंट्स हैं सारे पार्टिसिपेंट्स अभी जाके एक रूम में, एक क्लासरूम में बैठने वाले हैं विदाउट एनी एक्सेस टू द आउटसाइड वर्ल्ड। आपके फोन्स और सारे इलेक्ट्रॉनिक डिवाइसेस यहाँ पे मेरे पास जमा कर दिए जाएंगे। एक एक करके जब पार्टिसिपेंट्स आएंगे और अपना अपना केस प्रेजेंट करेंगे, उसके बाद यू कैन टेक योर फोन्स एंड सिट विद अस ओवर हियर। दिस इज डन टू एंश्योर कि किसी भी तरह का अनफेयर मींस यूज नहीं किया जा रहा है एंड सारे के सारे पार्टिसिपेंट्स को एक फेयर अपॉर्चुनिटी मिल रहा है टू प्रेजेंट देयर केसेस। ठीक है, चलो, तो विदाउट एनी फर्दर अडो लेट्स स्टार्ट विथ आवर फाइनल राउंड। ऑल द पार्टिसिपेंट्स प्लीज सबमिट योर फोन्स ओवर हियर एंड प्रोसीड विथ प्रणाली मैम टू द सेकंड फ्लोर का क्लास। अच्छा, हम तो बोलना भूल गए, अच्छा वो बाद में भूलेंगे। फोन के साथ साथ एनी अदर इलेक्ट्रॉनिक डिवाइस, इफ यू हैव योर लैपटॉप, इफ यू हैव योर टैब, एनीथिंग यू हैव, प्लीज सबमिट इट ओवर हियर साइलेंट मोड में डाल के। सुबल साइलेंट मोड किया ना? हाँ, सामने कैमरा है, थर्ड साइड हो जाओ। हाँ, हाँ जल्दी। ए चलेगा चलेगा, महाराष्ट्र बोल दे। 6 7 स्मार्ट वॉच भी अब किसी के पास स्मार्ट वॉच है? इससे अगर तुम चीटिंग कर लिया तो पक्का 2 3 4 5 6 7 8 9 10 11 12 13। एक और किसी का फोन बाकी है? निकिता का? हाँ, 13। I have 13 phones over here. Who's not submitted? अच्छा, अतिथि। All right. अच्छा, if anybody is wearing a smart watch, आप लोग अपना स्मार्ट वॉच भी आके यहाँ दे दीजिए प्लीज। बंद है? श्योर? नहीं ठीक है, आई ट्रस्ट यू। तुम एग्जीक्यूटिव किया ना, इसलिए आई ट्रस्ट यू। ये वही प्रिंट निकाले अपने फोन से। चलो, ऑल द बेस्ट गाइज, मे द बेस्ट पार्टिसिपेंट विन टुडे। जाओ और तैयारी करो अब। यस अनुष्का, यू कैन स्टे बैक ओवर हियर, वील स्टार्ट। चलो प्रणाली मैम प्लीज टेक देम टू द वो, आपके पास नंबर है ना? हाँ कहाँ से आएगी? हाँ हाँ पानी का बोतल यही है, नीचे में बस बच्चे बैठे हैं, फोटो नहीं किया। डन। सो जजेस प्लीज इधर आके बैठ जाओ। विकी सर इधर। All right, so guys, we're going to start in 5 minutes. The first participant is Anushka Jain, who's gonna appear from the respondent, that is the side of the state in the matter of Arav Mehta versus state of Dakshinayan or state of Maharashtra. रुक जा अभी 5 मिनट, हमारी जज ही नहीं आई है। और बोली मेरे को भूख लग रही है, और सोची मैम को भूख के लिए कौन मना कर? सही में मेरे को नहीं बोली ऐसा कुछ। आराम से बाहर बैठ के चिल मार। वेरी एवरीबॉडी है So we are beginning with our rounds, and the first participant today is Anushka Jain. She will be appearing from the respondent side in the matter of Arav Mehta versus State of Dakshinayan.
The Council seeks permission to address the bench collectively as your Lordship. The Council is here on behalf of the State of Dakshinayan. The Council would further like to state the facts of the case. A door without a handle turned a century into a tomb, and the silence of the man who held the key became the verdict of the death. Further, the Council would like to submit the memo of the case. The accused Arav Mehta is a qualified and experienced software and system consultant who conceptualized, implemented, and retained exclusive technological control over a digital-only access system governing ingress and egress of the premise in question. The said system eliminated all conventional or mechanical modes of exit, making occupants entirely dependent on the network connectivity, power supply, and software functionality for their physical safety and ability to evacuate. Prior the incident, the accused had actual and constructive knowledge of the system vulnerabilities, including manufacturer manual, warning of failure during network outrage of battery drain. Prior complaints and negative reviews, documenting instances where occupants were temporarily trapped due to system malfunction. Despite such knowledge, the accused failed to install adequate safeguards, including manual overrides, redundant systems, or emergency fail-safe mechanisms, and did not provide occupants with alternative means of exit. On the date of the incident, a forcible emergency situation arose, during which the digital access system failed, rendering occupants unable to exit the premise. The accused, despite being alerted and having the ability to intervene or override the system, failed to take timely corrective actions amounting to culpable omission. As a direct and proximate consequence of being trapped, due to the failure of digital-only access system, the deceased suffered fatal harm and succumbed to death. The prosecution contends that the death was not a result of unavoidable accident or mere technological failure, but the outcome of the accused's conscious design, choices, gross negligence, and breach of heightened duty of care arising from exclusive control over a safety critical system. In short, a life was not lost by chance, but by a man's deliberate inaction while controlling the only escape. The Council would further like to state the statement of charges. The very first charge, whether the accused possesses the requisite knowledge under Section 304, Part 2 of Indian Penal Code. Charge 2, whether the accused caused the death of the deceased by a rash and grossly negligent act and culpable omission, punishable under Section 304A of the Indian Penal Code, by implementing and maintaining a restrictive digital-only access system without adequate safeguards and by failing to act during a forcible emergency. Charge 3, whether the accused by exercising exclusive technological control and ingress and egress assumed a heightened duty of care towards occupant, and whether breach of such duty through omissions give rise to independent criminal liability. Further, the Council would like to state the summary of the arguments. Okay. Section 304 Part 2 IPC is attracted where the accused caused death by an act done with the knowledge that is likely to cause death, though without any intention to cause death. The prosecution submits that the accused's conduct in the present case reflects conscious and informed risk-taking going beyond mere negligence. Basically, the Council here needs to prove the knowledge. Arav had the knowledge that this would amount into something that would have been severe. The Council would like to prove on the basis of this test that I would like to further mention. The subjective knowledge test. The accused is trained software professional and therefore a sophisticated user of network-dependent digital system. He had actual and personal knowledge of the system's vulnerabilities through the manufacturer manual, which clearly warned the failure due to the network disruption of battery depletion. The awareness was further reinforced by a prior guest complaint that specifically highlighted delayed access and confinement-like conditions. Such material establishes that the accused was subjectively aware that the system could malfunction and trap occupants. The very next test that can be studied is the forcibility and the risk creation test. Despite this knowledge, the accused deliberately implemented a restrictive digital-only access system and removed any physical or alternative means of exit. By centralizing exclusive control with himself, he created a foreseeable risk and occupants could be confined during emergencies. A reasonable person with similar expertise would recognize that such confinement could endanger life. The next test, it is basically from the tort, but we can apply it here, the eggshell skull rule. This is statutory test for causation. It did ask, did the act accelerate a pre-existing condition? The law, if the act accelerates the death of a person with a disorder, the law deems that you caused the death. The fact that 24 minutes delay prevented the medical help that would have saved him. By preventing help, Arav's lock was the immediate cause of death during the critical movement. It is said that you take your victim as you find them. We can apply this under section 299 culpable homicide also, under which the explanation 1 is given. A person who causes bodily injury to another who is laboring under a disorder, disease or bodily infirmity and thereby accelerates the death of that other shall be deemed to have caused the death. The conclusion, taken cumulatively, the accused specialized knowledge, prior warnings, deliberate design choices. The failure to act establishes that he had knowledge that his conduct was likely to cause death. Accordingly, the mental element required under section 304 part 2 IPC stands satisfied. The counsel would further state the charge 2. Arguments for the charge 2. Section 304A IPC penalizes causing death by a rash or negligent.
In your first argument, you said that if somebody is suffering from a infirmity or a disease, and if you do something that accelerates the death or that disease or whatever, then it is covered under section 304A. That is what you said, right?
299 explanation 1.
299, right? Okay. So in the instant case, if you go to point 19, there is a statement which says that the treating doctor noted that earlier intervention could have significantly improved survival chances, right? Yes. So in our opinion, it wasn't the locking of the door or the fact that the door did not open on time that led to Ritesh's death, but in fact it was the fact that they delayed in taking him to the hospital. Again, if you come to point 18, it says Ritesh collapsed around 12:50 and he was taken to a private hospital at around 1:30, bypassing a government hospital which was closer to the apartment. So if you read these two facts conjointly, you will understand that Ritesh could have been saved had they taken a faster way of treating him, which could have been the government hospital. Instead, they chose, the friends or whoever was with Ritesh, they chose to go to a further hospital, which in my opinion was the act that accelerated his condition and deteriorated his condition. So it wasn't actually Arab's mistake, it was actually the friend's mistake, and I think they should be here charged with these charges.
The argument between Nikhil and Ritesh broke at 12:10. He had started breathing issues at the very same point. They bypassed the government hospital. The motive wasn't to basically, sir, the speculations that he would have been saved if he would have been taken to the government hospital could not break the criminal causation. It was the chain of events that occurred.
Counsel, it's not a speculation. The treating doctor who's an expert has said this.
But the delay, the major delay that was caused because of the door was locked, and not because, even if with the very primary duty, if we say, if the door is locked and I cannot open it, I cannot walk out of it. If the door was open, let's consider the door was open, he was being taken on proper time and he would have still reached even the private hospital if he would have. The major time loss that they had was when the door was locked. They couldn't reach there basically because they were trying to figure out how to open the door, because there were no manual exits that could have been given. A delegated duty should be given by Arav, that in case of any emergency, in case fire broke in the same room, they had to move out. The very thing to escape was open the door and walk out from it. The major key to get out was the door. If that was locked, anything that would have occurred would have caused the death of the person inside the room. Correct. So major reason for his death was not just the bypassing, that was a very negligible take, I would say, but the proportion that caused the death was majorly locking the door in such a way that one couldn't move out without the manual exits.
Counsel, you just gave an example that had there been a fire in the apartment and had they not been able to go out of the apartment, then they would have died being stuck in the apartment, right? In that case, we could have blamed Arav, because the whole reason why they would have fallen prey to this fire would have been because they were not able to get out of the apartment. The reason behind whom, which would be Arav, right? But in the instant case, that is not the situation. That is what I'm trying to tell you. In the instant case, it's not just Arav's fault. There could be a slight delay because of Arav, but even when they were able to get this person out of the apartment, they chose deliberately to not go to a closer hospital, and then they chose to go to a further hospital. Is there a slight chance that had they gone to the closer hospital, Ritesh could have been saved?
The motive of his friends would never be to risk his life. They were in a panic situation.
Is motive relevant in criminal cases?
No, sir. They were in a panic situation. The intent was not to, they did not think about what could have been done. The easiest option that they thought first, they tried for it.
We are anyway not talking about intention. We are talking about knowledge over here, right? Did they have the knowledge that delaying this treatment could have affected chances of Ritesh's survival?
The delay was already done. The delay was already done because of the
and they further delayed it.
The further delay was very negligible delay.
Nowhere has it been given that it was negligible. It just says that the government hospital was closer to the apartment. It is a speculation saying that it was a negligible delay. It could have happened, it could have so happened that the trauma center, government trauma center, was just next to the apartment, right? So we don't know how much delay was caused while taking him to the government private hospital and not taking him to the government hospital. That's just speculation, right? Acha, one more thing. Did the friends of Ritesh try to call emergency services?
They tried calling the ambulance.
Please come to point 17.
The calling of ambulance was done, but statement differs on who suggested it.
Correct. Other emergency services. So we have other people who can help us out. We can call the police, we can call the fire brigade. In such situations, you can call these people to help you out, right? Did any of the people present there call any of these people?
In the very first place, the access was, the safety was protected on a single device. That device was with Arav. Anything that would have been done from outside or from inside would have been breaking it. In the very primary instance, the occurrence of asthma in the very first place arose because of the compact, the place that they were into. The intervention, the lock prevented ventilation and access emergency exit. Thus, lock was proximate cause and not a remote factor. Shall I proceed with charge 2? Whether the accused caused the death of the deceased by a rash and grossly negligent act and culpable omission, Yes, sir.
So we are on the charge of culpable homicide not amounting to murder, and you're basing it on the fact that Arav Mehta had knowledge that his actions could have caused. Okay. How do you say that Arav Mehta had knowledge of any such thing would happen when it is very clearly stated in the fact sheet that number 1, parties were explicitly prohibited in his property. Number 2, more than 4 people were explicitly prohibited in the property. Number 3, he wasn't informed that there was a person who was suffering through asthma in the property at that point of time, right? He had no knowledge that people were partying at his place. He had no knowledge that there would be smoke. He had no knowledge that there would be so many people. And he had no knowledge that there would be a person who could suffer such a panic attack or such an asthma attack, right? So how do you show that Arav had sufficient knowledge to bring him under the ambit of section 299, culpable homicide not amounting to murder?
So for your lordship, the further I would like to state it in a way that ordinary course of nature test. The principle the court asks, would a person of ordinary prudence note that this act is likely to cause death? Okay. Application, if you lock 2 people in a room with a faulty electronic lock and then make yourself unreachable, any reasonable person would know that a medical emergency or a fire would likely result in death. Arav's specific knowledge of the lock glitches makes it even more certain. May I? The section 304A IPC penalizes causing death by a rash or negligent act not amounting to culpable homicide. The prosecution needs not prove intention or knowledge of the death. It must establish the existence of the duty of care, breach of the duty amounting to gross negligence, direct and proximate causal connection between the breach and the death. The present case satisfies all the 3 elements in their strongest form. Duty of care, creation of special relationship. The assumption of responsibility or duty of care. By installing and controlling a digital only access system, the accused assume exclusive control over the occupants, ability to enter or exit the premise. This created a special relationship imposing a high-end duty of care. Continuous accessibility, emergency override mechanisms and reasonable responsive in emergencies. In international criminal negligence standards, recognizes that one who creates potentially dangerous situation owes a positive duty to prevent harm. The accused cannot disclaim the duty after deliberately centralizing control. Breach of duty, gross, not simple negligence. Gross negligence test. The accused's conduct constitutes gross negligence, not mere error of judgment for the following reasons. Single point of failure design. The system was entirely dependent on the network connectivity and battery power, with no physical or mechanical fallbacks. Disregard of known risk. Manufacturer warning explicitly cautioned against access failure. A prior guest complaint further alerted the accused to confinement risk. Professional negligence standard. As a software expert, the accused is held to a higher standard of care. What might be simple negligence for a layman person becomes a gross negligence when committed by a professional with a specialized knowledge. Failure to act, that is the omission. The accused ignored repeated emergency calls despite being the sole authority capable of restoring access. This conduct reflects reckless indifference to human safety, meeting the threshold of criminal negligence. The rashness and recklessness, conscious risk ignored. Rashness involves acting with awareness of risk but with due caution. Negligence involves failure to foresee a risk that ought to have been foreseen. The accused's conduct embodies both. He was aware of the system's failure risk and he failed to implement basic safety measures. The such cumulative fault squarely attracts section 304A IPC. The causation, direct and proximate link to death. Doctrine, causa causans, the proximate cause. The negligent act system and accused inaction were the direct, effective and proximate cause of death. The chain of causation remains unbroken because the confinement prevented timely exit and medical intervention. The emergency response was entirely dependent on the accused's action. No independent or unforeseeable intervening acts has superseded the accused's negligence. The law requires only that negligence be substantial contributing cause, not the sole cause. Herein, the victim's conduct is irrelevant. Contributory negligence is not a defense in criminal law. Even if the deceased had vulnerabilities or made personal choices, criminal does not recognize contributory negligence as defense. Once the accused's negligence materially contributed to death, liability attaches. Basically, when the parties were organized, when he was drunk, even if he was drunk, that does not amount to a contributory negligence. That cannot stand as a defense out there. The policy considerations, technology and criminal negligence. Modern criminal law must respond to technology-induced risk. Permitting individuals to evade liability for deploying unsafe automated systems would undermine public safety. Section 304A IPC functions as a regulatory safeguard ensuring accountability where innovation outspaces caution. The conclusion, the accused assumed a clear duty of care, breached that duty through gross professional negligence, created a forcible and dangerous situation, failed to act when intervention was possible, and directly caused the death of the deceased. Accordingly, the offense of causing death by negligence under Section 304A IPC stands conclusively proved beyond reasonable doubt.
Counsel, when the booking was confirmed, this guy who made the booking got an email from Arav, which explicitly contained a warning which said, remote unlocking may be delayed or fail under low network availability or battery constraints. So the person who was hosting the party actually had knowledge that there is a possibility that the door remote unlocking might fail after 12 o'clock, right? So in a way, when Arav did not have any knowledge or he could not reasonably foresee that a party would be going on in the apartment, given that it was not allowed, and when he is already given a warning that remote unlocking may be delayed or it might also fail in certain cases, I don't see how he has breached his duty of care, because one, he wasn't aware of the foreseeable risk, and number two, his duty to care, I think he has rendered that by giving a warning to the occupants that this is a possibility, this might happen. Instead, I think instead of prosecuting Arav, you should be prosecuting the person who hosted the party, because he knew that remote unlocking could be a failure. He knew, or even if he didn't know, there were people in the party who knew that Ritesh has asthma history, and despite all of that, they kept Ritesh in that situation, and thirdly, they didn't call emergency services, neither did they take him to the nearer hospital. I think all of these chain of events conclusively prove that the people who were there with Ritesh at that point of time, including the host of the party, they should be held responsible for culpable homicide with negligence, and not Arav. I think Arav fulfilled his duty to care sufficiently by giving a warning and by telling the people that these things can happen.
So this, my lordship, this can be derived from the doctrine non-deligibility of duty of care. Safety critical duties, especially those involving movement, access or emergency escapes, are non-deligible. The accused could not delegate exit safety to software, emergency responses to connectivity, and human availability to automation. Once such duty is assumed, it cannot be outsourced to code or devices. Your counsel, your lordship, the counsel please ignorance. I do not have the case right now.
So this is something we'll assume you're saying by yourself. This is your opinion. Because if you have an authority stating this, what you're saying, then the case is absolutely in your favor. So if you can prove or show me an authority, the case is yours.
I just want to understand whether it is a gross negligence. You quoted somewhere that it is a gross negligence, right?
Yeah,
so how it is a gross negligence?
when there is a single point of failure design. There was no other medium through which the door could have been accessed. There was single point of failure design, disregard of the known risk, professional negligence standard. He was a professional, he had the knowledge. If there are battery issues or if there are other issues, the device could have failed. Even if we consider it in a way that it was the omission, it was his act of omission, that he did not have any spare options or any manual exits for it. So it was a gross negligence from his side.
So just because of omission, can you quote that it is gross negligence?
An act or an omission,
If you refer to the quoted section, right, I don't think so it will come under gross negligence. Because the arguments which you are providing, everything is based on certain facts, okay? And secondary, you are making him basically, you know, liable for the activity. But my basic question is whether it is a gross negligence, because if it is not a gross negligence, your entire argument is of no use as of now, as far as charge 2 is concerned. This is what I feel.
Your lordship, the likewise I said, the single point of failure design, the disregard of known risk, professional negligence standards, failure to act, these there is no basic test that what would be really a gross negligence in would differ from case to case. Every case has its facts different, has its severity different. So one standard method cannot decide if it was a gross act or it was not.
So basically you are trying to say that partying is okay, over occupying the premises is okay, but sleeping and not attending the call is gross negligence.
Partying should not amount. Sleeping wasn't the issue at
Alcohol
all.
was the issue.
The delegation, his work was to delegate in case of any emergency that could have occurred. The delegation, he did not delegated his he did not delegated any other option to have an exit route from there. Sleeping was never an option. No one is expected that he'll pick up a call at 12:30 am or at night and he'll do that. That's completely understandable. But his act of not delegating a way out in case of an emergency is the major issue.
In case of an emergency, right, there was other option that was available to call the emergency services.
The first major issue, the first major act, anybody, if we are at anyone's apartment and that is not opening, the first thing that we would do is ask the owner of the apartment that how do I get out of this place? The way, that is the first instance. Any human mind, any practically, one would do is he'll see the primary source and he'll take an exit from there. If that doesn't happen, they'll go for the secondary method, as later they tried with the chair to open the door.
So basically you earlier pointed out that they tried to call you know, the person जिसका वो premises है.
6 missed calls and 2 messages.
6 missed calls. So when he can do 6 missed calls to that person, can't he call one person to the one who can give the emergency services to them?
The argument had broken, the panic was created. The very first thing that they were doing is constantly calling him, ki, just pick up the call and I need to get out of this. The very person who knew the lock, the password to the lock or the exit route was him. So the first primary instance of them was just to get out of it. If that did not work out, then they would have then they would have figured out the secondary ways to move out from the room, which they later did by throwing chair on the.
Just last question. 12:35 a.m. right? They are trying to say point number 16. 12:35 a.m. one attendee attempted to break the door. ठीक है, जो भी lock है. बट यहाँ पे ये लोग क्या बोल रहे हैं, एट पॉइंट नंबर 17 नो कॉल वॉज मेड टू इमरजेंसी सर्विसेज अंटिल 1:05 AM. तो ये जो 30 मिनट्स का टाइम पीरियड था, दैट इज नॉट सफिशिएंट टू कॉल द इमरजेंसी सर्विसेज. Still they are pushing on that one person who is not responding to the calls and messages for 30 minutes, 6 people inside the premises.
The counsel would like to state the charge 3.
Can you just summarily complete the charge?
Okay. Whether the accused, by exercising exclusive technological control over ingress and egress, assumed a heightened duty of care towards occupant, and whether the breach of duty through such omission gives rise to independent criminal liability. The very first argument that I would like to state would be the doctrine of non-deligibility of duty of care. Safety critical duties, especially those involving movements, access or emergency escapes, are non-deligible. The accused could not delegate exit safety to the software, emergency response to connectivity, human availability to automation. Control to responsibility principle determines in criminal jurisprudence, control is moral and legal basis of responsibility. The accused control the conditions of the access, control the only means of exit, control the response mechanism. When liberty of movement is mediated exclusively through one person's technological interface, responsibility follows control as a matter of principle. Technology here was not autonomous, it was an extension of the accused's will. Calling it a technological failure is legally equivalent to saying the lock failed or the gate failed. Yet courts have consistently held that the control over safety mechanisms carries responsibility or their failure. The voluntary undertaking doctrine was a choice and not an accident. This case is not about passive ownership of technology. It is about a voluntary undertaking. The accused consciously chose to replace ordinary physical access with digital-only system, centralized all the control and with himself, operate the premise under that model. Criminal law draws a sharp distinction between accidental failures and failure within a system voluntarily designed and imposed by the accused. Once a person elects to run a risk-bearing system, liability attaches to the design framework, not the failure point. This is why the defense cannot reframe a human design choice as a neutral technological mishap.
Do you have any authority which says that?
I've actually figured out all the doctrines and I've based my case around it. So,
Prayer?
Prayer.
Prayer?
in the light of the facts set forth, the questions of the question of law raised and arguments advanced, it is most humbly and respectfully prayed before the Honorable Court that it may be pleased to convict the accused Arav Mehta under Section 304 Part 2 IPC for causing the death of Ritesh Kulkarni through reckless omission and deliberate disregard for human life, hold the accused's failure to unlock the respond during a medical emergency as a direct cause of death constituting culpable omission, reject any appeal or application for relief by the accused, ensuring the justice is upheld, pass any further order as the Honorable Court may deem fit, just and proper, to uphold justice and accountability and the rule of law.
This was our first participant, Anushka Jain, who appeared from the respondent side. Next up, we have Nikita, who's going to appear from the appellant side, that is Arav Mehta. She'll be arguing and trying to prove why Arav Mehta should not be convicted in the instant case, and the conviction order passed by the trial court should be reversed. Next up, we have Nikita, who will be appearing from the appellant Arav Mehta's side.
Am I audible? Can I just take 2 minutes? So, my sorry, I didn't notice. I'm so sorry. Good morning, bench. If it may please the Honorable Court, this is Counsel Nikita Bhagwat, arguing on the behalf of Appellate Arav Mehta in the case of State of Dakshinayan versus Arav Mehta. May I address the bench collectively as your Lordship? If your Lordship permits, Counsel would like to state the facts of the case. Okay. Arav Mehta, facts of the case are, Arav Mehta owned an apartment that he rented for a short stays under a clear rules limiting the number of guests and prohibiting parties or gatherings. These terms were accepted at the time of booking. The apartment used a smart lock system operated through mobile application. Arav did not stay at the premises and was not present on the night of the incident. Despite the agreed terms, the guests hosted an unauthorized gathering involving 7 additional people and alcohol consumption without Arav's knowledge or consent, which was above the limit given in the terms as mentioned. The booking listed maximum occupancy of 4 persons and explicitly prohibited parties. During the gathering, one attendee, that's Ritesh Kulkarni, suffered severe breathing difficulty, who also had a history of asthma, including hospitalization for 6 months earlier. The people present did not immediately call emergency service, and the delay of nearly 55 minutes occurred before the professional medical help was sought. By the time Ritesh was taken to the hospital, his condition had worsened and he later passed away due to the respiratory failure. Arav Mehta was asleep and unaware of both the unauthorized gathering and medical emergency when these events occurred. If your lordship permits, counsel would like to state the issues of the case. Issues of the case are whether Arav Mehta can be held criminally liable for the death of the deceased when the incident occurred during an unauthorized gathering conducted in the violation of agreed terms of occupancy. Issue 2 is whether the deceased and the attendees, by willfully breaching the contractual terms and hosting unauthorized gatherings, voluntarily assumed the risk of consequences, thereby mitigating the duty of care owed by Arav Mehta. Issue 3, whether the delay of nearly 55 minutes by the attendees in the seeking professional medical assistance constitutes an independent intervening act, breaking the chain of causation between Arav Mehta's conduct and the death. If the lordship permits, counsel would like to state the arguments of each issue. Issue 1. So can I repeat the issues again and then go for the arguments, or directly go for the argument? Okay. First, no criminal liability can arise from an act done outside the scope of consent. That is, it is submitted that Arav Mehta permitted the guests to occupy the apartment only under a specific conditions, which clearly prohibited parties or large gatherings. The incident occurred after the guests willfully violated these agreed terms. Once the premises were used in the manner explicitly prohibited, the accused cannot be held criminally responsible for the consequences arising from such misuse. Criminal liability cannot be extended beyond the scope of consent and control. Second, unauthorized gatherings amount to an independent intervening act. The unauthorized gathering fundamentally changed the nature of occupancy and introduced new unforeseen risks, including overcrowding, alcohol consumption, and delayed response during an emergency.
Counsel, where does it say this, that unauthorized gathering amounts to an independent intervening act? Do you have any authority?
Sorry, I didn't get the last line which you said.
The point you're just referring to, this unauthorized gathering one.
Yes.
Do you have any authority to support that point?
So ma'am, just a minute. As in the case which has been given, it is said that there is the maximum occupancy is 4 and explicitly prohibited parties. So there are 2 points in this line, and which clearly state that there is only 4.
No, I understand what an unauthorized gathering is. I'm saying you are claiming that unauthorized gathering amounts to an independent intervening act in the chain of events, right?
Okay, okay. I understood your question.
What authority are you citing?
Okay.
Or using to support this argument?
Okay. So as we have read in the facts, Nikhil was supposed to be in the property, but he called.
I'm asking you the authority, not facts. Are you using a case law or any principle of law?
And there are case laws that I have attached.
It's point. See, I'll explain it to you. You're claiming unauthorized gathering amounts to an independent intervening act, right? This is something that you are giving us to prove your point that there was an unauthorized gathering which resulted, which amounts to an independent intervening act, right? Now, where is this coming from?
Just can I complete my words once?
Sure.
And then, so the reason why I said about the Nikhil's the thing is because as per the facts, he was only supposed to be there, but he for a weekend stay. But him, without informing the actual owner, he gathered 7 people. Firstly, that is only wrong, because you can gather 4 people only when after the permission of the owner. He gathered 7 people, and that too resulting in the consumption of alcohol. So there were two events happened which was not as per the rules which they have given, sorry, the terms which they have been signed. So I think that is where this point may come.
Let me come to your point only. You're saying unauthorized gathering, only 4 people were supposed to be there, there were 7. But was the presence of 7 people responsible for whatever happened?
No.
Was the mere presence that there were 7 people, even if there were 4 people and they were stuck inside, panic could have happened, exactly the same situation could have occurred?
Yeah.
So how is the unauthorized gathering responsible?
We are studying the case because there was a dementia of a person that has been happened. So if there was 4 or more than 4 person who have been gathered, then without any XYZ things has happened, then this wasn't maybe been an issue, I guess. If there was no an illegal outcome which has been came, or there was no demands or any unfortunate outcome which has been came from here.
I'm sorry, I'm not able to understand. Can you please repeat?
Can you ask the question again, because I got a little confused.
See, I'll make it very clear. Okay, come to page number 7. What you have submitted to us, come to page number 7.
Yes.
There is issue number 1, right?
Yeah.
There is point number 2.
Yeah.
आ जाओ, ठीक है. आप point number 2 को एक बार read करो वापस से.
Unauthorized gathering amounts to an independent intervening act.
Unauthorized gathering amounts to, क्या amount करता है वो? Independent
intervening act.
What is the meaning of independent intervening act? This is what she is trying to ask you. How an gathering can amount to independent intervening act? Number 1. Number 2, what is independent intervening act?
So the moment these terms have been breached, that means occupancy of 7 and this, after that I guess that is when the terms have been exceeded. So Arav won't be liable for anything that has been happened over here, because he was not unaware about these things.
No, I absolutely understand your arguments. My question is very simple.
You want to know the meaning?
Yes.
Independent intervening act is after certain action, the person won't be liable for the things that he was liable as
Where
before.
it is defined.
This is my interpretation.
That is
might
absolutely okay. You might have some source of it, right? Maybe ChatGPT.
I have read a couple of cases, but I did not included each one of them because there was 10 to 12 cases which was there. I can't. I don't remember that one.
Have you made your memo yourself?
Yes, yes.
And you
This
don't remember the
morning
font?
I made.
Yeah, looks like that. And you don't remember the font?
No, I
Because as far as I know, this double underline and random change of font size and font only happens when you're using AI.
Sorry?
ChatGPT?
Ma'am, there are some things that I have searched from ChatGPT, and also I have chose some cases from whatsoever, but I made the format, and it's not that I just copy pasted
Because
it.
so conveniently you've just picked up the crisp of the cases that you're citing.
I think that's what I should do, that I should focus on the points that where my client is correct.
And give the prompt to ChatGPT, please give me the most important points.
No, I disagree to that, because I didn't do that as you're claiming.
Come to page number 7.
Yes.
Supreme Court का quote किया आपने.
Sorry.
You have quoted the Supreme Court held that.
Yeah.
ठीक है. उसके नीचे वाला underline देखो, in your case. This is you have drafted. In your case मतलब in my case you are referring to.
Sorry. And a double underline.
हाँ, I'll again come to you. Come to page number 7.
Yes.
Right. Page number 7. There is a statement that the Supreme Court held that. ठीक है. उसके नीचे अगर आप देखोगे तो there is one more underline. In your case.
Yes.
Right. In whose case?
So you're talking about the Keshav Lal versus the state of Maharashtra?
Do you have the memo?
Yes.
Yeah, show it to me. Ra. Supreme Court held that right.
हाँ.
In your case, where does it say uske niche wala double underline wala? What is your case? Whose case? Our case?
The Arav Mehta's case. Arav Mehta and the
So
state
why
of...
does it say in your case?
I thought that mentioning that again and again is not necessary.
This is what ChatGPT says when you ask him something, then ChatGPT points out and says in your case.
See, let me answer.
She
that.
disagrees.
Let me answer. I did not say that that I disagree that I did not use ChatGPT. I did. Along with that, I used from Indian Kanun as well. But I made format by myself. And here, as you're asking, in this case, I did not think that I have
Counsel,
to
the
mention
most
the case.
terrible thing in this memo is actually format, which you made yourself. Next is the, I think, arguments. You could have just said, yes, I use ChatGPT, and we would have been like, yeah, okay. But since you disagreed, now we have to look for things.
And this is my first time. मतलब पहले के बाद इसमें. So
Using ChatGPT. Your case तो हटा देती यार, हमारा ही केस बना दिया. ये 7 का साइज देखो, 8 का साइज देखो.
I was confused. Where did I stop?
Amounts to Independent Intervening Act.
So should I go for the third point? Intervening. So I have explained that. See that I said as yeah, it's my interpretation. Obviously I might be wrong. कहाँ से? Okay. Duty of care does not exceed to willful and illegal misuse of premises. The duty of care owed by a property owner is not absolute. It extends only to lawful and authorized use of premises. Arav Mehta could not reasonably foresee that the guest would host an unauthorized gathering in a direct violation of contractual terms. Imposing liability in such a circumstances would amount to punishing the accused for acts beyond his knowledge and control. Can I go for? Absence of mens rea or gross negligence on the part of Arav Mehta. Criminal liability for death requires mens rea or gross negligence. Arav Mehta neither hosted the gathering, nor was present, nor had any knowledge of violation of occupancy terms. The factors disclose a breach of contracts by the guest, not criminal negligence by the owner.
I just want to understand one more point, if you can explain this. Again, issue number 1, point number 4, absence of mens rea or gross negligence.
So that is, I guess, point number 5.
अच्छा, मेरे यहाँ पे point number 4 है.
अच्छा, हाँ. I just explained, so हाँ.
Okay, absence of mens rea. What is mens rea?
Action without a guilty mind. There was an
Without
action.
a guilty mind. Gross negligence. So if you have quoted absence of mens rea or gross negligence, this shows as per you whether mens rea and gross negligence is one and the same thing. Alternate words, same meaning. Is this the case?
I don't think 100% accurate.
Okay, tell me 99%. It is okay.
That what is
gross negligence?
What is the difference between two?
नहीं, what is gross negligence? You are saying, right, कि Arav Mehta के case में there is an absence of gross negligence.
So what is gross negligence?
Yes, please.
So gross negligence is a partial negligence, I believe.
Partial negligence. In this case, what is gross negligence? Which Arav had not done?
So here the Arav did, even though there was logged and all of that, he did not had any wrong intentions.
But he did not receive the call, yeah, right? If someone is staying at your premises, he is calling you, right? And you're not picking up the call. After 6 calls, after mentioning urgent, this is not negligence.
But he has called in the midnight, and obviously
Who's the owner of property?
Arav.
If someone happens at that property, who is liable?
But that does not mean that you are calling in the midnight.
Who's liable?
So counsel, for example, there was a fire. They're all locked inside. Not supposed to call after 12.
But okay, they were supposed to call, okay, once or twice. Then they have to go for the actual solution, na? So here, despite all the parties and everything.
So could they have known that he would actually die? It was a panic attack. He had been hospitalized before as well.
I agree.
So obviously they would call the owner ki please come and unlock the door. We need to just go outside to get some air.
I agree. And as per that, he did call to our. Can I answer her? Yeah, but as per her question, she was said कि तो क्या करे अभी? So what he must have done, he did. कि उन्होंने call किया, message किया. Okay, what one can do here कि आरव की गलती है, हमारी गलती है. That is not the point. The point is कि वो deceased person मरना नहीं चाहिए था. That is the point.
एक second. The point is not कि किसकी गलती है. Then why are you here for the case?
No, obviously I am here to support, but just for your supposed question कि उसको कॉल करना चाहिए था, उसको उठाना चाहिए.
It's not a supposed question, it is a question.
Okay, so in that case
I'm very clear with my question.
Okay.
Do you understand what
yes,
I just asked? Yeah.
Yes. So he had called and he has also texted. But what he can do, he should not. He called वगैरह तो उसके बाद वो wait तो करते हुए बैठेगा नहीं. What he can do is to get out of that situation.
wait करते नहीं बैठेगा?
मतलब अगर निखिल या फिर उसके friends जो भी थे वेट तो करेंगे नहीं.
तो उनको पहले से पता था ये निपट जाएगा?
नहीं मैम, अगर फायर लगा होता तो सॉरी लॉर्ड लेडीशिप सॉरी.
अरे वो बहुत आगे बढ़ चुकी है. वो फेंक के मारने वाली है कुछ मेरे को या विक्की सर को. या सॉरी.
सो एज यू सेड कि अगर आग लगती वगैरह ना तो उन्होंने कॉल किया, मैसेज किया. ओके, दे डिड.
नो, आई सेड दैट टू योर आर्ग्यूमेंट दैट दे वर नॉट सपोज्ड टू कॉल आफ्टर 12. देन यू चेंज्ड योर आर्ग्यूमेंट, सो आई चेंज्ड माय क्वेश्चन.
That is the secondary argument. First is they called. That is the right thing that they did because they were supposed to call. Owner को ही call करेंगे. तो उसके बाद क्या किया कि नहीं कर पाए, मैसेज नहीं कर पाए. In that way, you are also twisting questions. So how can I not?
I have to reframe. I have to reframe my supposed questions, no?
So that's why when I am answering, so how can I become wrong? So he called and he texted. Okay, and then what he can do is, it's not about कि अभी वो नहीं उठा रहा है तो मैं क्या करूँ, मैं घर पे बैठ जाऊँगा. That is not the thing. He has to rescue himself or his friend, which here happened.
Who has to rescue himself? The guy who is dying out of breathlessness.
No. Here, yeah. हाँ रितेश. नहीं वो नहीं मरा है अभी. in the circumstance नहीं मरा. हाँ, Ritesh was feeling breathless, anxious as it mentioned. So his friends who already knew that he's suffering and all the things that he was been admitted and there was a little critical situation happened. They might have called, say, fire extinguisher, so that they could break in and bypass and then save the guy. That is the main intent of the case. Among the 7, I agree. Yes, that is the thing.
Counsel, will you come to this case of Keshav Lal versus State of Maharashtra?
Yes.
Okay. So here, can we move on to this case? Yeah. So it says, when an independent act of another person intervenes, the act becomes immediate cause of. अच्छा ये same ही point है क्या? ये आपका GPT हटाना भूल गया?
My.
Yeah.
MS
Can you tell us brief facts of the case? And how are they similar to the present case in your case? So,
just can I take 2 minutes so that I.
चलो एक काम करते हैं, लेट्स डू वन थिंग, ठीक है, लेट्स नॉट मोर कॉम्प्लिकेटेड, है ना, फटाफट से इशू नंबर 1 जो है आपका, राइट, उसके अंदर यू हैव कोटेड 5 पॉइंट्स. पॉइंट नंबर 1 यू आर ट्राइंग टू से देयर इज नो क्रिमिनल लाइबिलिटी, मतलब देयर इज सम प्रीमाइसेस, राइट, इन दैट प्रीमाइसेस देयर आर 7 पीपल, ठीक है, and as per the facts of the case there is some problem, medical emergency, and you are sleeping at home at 12:30 after 6 calls, urgent messages, still you are saying that it is not a duty of care. Number 1. Number 2, you are trying to say unauthorized gathering, right? ये इंटरवीनिंग वाला पॉइंट मैंने आपके साथ पहले ही डिस्कस कर लिया, ठीक है. ग्रॉस नेग्लिजेंस वाला पार्ट आपको नहीं लगता है सच में ग्रॉस नेग्लिजेंस है? बिकॉज एज पर द मैनुअल इट इज योर ड्यूटी कि जो भी व्यक्ति आपके पास वहां पे रहने आ रहा है, यू आर सपोज टू गिव हिम द की. एंड पहले भी इस तरीके से सिचुएशंस हो चुके हैं कि यू नो still you are not satisfied that he is, you know, in the category of gross negligence and he should be made liable over here. This is what I feel.
Okay, so
Firstly, you are not picking up the call. ठीक है. Secondly, you are the owner of the property who should take care that what is happening in the property, right? You have ignored all those facts. Thirdly, basically there is gross negligence as per me, as per the facts of the case, because you are not answering. There is no emergency services. The physical keys have not been kept yet. So this is what I feel. If you have anything to say on this, you can please comment on it.
can I take 2 minutes?
You take 3 minutes.
Okay. As you mentioned, the call has been made, message has been sent. 6 times the message has been sent, and I won't say that Arav is completely right over here, even though he was responsible, obviously he's the owner, he's responsible, but the necessary thing here is to save Ritesh, which they couldn't do because there was some chaos that has happened which was out of Arav's knowledge. So here, okay, the death situation happened, but that comes fundamentally from the things that they did wrong.
If he was able to come out of the house when he said that or step outside for air,
Who came out?
he wanted to, what's the Ritesh.
Okay, Ritesh, okay.
So if he could have stepped out right then and there at 12:10, I don't think the death would have happened. It's a basic panic situation which resulted into severe asthma.
So
Plus the terms and conditions also said, and the advisory guidelines on emergency preparedness provide that there needs to be 24-hour host availability. So you can't even argue on that point that they shouldn't have called after 12 or he wasn't,
okay,
you know, liable to be available 24/7.
yes, but here there was the doors have been shut and they couldn't go out, but they had phones. Okay, they did not, Arav did not pick up the call. That does not mean they could not reach out to the other possible ways that they could save the friend, and they couldn't
Which
do that.
they did ultimately.
Sorry,
Which they did, right?
after 55 minutes.
No, after 55 minutes they reached the hospital.
Yeah, but they it has been mentioned in the case that
So the entire thing started around at 12:20. At 1:30 they were at a private hospital providing the best care. What else do you expect?
and also they have bypassed the government hospital which was nearby, and they chose to go a little far as well. And he was in a life and death situation.
Exactly. But there is more possibility that the person may turn off
Okay,
completely.
if that's so. There was also a delay that they have made for 55 minutes. Okay, they have called the owner. Yes. That we can know only through the case, that the facts that has mentioned in the case. So there are 4-5 points that they said. First, Arav ko call kiya, message kiya, those things. Other than that, there was no other thing that I mentioned that they
No,
reached
you
out
said there
somewhere
was
else.
a delay of 55 minutes, right?
Yeah.
So to prove that there was a delay, you need to prove that for 55 minutes they were sitting idly not doing anything that they were supposed to do. When did these 55 minutes start? At what time? And when did these end? How have you calculated these?
That 55 minutes, it's a vacuum. जो जब उसको थोड़ा सा uneasiness
Counsel,
feel.
I understood that. What does it mean? Because the fact sheet never mentioned 55 minutes. What time did the calculation start? When did it end? Tell me the time zone.
From 12:18 to 1:30 a.m. 30.
And they haven't done anything between that.
They have called Arav.
Your 55 minutes come from 12:10 to 1:05. It should start from 12:10 when the argument broke out. He started looking anxious, and 1:05 when the call was made to emergency services. This is the 55 minutes you're talking about.
That ma'am, that तो I agreed that I took help, but I don't agree that पूरा मैंने छापा है. अरे if I have written in my memo तो मैं तो argue करूँगी that I agree to these facts, वरना मैं क्यों include कर? Sorry. You accept that there is a cross negligence from the part of Arav? Yes, हाँ तो बोलो. Partially yes, not completely. But not as much कि उसको वो section 304 में ऐसे हो. तो उनकी भी तो गलती है ना. That they firstly, okay, he did not pick up the call, I agree. But ये 7 लोग gather हुए, उन्होंने alcohol consumption
So
किया.
was the gathering of 7 people responsible for whatever happened? Was he a claustrophobic? कि 4 लोग नहीं 7 लोग इकट्ठे हो गए, suddenly I can't breathe, I need to get out.
He had a medical issues before.
Yeah, so how is 7 people gathering instead of 4 responsible for whatever happened?
No, it's not about 7 and 4. It's about the people who are there, but they couldn't do anything other than calling Arav. That's what they did at the end. And but why didn't they call the ambulance or other means? तो दैट इज द अल्टीमेट थिंग वन मस्ट डू. हमारे घर में किसी को हेल्थ ठीक नहीं है तो ओके, आई डोंट कॉल माई फादर एंड मदर, आई माइट कॉल देम, बट उन्होंने पिक नहीं किया तो मैं अपने घर वालों को तो नहीं छोड़ूंगी ना. मैं पहले वो करूंगी कि उनकी जान बचे या फिर जो भी वहाँ पे एक्ट हो रहा है वो काम करे. माई फादर डिड नॉट पिक अप, माई मदर डिड नॉट पिक अप, दैट इज नॉट द क्या बोलता है कि जस्टिफिकेशन दैट आई वुड गिव. सो there is a negligence, but not as much as कि वो उसको causing death by there is a negligence, but I won't say कि इतना liable हो कि उसके ऊपर section ये section सब apply. As my definition of cross negligence is not accurate. Of cross negligence, that I can't, I don't know the exact word to word definition. Sure. The first, willful breach of contract attracts the doctrine of okay, I'm sorry. No, this one I just wanted to cut. Yeah, this one I did. Because I did not study it. So. There are few things that I didn't study. Yeah, yeah, that is the reason. So I have no idea about this. I wanted to strike that, but I couldn't do it. Sorry? Sir, I have no I say proper answer so that I can.
What?
I don't know. I don't know, sir. So I'm little intimidated by the questions that you've been asking. So if I was in the room, I might have called the ambulance rather than justifying Arav did not pick up the call. So, next. Assumption of risk sustainability mitigates the duty of care. The duty of care owned by Arav Mehta was premised on lawful and authorized use of the premises. Once the guest exceeded permitted occupancy and hosted an unauthorized gathering, they materially altered the risk environment. In such circumstances, the law recognizes that the host's duty of care is mitigated as the risk was created and enhanced by the occupants themselves. Can I go further? The deceased and attendees had full knowledge of the risk. The deceased and attendees were not unaware that they knew the occupancy limits, knew gatherings were prohibited, still chose to proceed. Such conscious decision making establishes knowledge and voluntarily acceptance of risk, a key requirement of assumption of risk. No, the deceased didn't disclose it. That was somewhere he went wrong as well. Yes. He was at fault, but he was at fault. That is to बिल्कुल ही other situation. Here he knew about his health and he still consumed the alcohol which he was not supposed to do. Due to which in the 19th point the medical records says that that elevated the blood alcohol levels and that was the primary reason that he got unconscious.
What was the primary reason?
Acute respiratory failure, delayed admission and elevated blood alcohol levels. This is given in the
These were the medical records, like whatever was happening to him. Nowhere says that these were the things responsible.
Along with the anxious breathlessness.
But did whatever anxious breathlessness happened, was it because of the consumption of alcohol?
I think it's an if situation.
Sorry?
It's an if situation because as much as I have read and the information given in this, it was not clearly mentioned every ifs and buts.
Counsel, what is over-criminalization of accidents?
Where it is?
Sorry, what is over-criminalization of accidents?
Would you care to say that where have I mentioned?
Yeah. What the Supreme Court held in Jacob Matthew case, Point number 4.
In issue first or second?
We are on issue 2, right?
Yeah.
Yeah. So there.
In that, which point, ma'am?
Jacob Matthew versus State of Punjab.
Yeah.
What the court held. Point number
What the
4.
Supreme Court held?
Yes. Point number 4.
Court
Court
must guard
must have.
against over criminalization of accidents
Yes.
of mishaps. I don't know, ma'am. No, which I really don't know. I would say I don't know rather than saying anything.
Counsel शुरू से ही बोल देना था. I don't know anything. नहीं? You know few things.
Yes.
Confidence जरूरी. So counsel, my fellow judge wants you to explain how the Jacob Matthew case is relevant in our case.
So is it fair if I read it once? So, a criminal law should be invoked only in the cases of gross
Counsel,
negligence.
tell us the facts of Jacob Matthew case and then tell us how are you applying that case in the present case.
Can I take 2 minutes? Because I have to say
Yeah,
crisp
30 seconds.
60, please.
Counsel?
Yes. Just a second. Can I? So first we'll go to Arav's points that these are the things that we have read in facts as well. That he did not host the gathering. So there was the recklessness that has happened in the Jacob. That I don't know. I did. In that case, I did not study in depth about this case. I've studied. Yeah. They have given you here. Criminal law should be invoked only in the cases of gross negligence. A person cannot be held criminally liable unless the act shows recklessness or difference to consequence. Sorry? The standard for criminal negligence is much higher than in the civil law. The court must guard against over-criminalization of accidents or mishaps.
See, firstly, you are accepting that there is gross negligence partially as per your previous argument, right? Am I correct?
Yeah.
Okay. Second stage pe you yourself are quoting what the Supreme Court held that criminal law should be invoked only in cases of gross negligence. Firstly, you are admitting that there is gross negligence. Secondly, you yourself have quoted that criminal law should be invoked only in cases of gross negligence. तो आप फेवर में बात कर रहे हैं अपने क्लाइंट की कि अगेंस्ट में बात कर रहे हैं?
फेवर में ही बात कर रही हूँ.
तो फिर ये दोनों चीजें तो अगेंस्ट में जा रही है मैम.
Recklessness and the
नहीं,
gathering.
there is no concept of recklessness as far as
It is there in the second point.
नहीं, I am talking about first.
Okay. कि gross.
There is no gross negligence you have admitted. Number 2, issue number 2 के अंदर first point you are saying कि criminal law should be invoked, right? Only in cases of gross negligence. तो यहाँ पे तो आपके खिलाफ ही बातें चल रही है मैम. आप अपने
But that negligence happened also backed by these people as well. It was not completely Arav's fault.
Who is the owner of property?
Arav.
Who should be made
But
liable?
Arav has been told that only one person would stay.
One person, where it is written?
So he was Nikhil.
Where it is written? Nowhere in the fact of the case it has mentioned that one person should only stay. अकेला कैसे रह सकता है यार घर पे इंसान?
Okay, if so, then how did even if not that, there was only 4 members who have in terms 4 लोगों को
Let
बोला.
us say कि उन चारों का क्या करना है, we'll talk that later on. Let us focus on Arav. Are you admitting that there is gross negligence on the part of Arav?
I said partially even before.
Partially, right? So he should be made liable partially. Admit it?
Yeah.
Please go ahead.
Prayer.
But conclusion के बाद third issue.
In the light of facts stated, the issues raised, arguments advanced, and authority cites, it is most humbly prayed before the Honorable Court, be pleased to allow the appeal, set aside the conviction under Section 304, Part 2 of IPC, and acquit the appellant. In the alternative, kindly modify the conviction of Section 304A IPC and pass any other order that the court may deem fit in the interest of justice, equity, and good conscience. My bad.
Thank you, Nikita. Next up, we have Sumer. Next up, we have Sumer Bhansali. He will be arguing from the side of the respondent, that is the state, in the matter of Arav Mehta versus State of Dakshinayan.
If it may please the Honorable Court, I am Counsel Sumer Hansraji Bhansali, presenting on behalf of the State of Dakshinayan in the case of Arav Mehta versus State of Dakshinayan. If this court may permit, counsel would like to approach the bench and present the facts and memorandum of the case. Sir, I thought. If this may please the Honorable Court, the counsel would like to present the introduction of the case. Introduction and then brief facts of the case. My ladyship and my lordship, this case is not about a freak accident or momentary lapse. It's about a deliberate and a profit-driven choice to run a short-term rental in a manner that converted a residential apartment into a trap which has a single exit door with no manual override, no manual key, and no presence of the owner at the site. And also, the only power to unlock this lock was vested in the hands of the appellant, which he chose to render himself as unreachable. In that trap, a young 25-year-old engineering student with a known respiratory vulnerability suffered an asthma attack and died after a critical delay in evacuation and treatment that the medical evidence tells us could have the difference between life and death. If this may please the Honorable Court, the counsel would like to present the brief facts of the case. Okay, sure. This case raised three legal issues, the core legal issues as issue first, the duty and breach. Second is mental element, that is mere knowledge, mere negligence versus the knowledge. And the third is causation. If the Honorable Court may permit, counsel would like to present the first issue and their arguments. Thank you, Your Lordship and Your Ladyship. The first issue is, did the appellant owed a breached a clear legal duty of care towards the occupants? To address this, as the owner and the commercial host of a short-term rental, appellant invited paying guests into his premises and thereby owed a duty of care and a reasonable care for their safety and especially regarding safe entry and exits. He configured an auto-locking smart lock so that the main door automatically locked from outside at midnight could only be opened via a mobile app on his phone and had no physical key or any manual override and gave no audible alert inside the when it engaged. This means after midnight, guests could be locked inside and could exit only if the appellant responded. Despite of the clear warning in the manual that there can be chances of failures in case of network issues and other software glitches, and an earlier complaint about the delayed access, he still used and promoted this system without any manual exit option. To support this arguments, in the case of Sushil Ansal versus State of Delhi, NCT Delhi, the facts of this case was that a cinema house was owned at a green park by Ansal brothers in New Delhi, and at the basement of that cinema there was a transformer of Delhi Vidyut Board which caught fire, and due to lack of narrow space at the exits, the party who suffered the death could not escape in the within time. Also, the fire entered the balcony and which caused death of 59 people due to smoke inhalation. The Honorable Apex Court stated that where the controllers of the commercial premises were held criminally liable and owed a duty of care. Similarly, the appellant as a commercial short-term renter hosts a similar and owed a breach of duty to ensure safe exits to the occupants. Moving forward to the second issue, whether the appellant's conduct...
Counsel. The case that you just stated,
Yes.
in that case, a fire broke out in the cinema hall,
Yes.
and as an immediate effect of that fire, 59 people lost their lives, which is why the owners were held liable, right?
Yes.
In the instant case, there is a fact which is very, very, very crucial, which differentiates our case from the Sushil Ansal case. That is, even when they were able to take the deceased out of the apartment, they chose not to go to the closer government hospital. Rather, they went to the farther hospital, which was a private hospital. And in the medical report, doctor has clearly stated that had this person gotten his treatment earlier, he could have been saved. So here, I don't see any direct nexus between the fact that the door was locked and the person passed away. There is no direct nexus, because there is a possibility that this person passed away because of the delay caused because of the choice of going to the private hospital and not to the government hospital. In the cinema hall case, there was no such breakage of link in between.
Your Lordship, there was a narrow exit, the seat due to earn profits at the balcony.
Exactly, because of all these reasons, they
Yes.
were held liable, right?
Yes.
That's what I'm saying. In the instant case, these facts are not present. Had it been the case that, you know, the door did not open only and they could not go out of the house, and
Yes.
because of that, this person died, probably then this case and this case would have been very, very similar to each other. But in this case, ultimately the door was opened and they took him to the hospital. There, they chose to take him to a farther hospital instead of the closer one, because of which there was a delay in him getting the treatment, and because of that he passed away. So you cannot necessarily link the death of the deceased to the door not opening. The death of the deceased can also be linked to the delay caused by traveling to a farther hospital.
Okay, Your Lordship, selecting a private hospital over a nearby government hospital may have added some marginal delay, but the material delay we see over here was door was unlocked. And if the door had unlocked at the first place, my client would not have suffered the death or this severe injuries. He would have gotten outside, he would have gotten medical aid, and he would have survived. So that's what, that does not amount to material delay over here, choosing of the hospital. Moving forward to the second issue, whether the appellant's conduct amounts to culpable homicide with knowledge of under section 304 part 2 of IPC rather than mere causing death by negligence.
Counsel, your duty of care wala issue is done.
Yes.
I have one more question over there. When you talk about negligence, I'm assuming that you're talking about negligence when you talk about legal duty of care, right? So one very important essential ingredient of proving negligence is that there should be a foreseeable risk, right? In the instant case, was there any way in which RF could have known that a party was being held in his place?
They are, this holding party, alcohol consumption, they are mere contributory factors, Your Lordship.
No, but still, did RF know that a party was being held at his place, number one?
No.
No. Did he know that there were more than 4 people in the house?
No, Your Lordship.
Did he know that Ritesh was suffering from asthma?
No, Your Lordship.
Did he know about the hospitalization history of Ritesh?
No, Your Lordship.
If he did not know any of these things, how do you expect him to foresee the risk?
But on his behalf, he have to ensure that in case of any emergency, not being the suffering of my client, but in case of any emergency, the person, the occupants inside the house need to get out of the house, even if it was not a vulnerability of suffering any disease, but if it was the case of a fire had broken out, but there was no exit options to the occupants inside, how could they get out? And
did he have a legal obligation to provide an alternative?
yes, Your Lordship.
Where is it given? Where is it given that he had a legal obligation to provide an alternative exit route?
As per the state advisory guidelines on emergency preparedness for short-term rental 2024, it's given in the facts, though non-binding expressly recommend manual emergency exit and 24-hour host availability.
Both of these are just recommendations which are not mandatory.
But
so if something is being recommended to you under law and if you don't follow it, you cannot be legally held by it. Morally wrong, ethically wrong, legally it's not wrong.
But if we see as per the Article 21 of the Constitution, it says the right to safety is also one of the rights of the.
So you are using Article 21 against Arav?
Yes.
Can you use Article 21 against individuals? Can fundamental rights be enforced against individuals? In that case, you're not allowed to sleep in the class in your drafting lectures. And you should also, invoke Article 21 against him.
But your lordship, here there was the duty. Also, we see in the class here itself. There is a duty of the owner of this class that to provide a proper exit options in case of any of the damage or any of the mishappening happens here. He would be liable for the.
Okay.
Can we move to second
So
issue?
there is no mistake on the part of the people present in the apartment.
Being
Despite the fact that it says not more than 4 people allowed, no partying allowed, they are, must 7 people are there in the apartment, partying, chilling. This person who has asthma, despite knowing that he has asthma, he's drinking. That is all fine. But just this person, this Arav guy, he did not pick up a few calls, and that too in the midnight hours. That makes him,
First of all, your lordship, over occupancy or drinking alcohol does not, even if there were 4 people as per the rules and they were not partying, and in case of any other emergency, there was no any other exit option. No?
So don't you think overcrowding and alcohol consumptions were triggering factors to his asthma
No,
attack?
they does not provide novus actus intervenes. No, they does not start novus actus intervenes, that mere any act that break the chain of causation that lead to death.
No. Right now we are discussing, what I am trying to say is, don't you think the fact that there was overcrowding in that place? See, if Arav has made a rule that only 4 people should be there in the apartment at any given point of time, there is a possibility that it was a small apartment and more than 4 people would have led to overcrowding. And when any place is overcrowded, people with asthma, they tend to get asthmatic attacks, right? So 1, this place was overcrowded. 2, this person who had a history of hospitalization knew, and the few people also knew about this in the gathering. And number 3, they were consuming alcohol. Don't you think these were the contributing factors with respect to his asthma attack? Because in point 11 it's given, an argument broke out between Nikhil and Ritesh over alcohol consumption and noise. So the argument that triggered the asthma attack was over alcohol and noise. And these were explicitly prohibited by Arav. So how do you hold Arav guilty for this?
We held guilty Arav for the emergency exit that he didn't provide. Even in this case, if he had provided the emergency exits to the occupants, to my client, he would have gotten outside, he would have got the medical help.
Even after getting outside on time, you did not take him to the closest hospital.
Your lordship, that does not, there is marginal delay and material delay over
So
here.
everything that Arav didn't do right is material, and everything that these people did are marginal.
Your lordship, the time between the difference was almost of an hour from getting outside. It was around 12:05 they got into an argument.
12:10 they got into an argument.
Yes.
12:50 he collapsed.
Yes.
40 minutes.
Yes.
And they took him to the hospital at 1:30. Again 40 minutes.
Yes. But your lordship, he was already collapsed at the time. My issue over here and my concern is that the Arav should have provided the early exit options to my client, so then he could get out.
Is there a legal duty on Arav for this, is my question. Is there a legal duty on him to provide an alternative exit route?
In this case of this Sushil Ansal, the court has held that there was legal duty to provide safe exits to the Sushil Ansal. Bas. Thank you. Your Lordship, page number 77 of that. It's around, it's almost fourth page. Fourth page of the case. In quasi-accusance for the death of 59 persons was their inability to quickly exit from the balcony area for the reasons we have already indicated. That being so, even the repairs carried out by Berbrising. Here, Your Lordship, direct cause and proximity cause is being given that led to death, that they did not get out within the within the time they have got to get out of that. Can we move to second issue, please? Thank you, Your Lordship and Your Ladyship. Whether the appellant's conduct amounts of culpable homicide with knowledge under section 304, part 2 of IPC, rather than mere causing death by negligence under section 304A of IPC. So, as per section 304A of the Indian Penal Code 1860, applies where death is caused by a rash or negligent act without the intention or knowledge as required by section 299 and 300 of the IPC. Also, as per section 304 part 2 of the Indian Penal Code states that where the act of causing death or likely injury that can result into death has happened with the knowledge and thought though without the intention to cause the death of such bodily injured and is likely to cause the death. Now, as per the facts of the case, the appellant deliberately installed and continued using an auto lock on the only exit, knew from the manual and prior negative review that remote unlocking could be delayed or failed, denied guest any physical key and also any manual override by the appellant R. Mehta, made himself unreachable precisely when the door was set to auto lock. Hence, from the circumstances given above, it can be referred that R. Mehta was unaware that in case of any emergency, occupant might be trapped and unable to escape or obtain timely help with a real likelihood of death. And
Counsel,
hence,
in the present case, you said when the accused engages in conduct so inherently dangerous that death is a likely consequence. How can you prove this particular point in our case?
will you please pardon Your Lordship, Ladyship? Sir.
The case you just referred to, Alistair Pereira case?
Yes.
The first line.
Okay.
Inherently dangerous act or conduct.
Okay, Your Lordship, this case was where Alex Anthony Pereira was driving a car and he was under the influence of alcohol and he rashed over the footpaths and caused death of the laborers that were sleeping there. Okay, so he had the knowledge that drinking alcohol and driving the car would be unsafe over here.
How was RF's conduct inherently dangerous?
Because there were negative reviews about this auto lock system.
But a negative review and a rash driving after consumption of alcohol, they're not the same thing.
Your Lordship, here in this case of R. Mehta, there were two things that the smart, as per the manual override, the smart, there was a guideline that it could fail, first of all. And second was that there was a negative feedback. That means someone who had stayed there had already stated that there might have some issues regarding that smart unlocking system. To refer in this case, the Anthony Pereira knew that he was under the influence of alcohol, and he could rashly cause the death by just drink and driving, and had already caused the death, sorry, and already caused the death, and was negligent for this.
So again, I need to just clarify on two things.
Yes.
Number one, you are admitting that there was some negative review,
Yes.
right?
Yes.
Number two, you have been given clear instructions that what is the capacity and what is to be expressly prohibited. This is what it is mentioned in point number 6 of the facts,
Okay.
right?
Yes.
So if you know that there is some negative review about the lock system, so don't you think so it is your duty as well to ask for physical key when you know that there is something wrong? There may be some difficulty for us. So even there is some kind of negligence on your part as well, because you have not asked for any kind of physical key even after you know that there is negative review over there.
Your Lordship, fifth facts of the case, it states that Arav did not provide.
Exactly, that is what I am trying to say. If Arab did not provide for physical key, it is not your responsibility to ask for it, that there is some negative review, boss, for my safety, please provide me that. Have you asked?
Lordship, the facts are silent on this, that whether it is asked or not.
Then how can you directly blame on Arab that he is responsible?
This is primary duty, Your Lordship.
No, it is not primary duty, because if I am not wrong, again the point which you are referring, that is point number 5, they have clearly stated, point number 4 and 5, they have clearly stated, boss, कि network, low network availability के कारण आपका चीजें रुक सकती है, right? So you know everything, still you haven't asked for it.
This was with the Arav's email regarding failures.
Exactly. So instructions has been given to you.
No, Your Lordship.
Sir, this is what.
Okay,
Come to point number 4. Point number 4, it is mentioned that the instruction manual, okay, retrieved from Arab email, warned that, right? So everything is mentioned over here.
Yes, Your Lordship.
So low network zone is also mentioned. Okay,
Yes.
point number 5 says that again, for maximum security and accountability, physical keys are not handed over. It is also mentioned, right? So it is not the responsibility of the one who is residing there for day or two to ask for a key, that just in case of emergency, what is the option available with us?
Your Lordship, actually the facts does not state that, and on replying on my contingent, this should be, first of all, the primary duty of the owner is to provide the safe exits.
So don't you think so it is also the primary duty of Nikhil not to invite more than 4 persons? It is also the primary duty of Nikhil not to consume any kind of activities which is specifically prohibited by owner.
These are the concurrent factors.
How can it be a concurrent factor?
That does not amount to causation chain and supply chain
Then
that lead to.
how can, if you are not asking to the owner that what are the safeguards that you can provide, how can you blame him?
Your Lordship, the 6 unanswered calls, messages were left to him that please open the door. There is an emergency condition over here.
Sir, point number 1. When did we had a call? Call कब करना पड़ा हमें? When all the 6 to 7 people were in the room?
Yes.
Were all 6 to 7 people in the room allowed to be there?
No.
Then?
But in case Your Lordship.
Were they allowed to consume alcohol?
No, Your Lordship.
Then?
But if in case there were only 4 occupants as per the rules and there were no party held, okay, and if we assume that there
No,
happened.
why there is a point of assumption? If everything is mentioned in the fact of the case, clear instructions have been given what is to be done and what not is to be done, how it can be assumed? It is a clear instruction that maximum 4 people should be there.
Yes, Your Lordship.
It is a clear instruction that there is a possibility that due to battery restraint, the lock system may not work.
Yes, Your
Right?
Lordship.
So there were seven people. Alcohol consumption was also dim.
Yes, Your Lordship.
How can we assume on the facts otherwise when you know clear cut what is happening over there?
My point of saying over here is, even if they would not over occupied at that place.
If, but current situation says कि there was consumption, there were 7 people.
I beg to differ on this, Your Lordship. Can we move? Also, and hence, referring to the case law of Alistair Anthony Pereira was a state of Maharashtra. This the council pleads that appellant's conduct be treated as culpable homicide with the knowledge under section 304 part 2. So would like to take permission to move to third issue. Thank you, Lordship. How does the chain of causation between the appellant's conduct and Ritesh's death remain intact? The appellant created a directly and dangerous situation by locking guests at midnight without giving them any alarm or any manual emergency exit, and being unreachable at the time when they needed him, which prevented Ritesh from stepping outside for air and increased his panic and delayed his evacuation and treatment. Also, as per the doctor's opinion, that earlier intervention would have significantly improved the survival chances of my client, but due to delay, he suffered his death, and hence making the appellant's conduct a direct and a proximate cause. Also,
Counsel, that's what I'm saying. When we say that some cause has to be a direct and a proximate cause to the death, there should be nothing that can cast a shadow of doubt of whether this was the direct cause or something else was the direct cause. In the instant case, there is still a question whether delay because of opening of the door was a direct cause, or whether the delay of not going to the government hospital and going to a farther private hospital was the cause.
Your Lordship, opening
Is there a slight chance that had they gone to the government hospital, Ritesh could have been saved? Even if is there a slightest of chance?
There's a marginal delay, Your Lordship.
Is there a slight chance that had
Maybe.
they gone to, there is a slight chance?
Maybe.
Then the proximate cause, the last cause because of which death happened, is their choice of going to the father hospital.
I beg to differ on this, Your Lordship, but since my client had already passed in the apartment itself, also passed out in my apartment itself, passed out in the apartment itself, and he was reported dead at 6:30 a.m. in the morning. This marginal delay of taking to private hospital and not taking to...
No, I agree that it was a marginal delay, but is there a slight chance that this marginal delay could have saved him?
Maybe, Your Lordship, I'm not...
No, slight chance, I'm not saying definitely, but is there a slight chance, like a 1%, 2% chance?
Yes, Your Lordship.
If there was a slight chance, then counsel, this marginal delay is actually the last thing which could have saved him. So you cannot directly hold Arav liable for it, because even despite Arav's delay caused because of Arav, delay caused because of this decision and choice is what ultimately led to his death.
Still beg to differ on this, Your Lordship. Also, Ritesh Asthma in alcohol consumption, delay in calling an ambulance, and their choice of hospital are at most a concurrent and a contributory factors. They do not amount to novus actus intervenis, and also the appellant must take the victim as he finds him. Ritesh pre-existing asthma does not break the chain of the causation, Your Lordship, here, or diminishing culpability of merely explains why dangerous confinements proved fatal to him. Referring to the last issue of the case, was the advisory guidelines are relevant to the standard of care and constructive knowledge. The state advisory guidelines on emergency preparedness for short-term rentals 2024, though a non-binding, explicitly recommend manual emergency exits, 24-hour host availability as well. They showed that emergency eagerness and host responsives are recognized policies concerns in short-term rental sector. A reasonable host is expected to foresee such risk and adopt appropriate safeguards. The appellant therefore cannot credibly claim that the need for an emergency exit or availability was unforeseeable. Hence, the conviction should be upheld and the appeal should be dismissed. The appellant clearly breached his duty of care and had both constructive and actual knowledge of life threatening risk, and his conduct remained a direct cause of Ritesh's death. In the light of this factor, the trial court's conviction under section 304 part 2 of IPC is justified. Can counsel move to the prayer? Wherefore, in the lights of facts stated, issue raised, and arguments advanced, the counsel on behalf of the state most humbly submits that dismiss the criminal appeal and affirm the appellant's conviction under section 304 part 2 of IPC and pass any other order as may deem fit in the interest of equity, justice and good conscience.
By dismissing the appeal, can we pass any other order?
Any other order, you can held liable under 304 part A if...
Can we do that in an appeal? We can just dismiss them.
Yes.
Thank you.
Thank you, Lordship.
Thank you so much, Sumer. Yes, so we are back and we are going to continue now. Next participant is Anushka Chaudhary, who's going to appear from the appellant side, that in the case of Arav Mehta versus State of Dakshinayan.
Good afternoon, judges. If it may please this court, may I proceed? If it may please this honorable court, this is Counsel Anushka Chaudhary appearing on behalf of appellant Mr. Arav Mehta in the case of Arav Mehta versus State of Dakshinayan. The counsel for the appellant humbly approaches this honorable court under Section 372, subsection 4 of the Code of Criminal Procedure, which empowers any person convicted on trial held by a sessions judge to appeal to the High Court. If it may please this court, may I proceed the bench with submissions of the case? If it may please this honorable court, may I proceed towards the facts of the case? The appellant Arav Mehta is a software consultant who installed a proprietary smart locking system in his apartment for security. The system was advertised as tamper-proof and appropriate for high traffic rentals. In March 22, the apartment was booked by Nikhil Rao with a strict limit of 4 persons and a prohibition on parties. Contrary to these rules, 7 individuals, including the deceased Ritesh, gathered at the flat and they consumed alcohol. Unknown to the appellant, Ritesh had a long history of bronchial asthma, including a hospitalization 6 months prior following a panic-induced attack. While this life-threatening vulnerability was known to at least 2 other attendees, it was never disclosed to the appellant, preventing him from making necessary emergency accommodations. At midnight, the door locked automatically as per the system's security settings. Around 12:10, Ritesh suffered a panic-induced asthma attack. The appellant was asleep with his phone on silent, a standard personal habit, and did not receive the guest's emergency calls. Despite the emergency, the guests waited 55 minutes until 1:05 a.m. to call for medical help. Furthermore, they bypassed a government trauma center and went on to a private hospital where Ritesh was declared dead at 6:40 a.m. on March 24, 2025 due to acute respiratory failure. Medical records confirm that delayed administration of bronchodilators was a critical factor, with the treating doctor noting that earlier intervention could have significantly improved his survival chances. If the Honorable Court may permit, may I proceed towards the issues of the case? The first issue is whether the appellant possessed required knowledge of a likely fatal outcome to sustain a conviction under Section 304 Part 2 of IPC. Second, whether the chain of causation between the locking of the door and the fatal outcome was broken by the independent intervening actions of the attendees. Third, whether the death was a result of tragic accident under Section 80 of IPC rather than a criminal negligence. If this Honorable Court may permit, may I proceed towards the arguments? Your Lordships and Ladyships, this is a case of tragic medical emergency, not a criminal act. The prosecution seeks to hold my client liable for culpable homicide because he slept while his phone on silent, which is a normal habit. The guests themselves have violated the conditions, failed to call an ambulance for nearly an hour, waited for the person to collapse, his condition to get worsened, and then reach out for the medical help. And now they are holding my client liable under the charges of murder. The appellant had no information regarding Ritesh's asthma. The locked door in ordinary circumstances would not have led to death. Therefore, the essential element of knowledge in this case is missing to hold him liable under Section 304 Part 2 of IPC. Yes, Your Lordship.
Why were the keys not provided to
It
the
was
guests,
a remote locking system which Arav installed to.
which he locked and slept?
It was there to ensure the safety of that flat.
Which he locked and slept. The door,
It was a remote locking system which could have been
which
unlocked.
automatically got locked, and he slept,
Yes, Your Lordship.
which is a good thing to do. You've locked people inside.
It was obviously a breach of duty which he had to take care, but to make him liable under Section 304 Part 2 of IBC is nowhere in question, because the required knowledge that this act of him could have led to death of somebody was nowhere in apprehension.
So you'll need a precedent. Someone should have died, and the next time he'll be careful about it.
But a locked door in normal circumstances will not.
It gets locked from inside, not outside.
Yes, Your Lordship.
A normal door.
Yes, Your Lordship. But the system was installed to ensure the safety.
From outside, when the
From-
people are there inside.
To ensure the safety of the flat. And remote access was to ensure maximum security and accountability on the people.
My question remains the same. If there's a latch inside, the door ideally should have been locked from inside, not outside, right?
Yes, Your Lordship. But it was a
So-
smart locking system.
So
It was not a normal
because
door
it is
lock.
smart, so it automatically gets locked. And even if it gets locked automatically, which is a good thing, at least an alternate key should have been provided to the guests.
The only spare key was with Arav. The access to the app was with Arav.
Which is a negligence.
It was a breach of duty. But to make him liable under 304 of Part 2 of IBC under culpable homicide, not amounting to murder, is.
उसको अटैक आया, वो बाहर ही नहीं जा पाया, मर गया वो। तो
But if the attendees there could have got medical services an hour later, could they have not done the same an hour prior?
So door तोड़ना पड़ता है in that case.
If a person is dying in front of you, would you wait for somebody to come and open the
He
door?
has got asthma.
The people there knew how serious his conditions were.
Right.
Two people there are aware
Right.
of what situations he is.
Right.
They engulfed into a fight. He got an asthma attack, and the people knew there how serious it could get. If Arav was not reachable on phone, should they have not tried earlier attempts to save him?
They did.
An hour later, bypassing a government trauma center, taking him to a private hospital.
All of this happened because they were struggling to open the door at the first place.
If paramedics could have been called an hour later, the call to paramedics could have been made earlier also.
They reached the private hospital at 1:30. All the events happened much before 1:30. So if the door could have been opened at the first place, they could have reached the government hospital or a private hospital in 5-10 minutes.
They made the first call at 1:05 a.m.
To?
To the emergency services.
And to your client,
It was made between 12:18 a.m. to 12:42 a.m.
which is quite quick.
Nearly.
Not nearly, absolutely.
Yeah.
So your client is guilty. दरवाजा खुल जाता तो इंसान बच जाता ना.
But to make him know about the fact that he had nowhere idea that this could have led to death.
So
To
that's
make
what
him
I'm saying. You need a precedent. Someone should have died, so you'll be careful the next time.
Okay, can you just brief out on that side? Why was this lock installed at the first place?
this lock was installed to ensure the safety and security of this flat.
Exactly. So when you secure a flat or when you secure an apartment, the security is about the people inside or the people outside?
About the people inside.
Inside. So why would you lock them from outside?
The access to unlock the door was available.
Was this your client's thought that no one should enter the house post 12 because he doesn't want someone to enter the house, and in that verge he mistakenly installed a lock which remotely locks it from outside?
While the flat was given on 22nd March to Nikhil Rao, it was clearly stated that only 4 people were allowed. No party was allowed.
No, let's say that if no party is going on, the point still remains and looms around the similar side. It's not about 4 or 7 people in the premise. It's about if you are having 2 options of unlocking a door, both options restricted to you, and then you go to sleep. What more do you want us to conclude this blunder? Had it been if we really wanted to sleep, this access could have been given in some different ways. The key could have been dropped over there, or he could have thought of some emergency exit for once, because you won't be waiting for someone to die before you could set. Is your client going to do the same thing in the next time as well?
Absolutely not. Your
Not
Worship.
exactly, and that's what we're trying to say. That you don't need a precedent to understand that the client is wrong.
The council accepts that there was a breach of duty by my
See,
client.
understand, what you're trying to say is that you're trying to take it out from 304. Your only idea is that this is a breach of duty, this is a breach of duty, and you're not seeing someone's death, and you're making it as a breach of duty. So what you've learnt over here is that I will not use any other word other than breach of duty, and that's what you're sticking to, that this is breach of duty. What is breach of duty over here for you?
There obviously was a mistake on part of my client, but the actions after that has also worsened the condition of the deceased. It was not only the gate lock.
Okay, how can, what wrong your client would have done for you to say that this is 304? If this was done by him, then I would have said that this is culpable homicide, not amounting to murder.
Supposedly, if there was a fire had broken out,
Right?
nobody could do anything about that at that moment.
So that time you're going to say that the person is culpable homicide, not amounting to murder, if a fire breaks out.
I understand your concern, Your Lordship, but
What am I trying to ask you is that can you please add something more wrong which your client could have done then you could say that this is a case of 304.
Even
Anything worse than this?
there was a guidelines issued by the state on advisory guidelines on emergency preparedness for short-term rentals. But it was a recommendatory, non-mandatory guidelines.
I'm not even touching that question. I'm asking you what more wrong could the client could have done?
Arav had a reason. He had his explanation to why he was not reachable on phone
See, there
that
is
day.
explanation to everything. How much justified it is the question.
The act of my client was never the direct and proximate cause.
What amounts to culpable homicide not amounting to murder?
If you were aware of the circumstances, if you don't had intent to kill somebody, but you knew the circumstances could cause death of somebody.
Exactly. And now your client knows.
He
That's what you just said, that
he
now
was
the next
nowhere
time he's
aware-
not going to.
he was nowhere aware of the condition Ritesh had.
No, not about Ritesh's condition. Emergency word is such a decent word that it can happen anytime, anywhere, without any reason. You don't have to lock the door from outside and set a precedent that now onwards I'm going to keep an emergency key over there. If the safety was about the people, the emergency key could have been inside the house.
It was a short-term rental flat. People every 2-3 days would change there. That was the reason.
No, those people who change it will not take the key.
Yes, sir.
The key would be there, and it would be used if and when emergency occurs, I believe. And I don't think a key, for a matter of fact, has been, wow, such a good key, let's take it.
His intent to install the system was to ensure the safety of the flat only.
What my brother judge is telling you is, in order to ensure safety of the flat, your client did something which is so inherently dangerous that he knew it could have led to death of something. Locking a certain group of people in a house with no exit route. Don't you think that is something which is pretty dangerous and could lead to mishaps and accidents like this? Is there a possibility that when you lock certain people in a room, something like this can happen?
In circumstances.
So there is a possibility, and it's common prudence, it's common knowledge that people would have this knowledge that if we lock certain group of people in a house with no exit options, then something like this can happen, right?
Yes,
Despite that, your client installed this lock and was casual enough to just go to sleep without, and also if you haven't said that, so I'll not say anything on that. And he went to sleep knowing that the door was locked and the people were trapped inside. So he had knowledge that this act of his could lead to somebody's death, right?
He already had consumed alcohol. His phone was on silent.
That's no defense.
But a reasonable person is also not expected to be reachable at phone at 12 a.m.
But the
in morning.
locks get engaged after 12, na? So obviously if before 12 something like this would have happened, the lock wouldn't get engaged. He knew that the lock gets engaged after 12.
The attendees there even were aware of the smart locking facility.
Yeah, and when the owner, your client, says that I have the access, then the guests would reasonably assume that as and when required, they could request and this person would open the door. It's not like a hostel or something like that where you can just lock in and this is the in time you have to stay inside after 12, right? Plus it's there in the guidelines as well that you need to have 24-hour host availability and manual emergency exits.
But these guidelines were recommendatory and not mandatory.
Made for a reason, no? Recommendations are also made for a reason for you to
But
understand.
violations of a recommendatory guideline does not.
We are not holding him legally responsible. That is what we are saying. Right now, is he responsible at least? आपने बोला एक reasonable man can sleep phone off करके, but can a responsible man sleep like that?
But you nowhere expect a person to be reachable at phone at 12 a.m. supposedly.
had
Yes, sir. Roshan.
So the final verdict from your argument is that your client locks the door automatically post 12. He cannot be reached post 12 because a logical person doesn't call after 12. And since he sometime is busy drinking, sleeping or doing anything, he will not receive the call. Yet he ensures the safety of the house by locking it from outside. You want to drink, you don't want to attend the call, give them an exit. Which part or any, I may be wanting to know, is this legally correct? Locking someone from outside without giving them an exit, not about the recommendations. I feel my rights are being infringed. It's my liberty to move. How can you stop my privilege to move the way I want to? Because you were ensuring the the door is locked nicely, the safety of your house, and you want us to be well prepared beforehand that if and when anything happens, we will try to reach just in case the owner is drinking. Sorry for this time, maybe in next life. What do you want? Okay, I think we've done enough of dragging on this point. You can proceed further. We're not convinced as of now.
If you could please refer to the case law. Keshav Mahindra versus State of MP. Page 22. A look at section 304 part 2 shows that concerned accused can be charged under provision of offense of culpable homicide not amounting to murder, and when so charged, if it is alleged that the act to the concerned accused is done with the knowledge that is likely to cause death but without any intention to cause death, or such injury as is likely to cause death, the charge of offense would fall under section 304 part 2. However, before any charge can be framed, the material must at least prima facie show that the accused is guilty of culpable homicide and the act committed by him must amount to culpable homicide. However, if material relied upon for framing such a charge against the concerned accused falls short even of prima facie indicating the accused appeared to be guilty of an offense of culpable homicide, section 304 part 1 or part 2 would get out of the picture. This judgment belongs to the case of Bhopal gas tragedy. In such fatal cases also, the court did not charge the people under section 304 part 2. It was under 304 part A because it was a case of gross negligence. They were dealing in harmful chemicals and all, but they were dealing in harmful gases, but what they did was in the course of business, and they nowhere knew that such an fatal accident would occur which would take life of thousands of people and leave thousands of people crippled for their lives forever. This belongs to the Bhopal gas tragedy. It was a negligent act. There is a mistake on side of my client, but his mistake only is not the cause of the death of the person. Sort of. Contributory negligence obviously is not a concept recognized under criminal law, but section 304A of IPC recognizes that to charge the act causing death must be the causa causans. It is not enough that it has been the causa sine qua non. It should be the direct and proximate cause leading to the death of the person and not one of the causes which has led to death. But the asthma attack was not induced due to him being locked inside the flat. It was due to the fight they engulfed in.
Counsel, you know, people come back from asthma attacks. ऐसा नहीं है कि once somebody gets an asthma attack, they die. So, okay, the asthma attack was induced because of alcohol and loud noise and all of that. But this asthma attack led to his death because of the delay. So, why asthma attack happened does not matter. People come back from asthma attacks, right? So, the cause of death was not asthma attack. It was delay after the asthma attack.
But delay has been on the part of the attendees also who were present there.
That is marginal delay.
1.5 hours of delay to take him to hospital. You are
Why
bypassing
could
a
they-
government trauma center
No.
before you take him to the private
Counsel.
hospital. If you knew he collapsed at 12:50,
Yeah.
you are taking him to hospital, you will take him to the first hospital that is there. Will
Correct.
you see that this is a government hospital, this is a private hospital, not take him there?
But
He's dying there.
the delay was not for an hour and a half because of this hospital fiasco. They could not open the door till 1:05.
If you knew, they were aware the door could not be locked other than Arav. You tried reaching him out on call. He was not
Yes.
reachable.
Hmm.
Reasonably, if somebody is dying in front of me, I know I can't open the door. The person who can open the door, who is not reachable, will I not try to call emergency services prior so that I could save the person dying? Because I know the condition that he is in. The people there were aware of his long medical standing history, the 6 months history. He was admitted twice.
Yeah, so it's not as if from 12:10 to 1:05 they were sitting idle. They tried calling him from 12:18 to 12:42, sent him text messages. In fact, a person also tried to break the door. What else you this is just one thing that they did not do. You cannot shift the liability of Arav on these people just because they didn't call the
The
emergency
council
services.
is not shifting the liability, Your Lordship. But his liability is not the only cause which has led to his death.
But there is some liability on his part, right?
Yes, Your Lordship. Accept. If you could please refer Sushil Ansal versus State through CBI.
Ma'am, one more question. Let's say for an example, the gates were open. They called ambulance. Ambulance reached in 20-25 minutes or maybe 30 minutes. And they reached hospital. And there should have been a doctor over there. But the doctor wasn't there. He was busy, he was drunk, he was sleeping. And he couldn't be reached. So who is going to be liable for you?
That will be medical negligence.
No. Who is going to be liable? The ambulance or the doctor?
The doctor will.
Thanks.
Yes.
Let's assume the ambulance as the friends over here and the doctor as the person who slept. And you said that the doctor is going to be liable if he was not there when he was required and not the person who delayed in reaching there. And that's what Weber sir was trying to
But
make you
medical negligence can't be.
my point is that I was trying to make you correlation with the facts. What he was trying to tell you that they weren't sitting idle. They tried. And you can't shift the blame over here because the entire problem started and stemmed. Maybe if the gates were open and if fresh air could have been, introduced to him, this entire problem would have not come at the first place. So no one directly calls the emergency service. Maybe the situation worsened after a while and you don't call an ambulance if, tomorrow my friend probably says that he's feeling a bit breathless. I would directly call ambulance. This is a bit of a surprise to me. I would not. I would try to take him or her out. That's what a normal, reasonable and responsible person does, which of course few like your clients don't understand by locking the gate from outside and sleep without providing emergency key because that might be stolen.
If you could please refer Sushil Ansal versus State to CBI.
Yes.
Page 38. Doctrine of causa causans. That the act of the accused must be the proximate, immediate, and efficient cause of death of the victim without intervention of any other person's negligence. Next page, page 39. The expressions proximate cause, that which in a natural and continuous sequence, unbroken by any efficient intervening cause, produces injury and without which the result would not have occurred.
So you're sure that because of the delay of the ambulance only?
It was the first instance, even the asthma attack was due to the fight which they engulfed in. It was not due to because he was locked inside the door or he was...
Could be, na? Could be.
It is very clearly stated in the facts. If you could please refer point 9 to the fact sheet. Sorry,
You refer to the fact. Fact number 11.
Point 11.
Yes.
Sorry,
Witnesses
Your Lordship.
stated that Ritesh appeared anxious, breathless, and repeatedly asked to step outside for air, which he could not, because of which he had an asthma attack.
An argument broke out between Nikhil and Ritesh over alcohol consumption and noise.
But alcohol consumption noise has nothing to do with asthma attacks. Does it, ma'am?
His medical history states that to him asthma attack was induced due to panic. It was a panic-induced asthma attack.
And why was he panicked?
Because of the fight that they have engulfed in.
And no, the panic was because he could not step out for air. So the first cause of his asthma attack was him being locked inside the gates.
The first cause stays with the argument, obviously.
And what was the argument about?
They were drinking alcohol.
And he
they were
wanted to
creating
step
noise.
outside for air, which he could not. That was the main crux of the argument. So had the lock not been, had the lock not been there, he would have been able to...
Had the lock not been there, would he not have a asthma attack?
No, he would have stepped outside for air.
The asthma attack was induced because of the fight they had engulfed in.
Yeah, she knows better.
But the... But the first cause that led to his asthma, the first direct cause was the argument that they had engulfed in. Subsequently, him not being able to step out.
See, counsel, asthma does not just randomly come like this. कि अरे अचानक से बैठे बैठे asthma attack आ गया. You start with breathlessness and then it gradually increases to an asthma attack, right? When this argument broke out, he was already at the breathlessness stage where he was asking to be able to step outside for air, which he could not. You need to understand, had he stepped out for air at that point of time, he would have gotten fresh air and the attack would have never happened in the first place. So firstly, the attack happened because he could not step out. Secondly, even after the attack happened, he could not get immediate help, medical help, because of the locked door. They tried opening the door, they tried calling the owner, they tried breaking the door using a chair, everything they tried, could not happen. Then they ultimately called the emergency services, he collapsed and then they took him to the hospital. From 12:10 to 12:50, they tried doing everything, they could not do anything, and that is when he collapsed. After that, they called the emergency services and they went to the hospital. Now, in all of this, if you see the role of the closed door, I think 95% role is that of the closed door, and probably if we were to agree what you are saying, probably 5% chance that his death happened because of the delay caused by not going to the government hospital and going to the private hospital. So in my opinion, closed door की वजह से asthma attack आया, closed door की वजह से delay हुआ, closed door की वजह से panic आया. So everything relates to the closed door which your client installed, knowingly that the only person who could open him, it was him.
Arav relied on the technology that he installed for the safety. His failure, the technical failure also was not controlled by him.
But he knew about it, right? He knew. Arav's email may they have found a user manual which says remote unlocking may be delayed or fail under low network availability.
Delayed.
Yeah, but there's a possibility.
It nowhere stated that it could lead to such a fatal incident.
No, but if you are, see, if I lock all of you inside this classroom and go, I will have the knowledge that there might happen a mishap which can lead to something like this, right? That is why we don't lock people inside houses from the outside.
But the knowledge of the fact that this situation, this circumstance, it has been a busy residential flat since always. Nothing like this has ever happened. No incidents were ever before. There was an incident.
There were negative feedbacks.
It was a 2 months prior feedback which stated there was a delayed access, to which RF replied, if the guests follow the instructions, it works fine. They breached the conditions. They were only allowed 4 people.
So +3 के कारण लॉक perfectly काम करना बंद कर दिया.
But my client can't control the technical failure of it. Was a software.
It was not a failure of technology. It was a failure of his mental thing. He was sleeping. His availability was the factor. But हो नहीं रहा है. ऐसा थोड़ी हुआ.
It was, the door lock obviously had a part to play, but to put all the liability on Arav himself, that has led to this incident.
So we'll do one thing, na, we'll not give him maximum punishment, we'll give him thoda bahut punishment, because there, yeah, only 2 years. That works with you?
304 part 2 clearly requires knowledge.
And he had the knowledge. When I lock people from the outside in a house, there is a possibility that something like this might happen.
Possibility.
Yes. अरे तो short knowledge थोड़ी चाहिए.
But the knowledge should have been of this this can lead to death of somebody. Nobody makes his, I will not make my house so that as to make a death trap for somebody or a prison. It was not what he has intended any time. The negative review stated delayed access.
ये problems हो रहे हैं.
Yes, Raj. But to make it a criminal liability,
कम punishment दे देंगे ना. We'll not give him life imprisonment. We'll give him 2-3 years of imprisonment.
he's not liable under 304 part 2.
You just said he had knowledge.
Negligence.
Okay, come to negligence.
Issue 2, whether the chain of causation between the locking of the door and the fatal outcome was broken by the independent intervening act of the attendees. If you could refer page 11 of the memo. Black's Law Dictionary defines negligence as the failure to exercise the standard of care that a reasonably prudent person would have exercised in a similar situation in any conduct that falls below the legal standard established to protect others against unreasonable risk of harm, except for the conduct that is intentionally, wantonly and or willfully disregardful of others' rights. The guidelines to have exit services and all were recommended. There was no breach of a legal duty on part of my client.
right? It is very simple. Firstly, you're not following the guidelines. Okay. Number two, 24 hours host availability. That is also gone. Number three, reasonable duty to take care what is happening in my property. No concern about it. And still you are saying that there is no legal duty on you.
The guidelines were
The
advisory and
people-
recommendatory. They were non-binding still on the homeowners.
Still you are supposed to give the care, na? If you are renting something, you should understand that what are the requirements of clients are basically, and safety is the prima facie the first thing which everyone should have it, right? So as a software engineer, you know that there is some difficulty in unlocking the door, so you haven't taken any care of it. No physical keys have been handed over to you, right?
Yes, Your Lordship.
So it's liable, I feel. Keep aside for 5 minutes ki let us say ki theek hai, it is recommendatory in nature, it is not mandatory in nature, but safety is prima facie the main concern over here. So let us say even if there is one single person inside the room, safety is must, and we have tried to call approximately 6 times.
Negligence. There was negligence on part of my client.
Exactly, this is what they all are trying to point out, right?
But 304A requires gross negligence.
So this is gross negligence,
And
man.
there should not have been any intervening acts also.
So what you are trying to say कि the people should come and sleep, जो करना है उनको करना, मरना है मरने दो अंदर. You are the owner of the property, and being the owner of the property, you are liable, because whatever is happening in the property, as a owner, it is your responsibility.
Yes, Your Lordship.
Right? अच्छा प्रेयर बता दो.
If you could please refer the case law Ambalal D. Bhatt versus the state of Gujarat. Okay. In the light of facts stated, issues raised, arguments advanced and authorities cited, the counsel on behalf of the appellants humbly prays before this honorable court to set aside the judgment of the trial court and acquit the appellant of all the charges and pass any other order as the court may deem fit in the interest of justice, equity and good conscience.
Counsel, one last question.
Yes, sir.
Do you want us to pass orders in the light of equity in criminal cases? How can we pass equity orders in criminal cases? Is ये मर गया तो उसको भी मार दो?
No, Your Lordship.
Then criminal cases में equity नहीं होता.
Sorry, Your Lordship.
Thank you.
The counsel pleads ignorance.
Now you can't plead ignorance. I've told you कि नहीं होता.
Sorry.
चलो, thank you so much. All right, we'll break for lunch now and we'll continue after the lunch break.
अभी 5 मिनट पहले ये बाकी का कुछ रिकॉर्ड नहीं हुआ है कनेक्ट नहीं है कनेक्टेड नहीं है माइक का रिकॉर्ड नहीं होता ना कुछ चालू नहीं था इसलिए ये नहीं थी
बस इसी अगले 20 सेकंड में जो हुआ है
All right, guys. So now we continue with our final round of the 7th yes moot court competition. अभी तक 4 participants आके अपना अपना case present कर चुके हैं, and now we have our next participant Abhinav Tilote, who's gonna argue from the respondent side, that is state of Dakshinayan, in the matter of Arav Mehta versus state of Dakshinayan.
If it may please the Honorable Court, I am Counsel Abhinav Tilote. I am arguing on behalf of the state of Dakshinayan in the matter of Mr. Arav Mehta versus state of Dakshinayan. If the Honorable Court may permit, the Council would like to present submissions to this bench.
Thank you.
If the Honorable Court may permit, the Council would like to address this bench as Your Lordship and Ladyship. Much obliged. If Your Lordship and Ladyship may permit, the Council would like to state the facts of this case. Right issues. So the first issue is whether the appeal is maintainable under this Honorable Court. And the second issue is the conviction should be upheld in section 304 part 2 of the IPC, and neither the accused should be activated nor the judgment should be converted to section 304A of IPC. If Your Lordship and Leadership may permit, the Council would like to move to the arguments of this case. So the triad court has convicted the accused under section 304 or part 2 of IPC and passed the sentence accordingly. So due to which the appellant has filed an appeal under this before this Honorable High Court, which therefore the statutory right of appeal has been invoked properly. However, mere maintainability does not warrant interference. It is settled principle of criminal jurisprudence that an appellate court can interfere in the findings of trial court only when there is a perverse, illegal or unsupported by evidence. In the present case, the conviction is based on clear factual findings documentary evidence, expert testimony, and proper appreciation of law. Hence, while the appeal is maintainable, it is devoid of merit and is liable to be dismissed. If the court categorized this present case under section 304A, it would trivialize the degree of recklessness involved. This is not a case of accidental omission, but a deliberate structural design and coupled with conscious unavailability during a foreseeable emergency. The appellant actions reflect knowledge of the risk and disregard to it. In an era, automated systems regulate physical access. Operators bear heightened responsibility to safeguard human life. Commercial convenience cannot supersede the sanctity of human life protected under criminal law. So if we move to the second issue, the present case mere transcends from negligence and squarely falls within the ambit of section 304 part 2, as the appellant has possessed requisite knowledge that his conduct was likely to cause death. Section 304 part 2 doesn't require intention to cause death. It is sufficient that section 304, under section 304, the accused has knowledge that his conduct can likely cause a death. The knowledge under this section can be inferred from the nature of the act or surrounding circumstances. Here, the appellant had deliberately installed a system that auto engages at every midnight, lacked an internal override mechanism, and can only be unlocked by the remote intervention of the accused. By creating a system capable of physically confining the occupants, hence without emergency safeguards, the appellant has consciously exposed guests to a foreseeable risk of fatal harm. This risk was neither neither remote nor speculative, as the appellant had earlier received a negative review highlighting the delayed access due to the smart lock. Instead of rectifying the deficiency, he chose to dismiss the concern, and thus he was fully aware of the operational associated with the smart lock. Knowledge under criminal law can be inferred where a person persists in hazardous design despite awareness of its consequences. The Honorable Court has consistently held that when the nature of the act itself is dangerous, the knowledge can be attributed to the accused. Appellant conduct was not an isolated but a systematic design choice prioritizing security over safety. So, criminal liability arises when the negligence is of a gross degree, displaying reckless disregard for life and safety. The appellant failed to provide any emergency override mechanism, failed to ensure 24-hour access availability, despite operating a commercial short-term rental, failed to warn guests about the emergency unlock system, automatic locking feature, rendered himself unreachable by consuming alcohol. He also ignored prior operational complaints, and the cumulative effect of these omissions doesn't demonstrate not mere inadvertence but a conscious indifference. So when the accused chose a technology that could trap human beings, he assumed a higher duty of care. The appellant knowingly created a scenario where the occupants could be physically confined without emergency safeguards. So this risk magnifies in case of medical emergency in such situations. Such recklessness satisfied the threshold of culpable knowledge under section 304 part 2 and exceeds the limited scope of section 304A, which applies only to accidental and momentary lapse. The causal between the appellant's conduct and the death remains direct and unbroken. The locked door was not just a background circumstance, but it was an active barrier to the survival. Evidence established that the deceased repeatedly sought to step outside for air during an asthma attack. The smart lock prevented timely exit. Multiple calls and messages were made to the plaintiff seeking immediate unlocking. No response was received. Medical records confirmed that the acute respiratory failure and note that earlier intervention could have increased the chances of survival. The delay in medical access was directly attributed to the delay in unlocking the door. Intervening factors such as the alcohol consumption, delayed ambulance calls, or pre-existing asthma do not sever the chain of causation. Criminal liability, the intervening acts do not absolve the liability if the original act sets a chain of events in motion.
Do you have a case law which says this, that intervening acts will not affect if the original act sets things in motion?
1 minute, sir. In the case of Keshav Lal versus State of MP, it was stated. This case is not attached to the memo as it was difficult to find. The disease vulnerability does not absolve the appellant, rather it underscores the fatal consequence of the hazardous confinement created by him. So these were the arguments. Questions?
So counsel, you have argued that knowingly Arav Mehta, the accused, put these people in a situation wherein this fatal harm could have caused. Now tell me something, if I lock a certain group of people in a home, in a house, where I have explicitly asked them not to party and not to overcrowd, which is, in this case, they had been explicitly asked not to indulge in any kind of party and not to have more than 4 people. So overcrowding was not asked, was completely banned by me, and partying was also not banned by, was also not allowed by me, right? In such a situation, how do you expect me to reasonably foresee that something of this sort will happen in the light of the fact that I didn't even know that there is a person who's asthmatic in this particular room?
See, first, the breach of this contractual obligations gives rise to civil liabilities.
No, I'm not talking a breach of contract. I am saying, as in the place of Arav Mehta, what do I know? I know that I have let out my house, in which there will be no party, there will be not more than 4 people, and you know, the question that I would know that somebody who's asthmatic is present in that room is also something that was not made clear to me. So how do you expect me to have a foreseeable, reasonable belief that my act would have caused certain harm to somebody?
See, these are minor deviations, and in such short-term rentals, often there are parties gatherings, so these are very minor deviations, and while creating a system, he should be conscious enough to make to give such safeguards for emergency exits.
Is it a legal obligation on Arav Mehta to give such safeguards?
No, there were advisory guidelines.
But no legal obligation, right?
No, but it established a standard of care. Though they were not binding, but it established a standard of care which a prudent person would take.
All right, okay. And when you say that the original act by itself led to the death of Ritesh, whoever he was, there is also a fact that this guy was taken to a hospital which was farther instead of being taken to a hospital which was closer to the house. Possibly this delay could have led to his death, because as per the medical reports, earlier intervention would have saved him. So how do you attribute this delay in intervention only to the lock system and not to?
See, the actual delay started when confinement arose, when the confinement arose. So, and in situation of panic or a medical dispensary, is people often take bad decisions, as they do not have the ability to consciously think properly, and then the dominant cause here still lies the locked door, and not the delay caused by, not the selection of hospitals, because
But that would have contributed to the delay which led to his death,
it
right?
may have aggravated the situation, but the dominant cause still remains the delayed lock.
Do you have an authority which says that the dominant cause will be held responsible and not any ancillary
no, sir.
aggravating cause?
No.
So this is your interpretation that if there is a dominant cause and then there is a smaller aggravating cause, the dominant cause will be the one that will be held liable for the whole act.
No, actually, if the intervening act, for an intervening act to absolve the liability, the intervening should be independent and overwhelming enough. So,
Do you have a case law which says this?
No, sir. I have only law.
So this is your interpretation.
No, sir.
Which case law is this then?
Actually, I have only researched about what are independent acts. Sorry? What are intervening acts? I only researched about that.
No, this statement that you just said, that intervening acts will absolve you from your liability if they're overwhelming enough, right? Where is it given? Is it your interpretation, or is it given or stated in some authority or some case law?
No, sir.
It's your interpretation.
It's what I have researched.
Again, you have read it where? In a case law, or after reading some articles, this is the conclusion that you have drawn from your interpretation?
After reading some articles.
So it's your interpretation?
Yes, sir.
Okay. And what does this Keshav Mahindra versus State of MP say? You just quoted it a couple of minutes back.
It says chain remains intact if the original act actively contributes to the death. Means for the dominating act should be substantial and operational at the time of the incident.
Why do you not have a copy of this? Why do you not have a copy of this?
Actually, the Indian government didn't provide the exact paragraph which I needed there. Sorry? The paragraph in which it was stated was not available was not mentioned in the copy which was downloaded.
Then where have you read this paragraph?
The research.
All right.
It on case mine, it just gives the article, but if we have to find a case law, then we have to find it from Indian Qanun. So case mine only gives the research.
So some summary, somebody made a summary of this, you read that, there it was given.
Yes.
So these exact lines are not given in the case.
No.
But something on these lines will be there in the case.
These are concepts only, yes, sir.
All right. Okay.
Sir, one thing you are speaking really well. There is no need to panic, right?
Sorry.
The very first thing which I want to ask you is about, come to page number 6. Issue raised. The very first issue you are talking about whether the appeal is maintainable before this honorable court. So can you please let me know, as far as High Court is concerned, so they have the jurisdiction to
yes, under section 374 of CRPC,
right.
1973.
Sir, then where the issue comes from? Because if you are saying that they have the authority, then what is the point of raising the question or raising the issue?
No, actually this issue was raised because this appeal is not maintainable because it divides of the merits which are necessary for entertaining the appeal.
Sir, as far as merits is concerned, right, it's up to the judge who is deciding the case. It's not the issue, I guess.
Okay.
Because when you go to High Court, they are having the authority to entertain the appellate jurisdiction, right? This is what we have understood. How it is issue, I am not getting it.
Because I think the first issue should, in an appeal, should be that whether his appeal is liable to be dismissed or should be entertained.
Exactly, but what you have mentioned is whether the appeal is maintainable.
It is maintainable in the court.
Yes, exactly.
See, it is maintainable in the court, but it is devoid of the merits, so it should be liable to be dismissed.
That saying has to be in prayer and not an issue. This is what I feel.
Okay.
Right? So whether the appeal is to be accepted or it is to be dismissed, that will be mentioned in prayer and not in issues. Right? This is what I feel. Honorable court has jurisdiction or no. Right? This is the first issue which they are raising. So when it comes to High Court, there is a clear-cut jurisdiction which they are having. So as far as whether to maintain the appeal or to dismiss the application, that has to be in prayer and not in issue. So as far as page number 6 is concerned, all these things are mentioned in issues. Right?
Yes,
so
sir.
this has to be corrected, I guess. See? Page number 6.
Now I only ask the questions.
No further questions. You can move on to your prayer.
Prayer. In the light of the facts stated, issue raised, and arguments advanced, and authorities cited, it is most respectfully prayed before the Honorable Court to dismiss the appeal and upheld the conviction and sentence under section 304 part 2 and pass any such order that may be deemed it in the ends of justice, equity, and good conscience.
Can we pass orders based on equity in criminal cases?
Not only in the ends of justice.
Good conscience?
Good conscience if the court feels.
Okay, thank you. Our next participant is Akanksha Shedge. She'll be appearing from the appellant, that is Arav Mehta's side, in the case of Arav Mehta versus State of Dakshinayan.
If it may please the Honorable Court, I am Counsel Akanksha Shedge, appearing on behalf of appellant in the matter of State of Dakshinayan versus Arav Mehta. If it pleases the bench, I seek permission to address this Honorable Court as my Lordship and my Ladyship. If your Lordship, Ladyship may permit, I would like to submit my memo. If your Lordship, Ladyship may permit, I would like to briefly state the facts of the case. Okay. Issue number 1, whether Arav Mehta is guilty under section 304 part 2 IPC, that is whether he had the knowledge that his act was likely to cause death. Issue 2, whether the act of installing and operating a smart lock system without a manual override amounts to gross negligence, attracting section 304A IPC. Issue 3, whether Arav Mehta's act was the direct and proximate cause of death or whether the chain of causation was broken. Issue 4, whether the unauthorized gathering, alcohol consumption and delay in seeking medical help by the guest amount to intervening negligence, reducing Arav's liability. Issue 5, whether the deceased's own conduct, asthma history, contributed to his death and amounts of contributory negligence, weakening criminal liability. Issue 6, whether the 2024 advisory guidelines create a binding legal duty and whether non-compliance can be treated as criminal negligence. If your lordship, ladyship may permit, I would like to start with the arguments of the case. Issue 1, whether Arav Mehta is guilty under section 304 part 2 IPC or for culpable homicide not amounting to murder. It is respectfully submitted that Arav Mehta's conviction under section 304 part 2 IPC is not sustainable in law or on facts because the essential ingredient of knowledge that the act was likely to cause death is completely absent. Arav had installed a smart lock system in his apartment only as a security measure and it automatically locked at midnight. However, installing such a lock cannot amount to culpable homicide because it is not inherently dangerous and was never intended to trap or restrain occupants. Even though the lock did not give any audible warning before locking and did not have a manual override, this at most shows a design flaw or inconvenience, not a situation where death was likely consequence. The prosecution reliance on a prior...
Counsel, how come is it not inherently dangerous if the lock auto locks at 12 o'clock and there's no other way that it could be disengaged except only through Arav's phone, and for that he was not available? What if a fire had broken out or some other such accident had occurred? There was no other way they could have come out.
Ma'am, your ladyship, Arav's phone was the sole thing that was able to open that door, right? At that moment, he was not available because he was sleeping at that time. He consumed alcohol and he also went to a party. But like at other times, if the fire or anything would have started, of course he would have been there and he would have opened it. You can't assume facts. You can't assume that if a fire broke out.
But how do you know he would have been available if this instead of having an asthma attack, there was a fire? How do you know he would have been available? You are also assuming.
The counsel begs ignorance for that sentence. I would like to add another sentence. I would say here I would say that of course, like if at that point fire would have broken out, he would not have been there. It is, I will accept that fact, but at that moment, it was not just the lock or the door that was the result of his ultimate death. Many independent factors caused his death. I will explain later on as things go on. The prosecution's reliance on a prior negative review is also misplaced, as it is only complained about delayed entry and did not indicate any serious life-threatening danger. Importantly, the incident occurred mainly due to unauthorized conduct of guests, as Nikhil Rao violated the booking conditions by hosting 7 people instead of 4 and allowing alcohol consumption.
Counsel, but this unauthorized usage is nowhere linked to the death of the deceased. What we're talking over here is because of that lock and the fact that the lock was not disengaged on time, Ritesh lost his life, right? What does it have any, how is it related to there being 3 more people in the house than what was authorized? Or
the main focus here was the consumption of alcohol, that the rule that stated that they can't have parties, right? They consumed alcohol, and the fight that broke out between Nikhil Rao and him was due to noise and alcohol consumption, right? So they were having a party. So that was my main point by adding both of the facts, that the victim Ritesh Kulkarni had a pre-existing history of asthma, and at least 2 attendees were aware of his condition. However, this medical condition was never disclosed to the owner or the host. The victim's condition was further aggravated due to the panic, intoxication, and dispute inside the apartment. Further, the guest delayed calling emergency services until 1:05 a.m. even though the victim collapsed at 12:50 a.m. and they also chose to take him to a private hospital despite a closer government trauma center being available. These intervening acts of negligence break the chain of causation. It is true that Arav was at a private gathering that night and that he consumed alcohol, due to which he fell asleep with his phone on silent mode and failed to respond to the calls between 12:18 a.m. to 12:42 a.m. However, such omission may act most amount to carelessness and cannot be treated as a proof of knowledge or reckless disregard required under section 304 part 2 IPC. At most, it may raise a question under section 304A IPC, but only if proximate causation is established. Therefore, Arav cannot be held criminally liable for culpable homicide, and the present case reflects an unfortunate tragedy caused by multiple factors and negligence of several parties rather than a direct act attributed to the appellant.
Consequence of the door being locked in this entire story?
Sorry?
What is the consequence of the door being locked in the entire story? Has it delayed taking him to the hospital, or it did not matter whether the door was open or locked?
I will say that it did at a point mattered that the door was locked, because the first thing he said was he would like to step outside for air, which he couldn't because the door was locked. But at the same time, they didn't call the emergency services on time. The first reaction that any person has is to call for emergency services.
So in case if I'm feeling breathless at any point in time, the first thing I should do is call for an ambulance.
No, of course not. But the time frame, the argument started, like he started feeling like that around 12:10 a.m. The calls were made at 12:18 a.m. to 12:42 a.m. and he collapsed at 12:50 a.m. As you can see, the time frame is of almost 1 hour, right? So after some time, you will realize that he is not feeling well. So the first thing you should do is call the emergency services. They were late to call for the emergency services. They were trying to break the door. They called Arav, but they still didn't call the emergency services. That should be the first priority.
So they started breaking the door at 12:35.
Yes, one attendee attempted to break open the door using a chair, causing minor damage to the lock housing but failing to disengage.
Was it a wool door or it didn't
state in the fact what kind of door it was. It had
what do we presume a door is usually of?
I would presume it is wood door, but here the smart locking system was installed, so many of the time the door is of metal, so
which is even more harder to break. So at 12:35 they started breaking the door.
One attendee attempted to break the door.
Right. So what do you think a man with normal strength without any tools to break the door
of course
would take some time, I'm sure?
Yeah, I think it will take some time to break down if the
the moment they realized that they cannot break the door, after that they called upon the emergency services, which is very logical.
They started breaking the door at 12:35 a.m. Right? And after that, some time at 12:50 a.m. he collapsed. Right. And after that, 12:50 a.m. they called the emergency services at 1:05. After he collapsed, they had time to think about it. Then why did they not call the emergency service at that time? They had the time to call emergency services.
So
He collapsed.
in
after.
those, how do you understand the word collapsed?
No, the door didn't collapse.
No, I'm talking about Ritesh.
Oh, huh. Ritesh collapsed here.
Yeah.
My apologies. 18.18, Ritesh collapsed at approximately 12:50 a.m.
So
He
collapsed
was taken,
means
he collapsed.
he fell down.
Yeah.
He just
might
fell
be
down.
conscious. He might be unconscious at that time. He collapsed. So
ये आपने assume
that
किया.
he collapsed at approximately 12:50
नहीं,
a.m.
ma'am,
That's what.
I understand
yeah,
the time. I'm saying what
I
you understand
assumed
by the
he-
state of being collapsed.
I assume that he was unconscious at that time.
He collapsed means he could not sustain the pressure,
Pressure.
at that point in
So,
time.
if
Collapse
he
does
was
not mean he
breathless-
would feel unconscious or probably would have
so
died.
even if let's assume that he was conscious at that time, okay,
Right.
he knew he had asthma, and that panic triggered that asthma, right? Then what about the pump that they use, the bronchodilator? What about that? Why didn't he know about that if he was conscious? Why didn't he tell? Two attendees there knew about it, that he had asthma. So why did they not take any charge about that? If he was starting to get breathless, he was breathless at that time, the two attendees must have noticed that this is the panic attack, the panic asthma attack he had. Then why didn't they work on
They
it?
were busy breaking the door which your
What?
client had locked.
Breaking a door, they should have called in emergency services. Because
So अब घर में अगर कुछ भी होगा तो मैं सबसे पहले I'll call for the emergency services and not open the door.
If I see someone that has asthma and he is having asthma attack at that point, of course the first thing I would do, because I know that he has asthma, I will call medical services, because I don't know what to do when a person has
Mind
asthma.
well, my fellow judge has something similar. Do you call for an ambulance whenever you sneeze 3 times? Ambulance. You do that very often. I'm sure no one does.
No,
And I think a man of normal sense or a normal prudence would certainly open the door first, which your client had locked.
He had a history before 6 months. He had this same condition, right? And that's why I think that the two attendees should have called in the emergency services, because he had a prior history of that. He had already been through that.
6 months back, it was a panic-induced asthma attack.
Asthma
right?
attack. Same. That's what happened right now. He
Here
panicked,
also,
and
it was a
that's why-
panic attack.
What?
A
No, panic asthma attack.
Panic asthma attack.
Sorry, but that's what.
So, what you're trying to say, just to clarify, you are saying that because of all these actions of the people present in the house, they also contributed to the death of Arav, and that is why, death of Ritesh, and that is why your client is not solely liable for his death.
I will say that he is not liable at all, because he didn't have any knowledge about anything. I will come to the negligence part after I start with issue number 2. I will add case law for the same.
Okay.
If it may please the Honorable Court, I would now rely upon a case law to support my claim. My lord, section 304 part 2 can be applied only when the prosecution proves that the accused had knowledge and his act was likely to cause death. In the present cause, such knowledge is completely absent. The Honorable Supreme Court in Sushil Ansal versus State Upar Cinema case has clearly held that what converts a case from section 304A to section 304 part 2 is the existence of prior knowledge, and such proof must be of a very high order. The court further observed that mere safety lapses or negligence cannot automatically amount to culpable homicide. In fact, even in the Apahar tragedy, where several people lost their lives due to severe safety failures, the Supreme Court ultimately treated the matter as one of the negligence under section 304A and not culpable homicide under section 304 part 2. Similarly, in the present case, Arav Mehta installed a smart lock system only as a security measure and not with any intention of confine or endanger anyone. Even if the lock had no manual override, at most it indicates a possible lapse in the precaution, but it does not establish that the accused had knowledge that was likely.
So if we rely on this judgment, we will absolve the liability under section 304 part 2, but then you agree that we should punish him under section 304A.
No, because if proximate or direct proximate and direct causation is proved, only then we can apply.
So you are saying we should rely on this case law to
cut off the
section 304 part B, and then you will prove separately that why Arav should not also be convicted under 304.
In this case, the negligence was proved because this case involved the gas leak, but here that it was a door. He didn't know, like the door was there for safety, but the gas that was leaked in this theater, they had, like they didn't take enough precaution for that. The gas is, the council would like a moment.
Yeah, please do.
No. The gas that was released in that cinema was hazardous, and the people there knew about the gas. That's why the negligence applied. But here the lock, the door, it was there for safety measures.
Sushil Ansal is Upahar cinema, right?
Yes.
There was no gas, there was a fire. Gas was Bhopal gas.
Bhopal gas, sorry.
Yeah, this is fire.
The council would like ignorance.
I will give you ignorance. Okay. Proceed to the second issue.
Whether the act of installing and operating a smart lock system without a manual override amount to gross negligence, attracting section 304A IPC. My lords, it is most respectfully submitted that the accused Arav Mehta cannot be held liable under section 304A IPC because his act does not amount to rashness or negligence as required under criminal law. It is submitted that section 304A does not punish every form of negligence. The negligence must be of a very high degree, showing recklessness, disregard for human life and safety. Criminal liability cannot be imposed merely because an accident occurred or because an alternative, safer method could have been adopted. In the present case, the smart lock system was installed purely as a security measure, which is commonly used in modern house apartments and short-term rentals. Such a system is not inherently dangerous or unlawful. The accused had no intention to harm anyone, and the installation of the smart lock cannot be treated as the act done with recklessness or conscious disregard for life. My lords, the smart lock system was designed to lock automatically and be unlocked only through the host phone. There was no spare key provided, and the appellant had no reason to foresee the guest would violate the booking terms, consuming alcohol or panic. This system was a standard security measure, and the unfortunate delay caused by many reasons, not by any inherent danger in the lock. Even if it is assumed that the system did not have a manual override, the same as the best reflects a possible lapse in precaution, but it cannot automatically be evaluated to the level of gross criminal negligence. A mere error of judgment, absence of additional safety measures, or failure to foresee an unlikely emergency situation cannot satisfy the strict threshold of criminal negligence.
Counsel, how did this lock not cause a disregard for human life? Just forget that there were 7 people, they were partying, forget anything, okay? There could be 2 guests inside the house, one of them could have suffered a heart attack or anything like that. है ना, कुछ भी urgency आ सकती थी, because of which one needs to unlock the door and go out of the house, right? So how was this not a disregard for human life?
Because it was there, again I'll stick to my point, it was there for safety reasons. He had no intent to restrain people there. It was just for safety precaution.
Yeah, but again, you mentioned it that it was only a negligence, but it was not a very high degree negligence, which shows that there was no recklessness, disregard for human life. but it did cause, I mean, you said it is a common security measure, but again, if you apply common sense, it is a disregard for human life. In any situation.
In this case, there were multiple factors that resulted in his death. The door was
But
just
we are
a
not talking
background
about the
factor.
other. No, so I am not coming to the other parts. I am sticking only to issue 2 where you talk about the lock. You yourself mentioned about the lock, right? So I am myself sticking to the lock here. What was the role of the lock? The common, supposedly जो security measure होने वाला था, कैसे वो एक death का कारण बन गया?
Like I said, it was still a background factor. Even if we disregard everything, it was meant for security purposes only. It didn't. Many of the, like I mentioned, many people install this safety lock.
Sorry?
Many residents have this safety lock.
Because
It
what
is modern
happens is when
technology.
other people secure safety locks, smart locks, they do have the unlocking power in their own phone. Suppose 5 members stay in a house, all 5 members will have that in their phones. So at least एक ना एक person available होता है. यहाँ smart lock भी था और only one person had the access, and who was himself sleeping. So what do you have to say in this regard?
Arav mentioned in the listing that remote access ensures maximum security and accountability. That's why he was the sole
That he
person.
mentioned, but do you agree with the same?
Yes, I agree with the same. I still think that remote access ensures maximum security and accountability.
You are referring to accountability. What is the meaning of accountability?
Accountability means a person
You are
takes
responsible for your actions.
actions, yes.
Right? So what you have done over here, you have installed the lock, right? Which gets locked automatically,
at work.
right?
Yes.
So the person inside the house, are they able to go outside?
No.
No.
Without Arav's permission.
Are they able to go outside as of now?
No.
No, right? So what was the basic reason of death?
The basic reason for that, I would say that it was the not calling medical emergencies on time.
Before calling medical emergency, didn't they call your client?
They did. At
Are you accountable to your
12:15.
actions? You are accountable to your actions.
Yes.
This is
But
what they are trying to say.
But even if he is accountable for that negligence, it is not very high order. He was sleeping at his home. It
There
was
is a-
12 at midnight.
There is a death of some person, right? And you're saying that it is not negligence, gross negligence.
Even
And you're not
if there were
accountable.
multiple factors that caused his death, the
Let us
door
stick to
may be
first
a
factor.
background factor, but I'll beg to differ that it was.
Let us stick to first factor, right? You are quoting about accountability and you are saying that my client is not liable for whatever is happening inside the house.
He would be liable if they
Imagine a
if they
situation.
followed the rule.
I am following the rule. I am
He-
calling you 6 times, right? I am
They-
calling you 6
They
times.
partied at his house when it was not authorized. Alcohol
Imagine a
was bought in the
situation-
house. They drank alcohol.
You are saying कि ठीक है, imagine a situation no one is partying. Imagine a situation there is just one people inside. There is just one person sitting inside the home, and just because of automatic lock of door, what can the other person do?
But this is
Can
just
you suggest
assumption.
some
These,
solutions?
these are just assumption that this could happen. But in this case, what happened
Matlab,
was there
what you
were
are
7
trying to
people.
say,
They
what you are trying to say, कि if Arav is sleeping, he's doing a good job. If he is drinking, he's doing a good job.
No,
But
I
if you
never
are suffering
mentioned
some
that.
kind of attack, you are at fault.
What? Sorry, last point I
Nahi?
didn't get.
If someone is suffering an attack, so that person is at fault. This is what you are trying to point out.
No, that is not what I was trying
So
to
if you
point
can,
out.
if you
What
can
I'm-
basically put out the allegations on other person that they are not calling the emergency services, right? Similar allegation can be put in against you. Ki that's boss, you are not responding to the calls. You have not given any kind of safety measures for us. You have not handed over the physical keys to us, right? You are not responding to the calls. You are not responding to the messages. So how can you say that other persons are liable? Even in issue number 1, every time you are quoting that you are liable, my client is absolutely free from all kind of allegations. As an owner, don't you think so? Owner has few responsibilities which they have to take care of it.
Of course, owner has the
So
responsibility.
if they have the responsibility, there has to be 24-hour as per guidelines.
It was not mandatory guidelines.
So even though if it is not mandatory, you can do anything on the
Of
flat
course
which
not.
is
It
not
was-
owned by you.
It was 12 a.m. I'll say it again. It was 12 a.m. at
So are you
night.
taking money for complete 24 hours or just 12 hours? If it is rental, you are taking money for 24 hours.
Yes.
If the money is being taken for 24 hours, why not 24-hour availability should be there? Someone is suffering inside and you are just bypassing the liability, saying that I am not responsible. Be it 12:30, be it 1:30, be it 4:30, you are getting paid for that. So if you are getting paid, you should make your services available. This is what I feel.
12, yes.
और फिर लॉक की जरूरत ही क्या है 12 से पहले?
क्योंकि
कौन
रात
आएगा?
को मल्टीपल रीजंस, कुछ भी हो सकता है, चोरी हो सकती है, कुछ भी हो सकता है. I will say it was the fight that caused him to panic. It was the fight between Nikhil and him which caused him to panic. It was about alcohol consumption and noise.
And he was continuously saying that he wanted to
Go out for fresh air. No, he was not.
because of which he had an asthma attack.
But he started panicking before. He was panicking when he was breathless.
Yeah, and he was breathless and he wanted to get out from the air because people with asthma, when they tend to have an asthma attack, it starts with
Breathlessness. He was anxious and breathless.
Yes, exactly. At that point of time, had he been able to go out, he would have gotten fresh air. फिर asthma attack आता ही नहीं, ये सब होता ही नहीं. ये सब हुआ because he could not go out.
And because you didn't hand it over the key and you didn't answer the calls as well as messages, right?
Okay, let's assume that the okay, let's say that this caused negligence, but there are multiple factors which caused his death. It was not just Arav's.
Are those other factors relevant?
Yes, they are relevant.
If there negligence on the part of one party and the other party also does something which is also negligent and not right, so do the actions of the other party absolve the first party from its liability under criminal law? So in civil law we have something known as contributory negligence, right? Do we have something like that in criminal law also, that other mitigating factors can absolve me of my liability even though I was negligent? So in this case what you're saying is there were other factors, agreed, but there was also this Arab factor, this door factor. If you can show me that these other factors that you're talking about, they can mitigate or absolve Arab's liability, then the case is yours.
Okay.
But if you cannot, then we'll have to convict.
Okay. My lord, if you will please refer to issue number 3. Whether Arav Mehta's act was the direct and proximate cause of death or whether the chain of causation was broken. Okay. My lord, the accused is not liable under section 304A IPC because this act was not the direct and proximate cause of the death. The Honorable Supreme Court in Qurban Hussain Muhammad Ali Rangwala versus State of Maharashtra clearly held that even in an act may appear negligent, it is not sufficient to attract section 304A unless the death is the direct and proximate result of that act. The court specifically observed that in order that a person may be guilty under section 304A, the rash or negligent act should be the direct and proximate cause of the death. And an act which is only an indirect factor cannot create criminal liability. Applying this principle to the present case. Yeah, I'll state that. Then we will refer to issue number 4 if you want that point. Okay. My lords, the action of the guest hosting an unauthorized gathering, bringing alcohol into the apartment and delaying medical assistance were independent and unforeseeable. These acts broke the chain of causation and are the direct reasons for the unfortunate outcome. It is well established that Section 304A liability, the rash or negligent act of the accused, must be direct and proximate in the of death. In this case, the smart lock was simply a standard security measure. Yes. Yes. The to impose wala part? To impose criminal liability under Section 304A Indian Penal Code, it is necessary that the death should have been the direct result of rash and negligent act of the accused, and that must be the proximate and efficient cause without the intervention of others' negligence. It must be the cause of others' negligence. Can counsel have a moment? Structurize it. Yes.
You are saying that Arav should not be held guilty because other people did this and they did that and they delayed in going to the hospital, went to the father hospital and all of that, because of which they also acted negligently, and therefore Arav should be absolved of its liability. Right?
Yes, that's
Now this case law that you just cited, what does it say? To
That is
hold
a-
somebody liable under Section 304A, there has to be a direct and proximate cause without
another
other party's negligence. Here other party was negligent,
Negligent,
and
but
therefore your client should be
client should be
absolved of its liability.
Yes.
Samjha?
Haan.
Move on to the last issue.
Okay. Whether the 2024 advisory guidelines create a binding legal duty and whether non-compliance can be treated as criminal negligence, it was not mandatory as said in the facts. Rare. If it may please your lordship, ladyship, the council would like to conclude with a humble prayer. In the lights of the facts stated, issues raised, arguments advanced, medical evidence is presented and authorized cited, it is most respectfully prayed before this honorable court that the appeal of appellant Arav Mehta be allowed and the judgment of the trial court convicting him under section 304 part 2 IPC be set aside. It is further prayed that this honorable court may be pleased to acquit the appellant of the charges under section 304A IPC, or in alternative consider any appropriate relief as deemed just and proper in the interest of justice, equity and good consciousness.
Thank you, Akanksha. Next up we have Vidushi Upadhyay, who will be representing the state of Dakshinayan, that is the respondent in the matter of Arav Mehta versus state of Dakshinayan.
अरे हिंदी यार, हिंदी बोलना यार. On. If it may please the Honorable Court, I am Counsel Vidushi Padhyay, arguing on behalf of prosecution in the matter of R.F. Mehta versus State of Dakshinayana. If it may please the Honorable Lordship and Ladyship, Counsel would like to submit the memo of the case. हाँ नहीं आपको थैंक यू. If it may please the Honorable Lordship and Ladyship, Counsel would like to state the fact of the case, then issue and then argument of the case. Okay, thank you. Just help please. वो मैं करूँगी ना. Page number 9, issue. Yes. Okay. Issue 1. Whether R.F. Mehta had the requisite knowledge that his act was likely to cause death, so to attack the liability under Section 304, Part 2 of IPC. The second one, whether the non-binding advisory guideline on emergency preparedness for short-term rentals 2024 can be relied upon to determine the standard of care expected from R.F. Mehta. The third one is whether R.F. Mehta's act of installing and exclusively controlling a smart locking system without providing a physical emergency exit or spare key amount to a negligent or reckless act under criminal law. The fourth one is whether the chain of causation between the RF's conduct and the death of Ritesh Kulkarni was broken by the intervening factors. And the fifth one is whether the conduct of Nikhil Rao and other attendants amount to contributory negligence sufficient to reduce or negate the criminal liability of R.F. Mehta. Shall I continue with arguments? Thank you. Issue number 1. Whether R.F. Mehta had the requisite knowledge that his act was likely to cause the death so as to attract liability under Section 304 and Part 2 of IPC. Section 304 Part 2 IPC applies when the death is caused by the act of the accused. And the second one is the act is done with the knowledge that the act will be the cause to the death. And the third one, but without intention to death of someone. Honorable Lordship and Ladyship, knowledge cannot be proved by the direct evidence, but it can be proved by the surrounding circumstances. Under Section 304 Part 2 of IPC, knowledge does not require any intention. It is sufficient if the accused was aware about the act that is likely to cause the death. And in the present case, RF is ignored emergency safety standard, failure to provide functional exit, and the third, no, the guest was staying in the premises. RF was aware about the guidelines, which is Advisory Guideline 2024, which is given in the facts. But even though guidelines are not mandatory to the RFs, but it can not mandatory, but it can the state recognize the real risk. But RF is being a host engaged in a short-term rental, which is a profit-making business, then he should aware of such conduct or his risk. And in this case, the risk degree of risk is higher, where there is a lack of emergency exit.
no host availability in the premises, or where in case of emergency the guest will not be able to contact with the guest will not able to contact with whom they will, or in case of emergency. In the case of Sushil Ansal versus State, which is given under page number 23. Where it is clearly stated that Supreme Court held where the accused has knowledge of hazardous condition and still failed to act, liability under section 304 part 2 arises.
What hazardous condition are you talking about in this case? See, when you talk about Sushil Ansal, this was a case in which there was a theatre, there was a movie hall with very narrow exits and no fire safety measures. That is what creates a hazardous situation. But in the instant case, it's a normal, paying guest accommodation kind of a thing, or a house which has been given out on rent. In a normal course or in an ordinary course, how do you explain that it is a hazardous situation? Or how do you call it a hazardous situation?
As in the present case, the door was locked at the midnight.
Didn't the deceased or the person who booked that place know about it?
No.
They knew?
No, he didn't know that the door will be locked at the midnight and it will be opened by only the Arabs.
It was there in the reviews and all the places. No, it's not as if it was a hidden fact.
No, they know that the door will be locked, but they didn't know that the door will be locked at the midnight and it will be only open by the.
How do you infer that they didn't know about this?
In the fact sheet. Point number 12, in this clearly stated that attendees later stated they were unaware that the door would auto lock. It is point number 12.
Okay.
They were unaware that the door will be locked at the midnight.
Okay. But they were aware of the fact that not more than 4 people were allowed?
It is like baseless point, 4 people or 7 people. In case of 4 people, emergency can be
emergency can be in case of 1 person also. I agree. Okay? But what emergency are we talking about? An asthma attack. Asthma happens because of breathlessness, and breathlessness happens because of overcrowding. So if the rule stipulated that only 4 people should be there, probably it was because of low ventilation or a small space. They broke this rule and got 7 people inside that small space, because of which there was breathlessness and suffocation.
But in this
beyond that, was partying allowed?
No.
They partied?
Yes.
And what caused this panic-induced asthma?
But because of they conduct party, that is not occurred because of party.
No, it occurred because of party. Go to point number 11. At around 12:10 a.m., an argument broke out between Nikhil and Ritesh over alcohol consumption and noise. So what is it because of which argument broke out?
Okay, I agree. But no, I will continue.
You agree only?
No, I continue. If any, can I continue? अगर आप कोई प्रॉफिट मेकिंग बिजनेस में हो तो आप ये एज्यूम नहीं कर सकते कि वो लोग अगर नेग्लिजेंस करेंगे तो मेरा क्या, मैं ड्यूटी ऑफ केयर करूंगा ही नहीं. इट इज आरव्स ड्यूटी ऑफ केयर कि दैट ही हैव टू गिवन अ स्पेयर की.
यू आर आर्ग्यूइंग 304 पार्ट 2, राइट?
यस.
वहां पे नेग्लिजेंस की बात ही नहीं होती है,
वहां
पे नॉलेज की बात होती है, राइट? तो अगर हम अपने घर पे लॉक लगा रहे हैं और उसके अंदर कुछ लोग हैं, मेरे को कहाँ से दिमाग में आएगा कि उसके अंदर पार्टी चल रही है जिसकी वजह से कोई बंदा है जिसको एज़मा है और उसको एज़मा अटैक आ जाएगा एंड देन उसको हॉस्पिटल नहीं ले जा पाएंगे, उसकी डेथ हो जाएगी? ये कहाँ से आएगा मेरे दिमाग में?
कोई और इमरजेंसी भी तो हो सकती है.
हुई,
बट इन
स्पेक्यूलेशन है, ये स्पेक्यूलेशन है.
ही इज इन प्रॉफिट मेकिंग बिजनेस, ही हैव टू अज्यूम दैट एनी इमरजेंसी कैन बी अकर्ड.
हाँ, ये प्रॉफिट मेकिंग बिजनेस में तो गुनाह थोड़ी कर दिया.
नो, गुनाह नहीं है, बट यू हैव टू टेक केयर ना. यस, स्टैंडर्ड टेक केयर
स्टैंडर्ड ऑफ केयर एंड एवरीथिंग इज नेग्लिजेंस. वो नेग्लिजेंस में अपने आर्ग्यू करेंगे. यहाँ पे मेरे को ये बता दो, लॉक लगाने से ये नॉलेज कहाँ से आ गया कि शायद इससे किसी की मौत हो सकती है?
बट एनी इमरजेंसी कैन बी अकर्ड, ही हैव टू, उसको बता के तो जाना था ना गेस्ट को कि मैं जा रहा हूँ, अगर आपको कुछ इमरजेंसी हो तो यू हैव टू कांटेक्ट विद देम। और
तो ये उसको करना था, उसने नहीं किया, ब्रीच ऑफ ड्यूटी हो गया, नेग्लिजेंस हो गया। तो नेग्लिजेंस वाले सेक्शन में बात करेंगे इसके बारे में। राइट नाउ योर सी दीज आर टू डिफरेंट सेक्शंस,
304A एंड 304 पार्ट 2 ऑफ
तो
IPC।
पार्ट 2 के बारे में जब अपने बात करें तो यू आर सेइंग कि इसको नॉलेज था कि ये जब लॉक लगा रहा था तो उसके वजह से किसी की मौत हो सकती थी। व्हाट आई एम सेइंग इज नहीं, ऐसा कुछ नहीं है। नेग्लिजेंस में भी वो अपने बात कर सकते उसके ऊपर, नॉलेज कहाँ से था यार? आप जो बोल रहे हो ड्यूटी ऑफ केयर बताना चाहिए था, ऑल ऑफ दैट इज नेग्लिजेंस के अंदर।
बट बिकॉज इज नेग्लिजेंस दैट इज अकर्ड ना, अल्टीमेट
तो
दैट इज
नेग्लिजेंस
अकर्ड बिकॉज ऑफ
यू आर एग्रीइंग ना, नॉलेज का कुछ नहीं लेना देना, नेग्लिजेंस ही है जो है।
यू इफ यू प्रॉफिट में बिजनेस आप कर रहे हैं तो आपको कुछ तो नॉलेज होगा ना कि एक कोई सी भी इमरजेंसी हो सकती है।
बिजनेस कर रहे हैं, मेरा ड्यूटी ऑफ केयर था, वो मैंने ब्रीच किया, क्या हो गया?
डेथ।
अरे नेग्लिजेंस,
नेग्लिजेंस।
तो नेग्लिजेंस पे तो हम बोल रहे हैं, हम बात करने के लिए रेडी है। पहले ये तो एक्सेप्ट करो कि 304 पार्ट 2 के अंदर नॉलेज वाला प्रॉब्लम नहीं है, नेग्लिजेंस इज 304A।
प्रॉब्लम वाला पार्ट भी है।
तो क्या है?
आप अगर कोई भी बिजनेस करो,
अरे
तो
यार इसको बिजनेस वालों से बड़ा प्रॉब्लम है।
जैसे विकास सर है, तो ये जैसा अकेडमी का कुछ कर रहे हैं तो उनको थोड़ा तो अज्यूम होगा
अच्छा,
कि
अगर कल
कोई भी
विकास सर ने,
इमरजेंसी हो सकती है।
हाँ, कल अगर विकास सर ने आप लोगों को इस क्लास में बंद कर दिया,
हाँ,
ठीक है, और अचानक से रैंडमली शॉर्ट सर्किट हो गई, ठीक है, तो क्या हम लोग ऐसा बोलेंगे कि विकास सर जब आपको क्लास में बंद कर रहे थे उस समय उनको नॉलेज था कि शॉर्ट सर्किट हो सकती है, तब आप उसको मतलब उनको जेल में डालोगे? या हम ऐसा बोलेंगे कि उनको ये ड्यूटी ऑफ केयर था कि जब बच्चों को क्लास में बंद कर रहे हो तो ध्यान देना चाहिए था, नहीं ध्यान दिया तो इसलिए नेग्लिजेंस हो गया? दोनों में से क्या बोलेंगे अपने? किसी को क्लास में
आइडिया तो होगा ना कि हो सकता है कि अगर ये भी वर्क, आपको इतना तो आइडिया रखना चाहिए। अगर आप किसी को जिस क्लासरूम में बंद किया तो उनको फैक्टर पता होंगे क्लासरूम में क्या क्या चीज हो सकती है।
अरे शॉर्ट सर्किट बता के थोड़ी होता है, वो तो रैंडमली कहीं पे भी हो जाता है।
अब इसका तो लेके चलना चाहिए ना कि अगर हो गया बाय एनी चांस।
तो वैसे केस में तो फिर आप जब ट्रेन में जाते हो तो ट्रेन का भी गेट बंद नहीं होना चाहिए। व्हाट इफ उसमें किसी को एस्मा अटैक आ गया, उसमें आग लग गई, वो तो रीजनेबल अजम्पशन लेके अपने चल सकते हैं।
परमानेंट थोड़ी होता है, आप तो चैन खींच के रोक सकते हो ट्रेन के, तो इमरजेंसी आप कॉल कर सकते हो। हाँ, तो वो रखते हैं ना मेडिकल की, अगर कुछ हुआ तो हमारे पास है।
क्या 200-300 एक्स्ट्रा ले लैंड करा दे?
नहीं तो वहाँ पे सब होता है ना, वो अरेंजमेंट रख के रखते हैं ना कि अगर कोई इमरजेंसी आएगी तो लाइक वी कैन टेक केयर ऑफ हिम। आरब को रखना था कि अगर वो उसने शॉर्ट टर्म रेंट पे दिया, हैव टू टेक केयर कि अगर कोई इफ एनी इमरजेंसी अकर्ड तो अगर वो किस से कांटेक्ट करेंगे तो किससे
कांटेक्ट इसी से करेंगे। बट ये तो स्टेट की तरफ से
नहीं, आपने सुना नहीं था, आप आधा सुने।
नो सी, आप जो भी बोल रहे हो ना, चलो ये बिजनेस में था। जैसे फ्लाइट वाले लोग अगर मान लो मेडिकल किट नहीं रखेंगे, मान लो किसी एक फ्लाइट में मेडिकल किट नहीं है और वहां पे किसी को एस्मा अटैक आ जाता है, ठीक है, तो वैसे केस में हम लोग ये बोलेंगे क्या कि आप नेग्लिजेंट थे, आपके पास ड्यूटी ऑफ केयर था, आपको ये करना चाहिए था, आपने नहीं किया? या ये बोल देंगे तुमको तो पता था कि किसी को एस्मा अटैक आ सकता है?
मतलब पर्टिकुलर उसको
नहीं, आई एम गिविंग यू एन एग्जांपल।
हाँ, पर्टिकुलर एस्मा अटैक का नहीं पता, लेकिन उनको ये तो पता कि कोई इनकेस हार्ट अटैक आता तो वो तो यही बोल रहे थे, मुझे क्या पता हार्ट अटैक आ जाएगा। तो कोई भी इमरजेंसी आ सकती है ना, आप एस्मा अटैक ही क्या XYZ कोई भी इमरजेंसी आ सकती है, तो उसको टेक केयर तो रखना था। उसको इतना नॉलेज तो था कि इमरजेंसी आ सकती है, तो मेरे को देखना चाहिए।
आई स्टिल थिंक आप जो बोल रहे हो एकदम फिट बैठ रहा है नेग्लिजेंस में, वो नॉलेज में नहीं बैठ रहा मेरे हिसाब से।
एक सेकंड, फैक्ट्स में भी दिया है। पॉइंट नंबर 4।
कौन सा?
4th। The product browser advertised the lock as tamper-proof and secure of high-traffic renters. However, the instruction manual retrieved from Arab's email warned that remote unlocking may be delayed on failure under low network and availability of battery constructive. तो मतलब आरब ने बताया नहीं था जब उन्हें शॉर्ट टर्म रेंट पे दिया कि अगर बाई एनी चांस डोर लॉक हुआ, लो बैटरी में डोर अनब्लॉक हो ही नहीं सकता, अनलॉक हो ही नहीं सकता।
अगेन उसकी ड्यूटी थी बताने की,
ड्यूटी थी, नहीं
बताया। हाँ। ये नेग्लिजेंस होता है।
उसको नॉलेज भी था ना कि है ही नहीं, तो इमरजेंसी भी हो सकती है। हाँ, हाँ एक ओके केस लॉ यस थ्री हाँ हाँ 304 पार्ट ए 304 पार्ट 2 5 नेग्लिजेंस कल्पेबल होमिसाइड हाँ विदाउट नॉट इंटेंशन okay by referring case law I would clear this refer page number 23 yes in the case Sushil Ansal versus State of through CBI in I will continue with the fact of the case then I will conclude with the case जिसमें ये बताया था 304 पार्ट पहले सेक्शन का डिफरेंस ओके आपने बोला था ना 304 पार्ट 2 का बता दो पहले सॉरी हाँ ओके और पेज नंबर 17 section 304A IPC is that caused due to rash or negligent act. The three things which are required to be proved for an offence under section 304 part A are death of human being. The second one is the accused caused the death, and the third one is the death was caused by the doing of rash or negligent. ये section 304 part A. Okay. And page number 18. हाँ सेक्शन 304 पार्ट 2 ऑफ आईपीसी a person responsible for a reckless or rash or negligent act that causes death which he had knowledge as a reasonable man that such act was dangerous enough to lead to someone untoward things and that death was likely to be caused may be attributed with the knowledge of the consequences and may be fastened with the culpability of homicide not amounting to murder and punishable under section 304 part 2 of IPC. Shall I further with issue or continue with this case law? Issue number 2, whether the non-binding advisory guideline on emergency preparedness for short-term rentals 2024 can be relied upon to determine the standard of care expected from Arav Mehta. That even though the advisory guideline 2024 are non-binding, but they can be still relied to identify whether the standard care by the surrounding circumstances. Okay. Issue number 4. Okay. Whether the chain of causation between the Arav's conduct and the death of Ritesh Kulkarni was broken by intervening factors. Drink करा party की which is prohibited in the case. You allowed to? क्या? चले continue. हाँ उन्होंने इमरजेंसी कॉल नहीं करा अरे एम्बुलेंस को इंटरवेनिंग फैक्टर से बाईपास हाँ वो तो इंटरवेनिंग फैक्टर्स यू आस्क ना हाँ हाँ बता रही हूँ ना बाईपास द गवर्नमेंट हॉस्पिटल टू ट्रॉमा वहाँ गए, जिसमें टाइमिंग गया। तो ये सब उसमें आरव ने इस पे एलिगेशन लगाए थे कि आपका नेग्लिजेंस है, इस वजह से हुआ। दे आर द इंटरव्यूइंग फैक्टर्स व्हिच आई एम टॉकिंग अबाउट दिस। आरव आरव ने तो ये एलिगेशन लगाया ना। हाँ वही तो मैं कर रही। Shall I continue? हाँ फोर्थ। हाँ Shall I continue? नहीं, the chain of causation remains intact. The intervening act must be independent, unforeseeable, and sufficient to complete the override the original act. As in the present case, the short-term rental, medical emergency is foreseeable. Alcohol consumption at gathering is foreseeable. As in the case, it is clearly stated 23rd March, which is on Sunday. On Sunday, party can be conducted, and it is a foreseeable.
No. I have specifically restricted parties on my property.
हाँ, but assume.
No, why will I foresee that somebody will do party on my property when I have
Okay.
specifically restricted and banned it? That too on a Sunday. Nobody parties on Sunday. People party on a Saturday.
जिसका जैसा मन वो तो। अरे हाँ ओके, बट पार्टी इज फोर्सेबल ना, पार्टी कैन बी कंडक्टेड। ओके, थर्ड वन, पैनिक एंड डिले आर फोर्सेबल। इमरजेंसी इज फोर्सेबल सीन। हाँ हाँ, as in the case Sushil Ansal versus state, even though the fire was not started by the accused, but unsafe exit condition and the contributed to the death, the chain was not broken. And similarly in the case Arab did not cause asthma. हाँ
ये फटाफट करो, हम प्रेयर पे आने तक।
हाँ, तो क्या बोलते हैं, हॉस्पिटल जाने में लेट किया, दोनों ने कंट्रीब्यूट किया है, जो आपका डायरेक्ट लिंकेज है वो खत्म हो गया।
क्या, सॉरी, फिर अगेन कैन प्लीज
खुद की फीस कर रही है क्या?
हाँ हाँ
लीगल एड्स।
बट हाँ, बट निकलने में डिले हुआ ना, मेन डिले किधर हुआ? बट इन पैनिक, हाँ, but in panic situation how can you expect the perfect decision should be made? But
that too after party, आप तो बोल रहे हो कभी भी कर सकते पार्टी। हाँ
बट आरव इज इन बिजनेस है, ये वही उसकी ड्यूटी ऑफ केयर था ना, उसकी ड्यूटी ऑफ केयर था ना कि why would he leave even if the guests are in premises? He have to, उसको बताना तो था कि I have to leave and you can contact with anyone in case of emergency.
हो गया ना यार? अरे अभी बहुत लंबा टाइम लगेगा।
नहीं, एक सेंटेंस में लास्ट,
आप पेज 10 पे तो आओ।
एक सेंटेंस
No, I really want you to come to the prayer on page 10 after this.
Issue number 5, whether the conduct of Nikhil Rao and other attendants amount to contributory negligence sufficient to reduce or negate the criminal liability of Arav Mehta. Huh? Sorry. No, the act of Nikhil Rao and other attendants, even if negligent, is irresponsible. The negligence of attendants can be come under irresponsibility. But it, huh? Minor negligence. हाँ. Attendance negligence and minor negligence. In case of Arav's negligence, it is coming into major negligence. How can you compare with minor and major negligence? Huh.
Overcrowding, minor negligence. Going to a different hospital, farther hospital, minor negligence. Loud noise, minor negligence. But not answering phone calls, major negligence.
But duty of care is of Arav na. How can you expect to from attendance to? आप सुनो दो पूरा. Contributory negligence is not a defense in criminal law. It will be reliant in case of civil law. You can civil case mein you can refer the contributory negligence, but in case of criminal you can't be relied on the contributory negligence. Instead, contributory negligence can be reduce the punishment, but it cannot be relied only to. It cannot override the negligence of Arav, which is a duty. You cannot like आपको उसको अंडर सेक्शन 304A and 300 पार्ट 2 में तो करना ही पड़ेगा, बट पनिशमेंट यू कैन रिड्यूस. हाँ. In the light of the facts and circumstances in the present case, it is more respectfully submitted to the Honorable Court to please that hold the accused Arav Mehta to be has requisite knowledge that such a conduct was likely to cause and shall be held liable under section 304 part 2 or in the alternative under section 304A of the IPC. And the second, hold that the chain of causation did not break the by the third party or the disease which of attendance. And the third, hold the non-binding advisory guideline can be relied upon to determine the care of expected from the Arav Mehta. And the fourth one, award just a reasonable compensation of 55 lakh.
55 lakh, 36,000.
हाँ, you can follow the.
इसमें इसने she has written income assessment as a junior site engineer. Then she has written
assumption.
Funeral expenses.
हाँ, by referring case I have break down the. हाँ.
Non-pecuniary damages.
हाँ, you can refer case law. हाँ, I have two cases regarding this. हाँ, damages I am asked about.
Counsel, what is loss of consortium to parents? Mental agony and loss of consortium.
कितना अफेक्ट कर रहा उसकी फैमिली को बिकॉज ऑफ डेथ ऑफ.
उसके लिए 10 लाख रुपए.
इट इज ऑल अबाउट अजम्पशन. यही अजम्पशन है, ऊपर का सब केस लॉ के रेफरेंस से ही ब्रेक डाउन करा है. यू कैन रेफर केस लॉ पेज नंबर आई विल टेल यू. नेशनल इंश्योरेंस कंपनी लिमिटेड वर्सेस प्रेरणा सिटी विच इज ऑन पेज नंबर 33.
Give to the court that which kind of method is to be adopted for calculating damages. अच्छा damages दे सकते क्या नहीं दे सकते, पहला क्वेश्चन तो ये.
हाँ.
दे सकते.
I am just relied on the case.
The method of calculation can also be given to court.
No, it is not compulsory, but I am just giving like for. हाँ इनके सॉरी हाँ यस 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 मैम इज अ क्रिमिनल केस हाँ यू कैन रेफर पेज नंबर 33 हाँ 2 केस लॉस रेफर ही नहीं करा बट यू कैन रेफर ओके so like
Next up, we have Subal Agarwal, who will be appearing from the appellant side in the matter of Arav Mehta versus State of Dakshinayan.
If it may please the honorable bench, I, Subal Agrawal, representing on behalf of Mr. Arav Mehta, the appellant, in the case of Arav Mehta versus State of Dakshinayan. Further, if the bench permits, I seek the permission of bench to present my submissions. If it may please the honorable bench, for the sake of convenience, I seek the permission of the bench to hereinafter refer the bench as your lordships. Okay. With the permission of your ladyship, I hereinafter refer the bench as your lordship and ladyships. Ignorance count. Ignorance bin. Shall I? If it may please your lordship and ladyship, shall I proceed with the facts? With the permission of your lordship and ladyship, I first. The first issue or first argument is that whether the first issue is that whether my client appellant Mr. Arav Mehta has been rightfully convicted under section 304 part 2 of IBC 1860. If we refer to the case of, if we refer to the section 304 of IBC 1860 as provided in the submissions, for conviction of culpable homicide not amounting to murder under part 2 of section 304, there must be the death must be caused with the knowledge, and there must the presence of intention is not necessary. The elements for conviction under section 304 part 2 of IBC 1860 has also been discussed under the case of Yuvraj Lakshmi Lal Kantar and others versus State of Maharashtra as provided in the submission. The elements, the ingredients or elements for conviction under 304 part 2 are there must, the act must be a culpable homicide not amounting to murder. Further, the person, the doer of the act must be aware of the, has the knowledge that his action might lead to death or such body injury that would ultimately cause the death of the victim, cause death. And third, there should be ultimately death. So, if we coming to the present case, if we discuss whether there is culpable homicide not amounting to murder, the definition of culpable homicide is provided under section 299 of the IPC Act, which states that culpable homicide refers to causing. So the and section 300 provides the exceptions where the which provides where the intention is not required, where the intention is not, where the culpable homicide is there, but it does not amount to murder. That is, there is absence of intention, but the conviction is for the knowledge of causing death and the death that has been caused. So in the present case, whether there Arav Mehta has the knowledge is questioned. So if we refer the facts of the case, the facts which might be considered as knowledge, like facts, the knowledge, the facts like the not providing of spare key, the auto locking system, not picking up the call at midnight. This all does not show that the appellant Mr. Arav Mehta had the knowledge. If anything can be inferred from the same, it can be inferred a negligence. Then if we come to the for conviction under section 304 part 2, first we have to acquit the knowledge, then I will move on.
We have acquitted the knowledge, come to the negligence issue.
Negligence. The section 302A of IPC Indian Penal Code 1860 talks about the causing death by negligence. If causing death by negligence, where the
we know the section arguments. In
this case, the client has been acquitted. The client Mr. Arav Mehta has been convicted under section 304 part 2 and for causing death by knowledge, and I am arguing on behalf of Mr. Arav Mehta that he did not have the knowledge of causing death of Mr. Ritesh Kulkarni. Further, he does not he acted negligently, but the question is that whether his negligence was gross negligence or was the ultimate reason for causing the death of Mr. Ritesh Kulkarni. So, if we see if we refer to the fact that the delay was caused in taking Ritesh Kulkarni to the hospital it is contended that he didn't picked up the calls at midnight. Further, he didn't provided the spec. He did not provided the any alternate route for the alternate access in case of any emergency. This, but we cannot, at the same time, we cannot ignore the fact that this was not the primary reason of causing the death of Ritesh Kulkarni. There was negligence also on the part of the friends of Ritesh Kulkarni.
So you are saying it's a matter of contributory negligence?
No.
Then?
I am saying it is a matter where my client has been negligent, but his negligence was not the reason of the death of Ritesh Kulkarni. There were other factors which led to the death of Ritesh Kulkarni. The same has been I would like to refer a principle of causa causans from the case
Sushil Ansal.
Sushil Ansal versus the Sushil Ansal versus state through CBI and others. In this case, the question was in this case the client please refer the page number 7 of the same case.
Page number 7?
Yes, sir. Yes, your lordship.
मेरे में तो केवल 1 लिखा हुआ है.
Page
number 38
of the case. I have marked it with the pen.
Okay.
In this judgment, the court held the doctrine of causa causans, which reads as to impose a criminal liability under section 304A Indian Penal Code. It is necessary that the act should have been the direct result of a rash and negligent act of the accused, and that the act must be proximate and efficient cause without the intervention of another negligence. It must have the causa causans. And in the next page, further it is discussed that the act accused must be proved to be the causa causans and not simply a causa sine qua non for the death of the victim in a case under section 304 A of Indian Penal Code 8060. So in this case, although the appellant was negligent on not attending the calls and not providing the alternate emergency exit routes, but the main reason of the death of Ritesh Kulkarni is related to the fact that he consumed the alcohol on that day, and there was a argument between the Nikhil and Ritesh Kulkarni, after which he had a panic attack and he got anxious and his asthma aggravated, due to which he collapsed. Then they tried to break open the door and contacted appellant Arav Mehta, but he did not respond. But at the same time, they were not trying to contact with the emergency services. For it is from the fact, it is clear that between 12:18 AM to 12:42 AM, they were only trying to reach Mr. Arav Mehta, and at that time they were not trying to reach the emergency services. After that also, when they around 1 PM, they tried to contact the emergency services, and further on which the facts of the case is silent is that who opened the door or who called the ambulance. So it can be said that they had the means to open the door, but they were negligent. And if they also after the ambulance reached, they ignored the nearby government trauma center and took the Ritesh to a faraway private hospital. This all cannot be ignored.
Right. Prayer counsel.
Yes, Your Lordship.
Prayer. Prarthana.
Pray. In the light of the arguments, in the lights of the facts stated, argument raised, argument stated, the council most humbly praised Your Lordships and Ladyships that to discharge my Mr. Arav Mehta from Section 304, Part 2 of IPC 1860 to allow this appeal and to provide any other order in justice, equity and good conscience.
Thank you.
Thank you, Subal. Next up we have Arya Alhat. She'll be appearing from the respondent side in the case of Arav Mehta versus State of Dakshinayan.
Good afternoon to the Honorable Court. This is Counsel Arya Alhat representing on the behalf of State in the case of Arav Mehta versus State of Dakshinayan. The council would like to submit the submissions. If the bench may permit, the council would like to address the bench as Honorable Lordship, Lordships. So, The council would like to start by presenting the stating the statement of jurisdiction of the court. Statement of jurisdiction. The present appeal has been preferred in front of the preferred before the Honorable High Court under the criminal appellate jurisdiction. This Honorable Court derives its jurisdiction from Section 374 of Code of Criminal Procedure, which empowers the High Court to hear the appeal against the conviction passed by Court of Sessions. Since the learned trial court has convicted the appellant under Section 304 Part 2 of the Indian Penal Code, the appellant has challenged both the conviction and the sentence. This Honorable Court has requisite jurisdiction to adjudicate the present matter. Further, the council, if the bench may permit, the council would like to proceed with the facts of the case. The council would like to state the issues of the case. So the first is whether the act of omission, whether the act and omission of the accused amount to culpable homicide and not amounting to murder under Section 304 Part 2 of IPC. Second, whether the accused has the requisite knowledge that his conduct is likely to cause the death. Third, whether the chain of causation between the act of the accused and the death of the deceased is clearly established. And lastly, whether the conviction under Section 304 Part 2 of the IPC is justified and should it be upheld. The council would like to proceed with the arguments of the case. So the first issue was whether the act and omission of the accused amounts to culpable homicide not amounting to murder under Section 304 Part 2 of IPC. First, knowledge of likely consequences clearly established. It is most respectfully submitted that Section 304 Part 2 of IPC requires knowledge that the act is likely to cause death and not intention. The accused installed an automatic smart lock system which can only be opened by the device of Mr. Arav Mehta. There was no physical spare key provided to the tenants. There was also no provision for any emergency exit. Nextly, the manual which was received from Arav Mehta's mail also stated that the unlocking could be delayed due to network or battery issues. By creating such system where the guests are confined without any immediate exit during emergencies, the accused was aware that such confinement could endanger the life of the people in the room. The same can be further supported by a case of Varsa Singh versus State of Punjab, wherein Supreme Court held that the mental element required for culpable homicide can be inferred from the nature of the act and surroundings of the nature of the act and surrounding circumstances. The court emphasized that when an inherently dangerous act is done and it is done consciously, the law presumes awareness and it's likely the law presumes awareness and of its likely consequences. In the present case, installing a system restricting the emergency exit without safeguarding reflects conscious creation of dangerous situation. Further, in the case of State of Andhra Pradesh versus Rayavarapu Punyaya, Supreme Court explained and clarified that knowledge refers to awareness of probable consequences of one's act even in the absence of intention to kill.
Do you really think installing an automated lock system at some place would amount to having knowledge that something fatal can happen in this place at any later point of time? He just installed a normal lock system. How do you infer that with this action he had knowledge that it would become dangerous in future?
Because there was no emergency exit provided, and which could again be a fatal thing or which can have a fatal
But did Arav know that there was a party going on in the house?
No, he was unaware.
Did he know that there were so many people in the house?
No, he was unaware about
Did he know that there was an asthmatic patient in the house?
No, he was unaware about it.
Then how do you expect him to have the knowledge that something like this would happen?
Sir, it can be further justified by the second point in the issue, which is conscious disregard of risk. Just a minute. The accused designed and implemented a system where after midnight the premise could only be unlocked through his mobile device. He was aware that the auto lock is engaged and that it required app-based access. And when delays were possible, as per the manual warnings and prior as per the prior guest's complaint. So with this, it can be concluded that the person created an inherently dangerous situation to the life of the to life and retains exclusive control over it. His knowledge of likely consequences can be attributed. Shall I proceed? The second point is conscious disregard of known risk goes beyond negligence. It is submitted that this is not a case of pure carelessness. The manual warned about possible delay in unlocking, and a prior guest had complained about the delayed access. Despite this, no backup mechanism was provided. This shows conscious disregard of the known risk. Further, in the case of Keshav,
the risk was limited to people getting trapped inside the house, not somebody dying. You understand? The risk that is foreseeable in this case is that maybe somebody would get trapped in the house and there would be a delay in them coming out of the house. That's it. But nobody would foresee that an asthmatic patient would come to the house in a party and then would, get an asthma attack and then would die. That's too far-fetched, in my opinion.
Counsel would seek some time. Counsel pleads ignorance for it. So I'll proceed with the second issue. Whether the accused had requisite knowledge that his conduct is likely to cause the death, it is most respectfully submitted that knowledge can be inferred from the degree of control exercised by the accused over the situation. The accused retained exclusive authority over the unlock and authority to unlock the premise after midnight. After centralizing exit access entirely within his personal mobile device, he created a system where emergency escape depended solely on his responsiveness. A reasonable person in such a position would foresee an inability to access the premise during a medical emergency and could result in serious fatal consequences. This further, in the case of Ambala D. Bhatt versus Gujarat, versus State of Gujarat, the Honorable Supreme Court held that where an accused exercised exclusive control over the dangerous situation.
But this is not a dangerous situation, it's a normal house.
Yeah,
How do you
but then being
equate this?
confined in a house where you cannot go out without any emergency exits or anything could be fatal.
Okay.
In Ambala D. Bhatt versus State of Gujarat, the Honorable Supreme Court held that where an accused exercises exclusive control over a dangerous situation, knowledge of the inherent risk may be inferred by surrounding circumstances. Court further observed that conscious disregard of such risk while retaining control may attract criminal liability. The counsel would like to proceed with the third issue. Whether the chain of causation between the act of accused and that of the disease is clearly established. So the first is act of the accused was a direct and proximate cause of death. It is most respectfully submitted that the criminal liability arises when the act or omission of the accused is the proximate cause of death. the restriction on exit during the medical emergency caused delay in obtaining treatment.
What was the reason that triggered the asthma event?
Sorry?
What was the thing that triggered the asthma event?
It was the clashes between the one.
That triggered the breathlessness.
Yes.
And after having breathlessness, he wanted to step out for free air.
Yes. Yes.
Right? But what caused the breathlessness? It was the loud noise and alcohol, not the door. If you read point 12 at 11, 12:10, an argument broke out between Nikhil and Ritesh over alcohol consumption and noise. It was alcohol consumption and noise that triggered this breathlessness episode, which ultimately led to asthma attack.
That triggered the argument between the both of them, and not the asthma attack.
No, witnesses state that he was anxious, breathless, and repeatedly asked to step outside for air. He was anxious at the time of this argument only. So it was their party that triggered this entire thing.
Yes, it was.
Plus, if you go ahead and you see, they chose to take Ritesh to a further hospital,
Yes.
which was a private hospital, instead of going to a nearer hospital. Do you think there is a 2% chance that had they gone to the government hospital, Ritesh could have been saved?
Just a minute. Choosing a private hospital was an emergency decision taken in good faith, and it is not an independent or reckless act because of which.
If you see someone has gotten unconscious and collapsed in front of you and you're taking them to the hospital, will you go to the first hospital that is accessible to you, or will you look for a fancy hospital ki nahi yahan nahi jayenge, ye better hospital hai, yahan jayenge? In such emergency situations, you always tend to choose the closest option that's available to you, right?
Yeah.
And in this case, even though chalo, it was done in good faith, there was a time lag, there was a time gap,
There was a time.
which could have been avoided had they gone to the government hospital.
Yes.
Later, the doctor said that because of some delay, had this person been brought earlier, he would have been saved. Is there a slight possibility that this delay that the doctor is referring to could be the delay that happened from going to the government to the private, and could have been avoided had they gone to the government hospital?
Yeah, but it was a panic situation wherein.
No, I'm not blaming them. I'm not saying you can go and sue them. But I'm just saying that is there a possibility that had they gone to the government hospital, they would have been in a better position to save Ritesh? Is there a possibility? I'm not saying for sure. Is there a possibility?
There might be a possibility.
There is a possibility, which means the real reason for death may not be delay in opening the door, but the delay caused in going to the private hospital.
The delay was already caused when the door was not opening and he was already collapsed in the house itself. So delay was caused there only initially. Because he collapsed in the house only. No? It is mentioned in the breathlessness. Because he was repeatedly asking for opening the door to step in the free air. So he was not able to step out in the free air, and that is where. So, shall I proceed?
On whose behalf are you arguing?
State.
State? Or Arav?
State.
Sure?
Yes.
So is this an appeal or fresh petition is being filed?
Appeal is filed by Arav and I am the respondent to it.
So parties mentioned is Arav Mehta petitioner and state as respondent.
Sorry.
So everything is good.
Shall I proceed? Appeal is by the Arav Mehta. Okay. So nextly, no intervening act broke the chain of causation.
We have discussed this, no? We just discussed this.
No, we discussed the above point. We
No, no.
discussed the point right
What
now.
is the intervening act that you're going to talk about? Delay in going to the hospital. We discussed that. Move on to the prayer.
Prayer. Okay, so the council would like to move on to the prayer that in the light of the facts and circumstances which are presented in front of the court, the council would be most humbly pray to the honorable court that it may be pleased to dismiss the appeal raised by Mr. Arav Mehta and upheld his conviction under section 304 part 2 of IPC and pass any other such order as it may deem fit in order of justice. Thank you.
Thank you, Arya. Next up, we have Niyati Jain, who will be appearing from the appellant side in the matter of Arav Mehta versus State of Dakshinayan. आपका समय शुरू होता है अब.
Good afternoon, bench. Good afternoon, bench. This is Counsel Niyati Jain appearing on behalf of the appellant in the case of Arav Mehta versus State of Dakshinayan. If the honorable court permits, the council would like to address the bench as your lordships. If the honorable court permits, the council would now like to make the submissions. Thank you. If the lordships may permit, the council would like to move towards the facts of the case. The council would... Yeah. If the lordship may permit, the council would now like to present the issues of the case. The council has two issues. That is whether the conviction of the appellant under section 304 part 2 of the IPC is legally sustainable, And the second issue being whether there is any criminal liability of the appellant under section 304 AIPC. I am questioning the criminal liability. Sir, it's a criminal case. How would you impose a civil liability? Thank you, ma'am. Moving on, if the council may like to seek the permission to move towards the arguments. The first argument being that of whether the conviction of the appellant under section 304 part 2 of the IPC is legally sustainable. So here it is most respectfully submitted that the conviction under section 304 part 2 of the IPC requires knowledge as one of its elements, and since knowledge is absent here, knowledge is absent in the form of, as there is no knowledge to my client Arav Mehta about the asthma disease which the deceased was suffering from, the alcohol consumption which was one of the violations of the listings which were presented by Arav Mehta, and the occupancy violations. Further, there was smart lock which was commercially marketed, and advisory guidelines were issued which were not binding, and since there were no prior fatal incidents about any of the fatal things happening, hence the smart lock was not the proximate cause, and the
Counsel,
yes.
if you go to the fact sheet carefully, let's go fact by fact. First fact is given on page number 22. Point number 22. A negative review posted 2 months earlier on Arav's listing complained of delayed access due to smart lock. So first, this is the first instance where he got knowledge that the smart lock was creating problems. Second, if you go to paragraph number 4, they retrieved an instruction manual from Arav's email which said remote unlocking may be delayed or fail under low network availability or battery constraints, right? For instance, let's just assume that network connectivity का कोई problem नहीं था, but battery constraints तो कभी भी हो सकता है. Given that he knew about these two things, he knew about the review because he replied to the review, and he knew about this manual also. He's supposed to know about the manual because he's the owner and he's installed those locks. Don't you think it would be very, very, very reasonably foreseeable for him that if there were people who were locked inside the house, there could be any event, I'm not talking about asthma, there could be any event in which they might be required to get out of the house in by way of an emergency, because of which either he should have provided an emergency exit or he should have provided a spare key. So he had the knowledge that the locks could malfunction, and he knew that he was the only one who had the access to open the lock. So I think there was sufficient knowledge that when he was installing the locks, that this could result in an act that would lead to death of somebody. You don't need to have the knowledge of exact what would happen, but I think this act he had sufficient knowledge.
Much obliged, your lordship. As you stated, the 22nd fact which states that a negative review posted 2 months earlier. So basically the complaints here are merely they resemble the inconvenience and not the possibility of Arav Mehta foreseeing that this kind of fatal incident would happen. And even if as you said asthma or any event, but here as asthma is one of the facts stated here, Arav Mehta was not aware of the disease suffering from asthma, due to which there is no knowledge. And secondly, as you stated, the smart lock. The smart lock is mere secure. It is for security purpose, and a reasonable man would not just install it for something which would cause a danger. Rather, a reasonable person installs it for his or her own security, and hence we cannot say that it was inherently dangerous or unlawful. Much obliged, Your Lordship, but it is stated that parties were explicitly prohibited, and the moment they went against the prohibitions, sir, even if not my client, at least he could inform the host. Even the host was on. If much obliged, Your Lordship, but currently in the situation, the facts state that Ritesh Kulkarni, the deceased, was affected by asthma, and 6 months prior he had been hospitalized. So if he was hospitalized, he should have had the reasonable prudence that in the near present or future something of this kind could happen, and he should have informed at least the host. If the host was informed, the owner would have been informed in that case.
Counsel, which reasonable man installs a lock which auto locks from the outside and there's no other way to open it except using their own control?
Much obliged, Your Lordship. As you stated, as you stated that there was nobody was informed. Here, in point 5, Arav has stated in his listings that remote access ensures maximum security and accountability. This states that even if he didn't inform, it was written in the listings and it implied.
No, remote access does not imply that only I will be able to open the door, nobody else will. Remote access means I also will be able to open the door remotely.
Much obliged, Your Lordship, but the Lordship asked me about that, how was he aware that nobody was aware about the lock which was there. I'm stating the same point that he stated that in his listing he stated remote access, but he stated remote access, which signifies that there was a lock system. Since the Lordship is raised in concern that the people therein weren't aware of the lock system. They were aware because in listing it has been mentioned.
And it means for security and accountability. That logically should have been like, ki you also have access, you can open the door. If, exactly, in case of any emergency, I can open it remotely as well.
Much obliged, Your Lordship, but if you refer fact 22, Arav had replied that the system works perfectly when guests follow the instructions.
Obviously, he's going to say that he's not going to accept that, yes, it's the fault of my system.
If you refer fact, just a second. If you refer fact 18, it stated he was taken to a private hospital at 1:30 a.m. If the lock was such rigid that it wouldn't have opened, how did it open at 1:30 a.m. and
it never said that the lock opened, did it? Yeah, broke the door.
Sir, the facts don't say about the same.
It doesn't even say that the lock opened.
How was he taken to the private hospital?
Because the emergency services came.
it is nowhere stated in the facts that the
But at
emergency
least we
serv-
can presume that.
uh, presumption of facts wouldn't. But sir, being taken to a private hospital, first of all, if they wanted to call the emergency services, they would have called by 1:05 a.m. They waited. Sir, panic situation. Sir, much obliged, your lordship. There were seven people out in there, and out of which two of them knew about the same, due to which they would have known that if certain circumstances of this type happen, they would have made the assurance. And between Sir, it is a very reasonable man would, instead of calling 6 times, and even if there were 7 participants, out of which one was deceased, one who was the one of them had called, was calling Arav Mehta, which he wasn't answering. In a very reasonable situation, any of the persons would have called the emergency situation. For 50 minutes, they cannot be in a panic
counsel,
situation.
you're saying everybody except your client, who was actually the one responsible for locking them inside, is responsible for the death?
Much obliged, your lordship, but the Arav Mehta, my client, wasn't liable for locking them inside. It was stated.
Who
in
locked them inside then? At 12 o'clock.
The technology was responsible.
And who was responsible for the technology?
The mere misfunction we cannot just state that because of a mere misfunction that it is delayed access, and we cannot.
So if I rent a car, if you rent a car tomorrow from say, right, and the brakes don't work, technology is responsible.
Ma'am, you should have if you rent it, you first check all the.
चला के देखे brakes चल रहे हैं कि नहीं.
But then if they're doing these kind of services, or they're providing these kind of services, they also mention it in. Obviously, there would have been some of the written facts or statements which depend on case to case.
You are assuming that now.
Much obliged, your lordship. The case which you are talking is a hypothetical situation, and according to that, it differs from case to case. What are the facts stated and the agreements? So we cannot just assume a situation unless and until there
So
are
according
relevant
to you,
facts.
what was Arav's responsibility in this case? Was he responsible for anything? His apartment he was renting, or the guests he was hosting, or the lock he had installed? What was he responsible for?
He Sir, he was a resident of, he was residing in Rudrapur, and you, as a reasonable person, we can't expect every now and then a person to be available. And sir, it is a high traffic rental building, due to which we can't just leave it as it is. And in the present case scenario, it was needed because the state has witnessed its own exponential growth, due to which such security system were much needed in the
Then
case.
why lock the door from outside? Provide 3-4 good locks inside. The guests you're hosting, I don't think
Sir, much obliged, Your Lordship. But from time to time it changes, and now that technology is into consideration, no people would go for wooden locks. They would go for a good type of technology.
Give good कौन सा वाला lock था ये? Technology lock only, but make it so that it can be opened from inside as well. In the new office, yeah, it can be opened from inside as well. Code.
Sir, the facts nowhere mention that there was no lock from inside. It just mentions that it had a smart lock outside, so we can't just
You're
assume.
saying they could have opened from inside as well, they just didn't. सात लोग एक साथ पागल.
Because it was witnessed that at 9:45 p.m. everyone was carrying a liquor bottle in their hands. Sir, it depends from case to case. Why are you carrying a gun, first of all?
So your case is the door was, it was possible to open the door from the inside, but because these people were drunk, they were not in a position to understand where is the door, how to open the lock.
Sir, we can't. I'm not saying that there was a lock inside. I'm just saying that there is no fact stated in the fact sheet about the same.
But then why would there be this entire story or problem if there was a lock inside and it could be unlocked?
It is. Again, Your Lordship, the people there were drunk, and you can't.
You are saying that it was possible to open the door from the inside, but when these drunkards tried to open the door from the inside, they failed.
The council, please ignore it.
How can you please ignore it?
I'm not stating that it was possible for the people to open the door from inside, but I'm just saying that since the facts remain silent there, we can't just assume that the door had only the smart lock system and not the. Sir, assumptions are not allowed in a criminal case. So basically, as per my client, the act here lacks proximate nexus with the death. Basically, it is much needed that in order to derive the criminal negligence or the criminal act, you need to establish the proximate nexus with the death. See, the act herein which everyone is referring to is the lock, but there are several intervening acts which weaken that, and due to which the Arav being Arav being convicted culpably liable is not. Convicted under culpable homicide not amounting to murder under section 304 part 2 of IPC.
Culpably liable.
Just a criminal liability, sir.
Yes.
Yes, sir.
If you again refer to point number 12, what she pointed out, there is one more thing that attendees later stated that they were unaware that doors would auto lock. Matlab, if you are the owner, you really don't care to inform them that automatically after 12 तुम्हारे 12 बज जाएंगे.
Sir, I addressed this question earlier. Actually, he had mentioned in his listings about the remote access, and the remote access impliedly signifies about the lock system.
No, ma'am. Nowhere it says that it will amplify what you are trying to say.
If you say in your listings that there was remote access, it means that there
Again,
was.
Weber sir just pointed out there is a difference between exclusive access and remote access.
Sir, here in point 12, as your attempts to you referred point 12, right? Attempts to open the main door manually failed. Attendees stated that they were unaware that the door was auto-locked.
Yes, so you would have informed me. मैं दरवाजा बंद ही नहीं करता. Right?
Sir, again, Lordships, could you repeat the question? Could you repeat the question?
What I am trying to say, it is very simple, right? Arav Mehta informed the client inside that automatically after 12 the door will get locked. Inform किया है कि नहीं किया है?
He stated in his listings though that remote access ensures maximum.
There is a difference between remote access and there is a difference between information giving, right? So I am not talking about remote access.
So when Nikhil, who was the host of the party, was booking the flat, he may have raised a query.
He may. There is a difference between may and actual knowledge.
Exactly, Your Lordship, I am stating the same fact that as you stating that the auto-lock thing, it happens at 12, it is nowhere mentioned. So, Nikhil, while booking, there are no facts stated here regarding any communication between them, only that the listing has been mentioned. But prior to the bookings, if he is written here that the remote access ensures maximum security and accountability.
What is the basic purpose of remote access? Remote access is related to lock, right? Number one. That lock is for the purpose of security. Number two, right? So as far as security is concerned, as far as automatic lock is concerned, do the person visiting that specific premises have knowledge about this automatic lock? No. So don't you think so your client is under an obligation to inform कि boss रात को 12 बजे के बाद automatic lock हो जाएगा?
Sir, if you the listings.
What listing are you talking about?
The listing that is stated in point 5, remote access ensures maximum security and accountability.
Yes.
This implies that there was a smart lock. The smart lock is known as a smart lock because it would engage at 12.
मतलब if you are trying to say that remote access वाला जो है, right?
Yes.
अगर वो other किस्म का lock होता तो उसमें security नहीं होती.
It depends on the technology which you're using.
What if I am using the normal lock? There is no security.
Your Lordship, it differs from the facts to facts of the case.
Exactly, that is what I am trying to say. As per fact, you are supposed to tell me about the kind of lock which you have installed on the door. That too with specific timing instructions.
Sir, herein there is no fact stated about the same.
It is stated. This is what I pointed out in point number 12 as well.
Here it's written attendees later stated that they were unaware that
yes,
door.
They were unaware.
Sir, again, it would be the host's response. Lordships, it would be the host's responsibility to make them aware about the same, because the host had booked the flat after seeing the same, and since in state of Dakshinyan, it being it facing an exponential growth in the short-term residential leasing, the advisory guidelines were mentioned, but they were not mandated.
Okay, who is host, by the way, as per you?
Who conducts the...
In this case?
Nikhil.
Are you sure?
Yes, sir.
Is it Nikhil or Arav?
It is Nikhil. Arav is the owner. Sir, here... Just a minute, Your Lordship. Just a minute. Your Lordships, the word host would have different meaning in different circumstances. He was hosting 7 people. Not the host. The thing of hosting doesn't restrict up till parties. It differs from case to case. In this case, it is not restricted to only parties. Arav was the owner of the flat. He's not the host. The host in this case, stated as per the stated facts, is Nikhil, because Nikhil hosted 7 people. It is not restricted that he hosted 7 people for the party purpose or anything. The second argument, yeah. Just a minute. The second issue of mine states whether he was criminally liable under section 304A. So basically, as per section 304A, criminal negligence is what is needed, and herein criminal negligence was not seen because of the intervening acts and broken chain of possession. The intervening acts which stood after the intervening acts of negligence, basically here for absolving 304A's negligence, a criminal negligence is required, and for absolving criminal negligence, what is required is that the proximate cause and the death cause should be very immediate to each other. That is, direct cause should be there, and no.
And what makes you say that it wasn't direct and connected? And
due to the human intervening, there were multiple human intervening decisions. Like, firstly, just a second. The delay in the emergency calls, further bypassing the nearest trauma center. Trauma centers are the government trauma center which was bypassed by him. The government trauma centers are basically equipped with all the emergency things.
Not really. So maybe this government trauma center did not have asthma related machinery.
So trauma centers are meant to have all the type of emergency requirements, and yeah, so they bypassed it. Here, it is the intervening act that the human decision of taking him to a private hospital rather than taking him to a government trauma center which passed by the private hospital.
You know, some kind of private hospital and why government hospital, when he knows the consequences of it?
Sir, emergency, Lordships, a reasonable person would prefer his life more than luxury in a private hospital.
I am not going to get luxury over there. I am going for treatment. Better treatment.
Since he was into so much of emergency and panic, the first and the foremost thing which a person could do is go to any hospital so that they get some treatment, and after that, if you wanted, you could shift them to a private hospital for the same.
Before shifting anything happens? And what if the doctors sitting at government hospital are unconscious?
Or maybe not even available.
So
This happens.
Just a second. Sir, actually, this is again assuming of facts that what if this is not available, what if that is not available. But then since a trauma center passed nearby, it was very evidently seen that they would have gone to this, and then after taking appropriate treatment, if he would have stabilized, then they would have moved to a private hospital for seeking a better recovery and yes, Your Lordship.
Move on to the prayer. आपने बहुत समय ले लिया already.
In the light of facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly prayed before the Honorable Court to approve my appeal, approve my client's appeal, and acquit the appellant from all the charges of Section 304 Part 2 and Section 304A, and pass any other orders which the court may deem fit in the interest of justice, equity, and court conscience.
Can we pass equity orders in criminal cases? Equity means giving equal or similar treatment to the other party. तो इसको asthma attack आया तो उसको भी asthma attack दिलवा दे.
Sir, please could you repeat?
Can we pass equity orders in criminal cases? जो नुकसान इसका हुआ वही नुकसान अब इसका होना चाहिए. Equal treatment मिलना चाहिए. That is equity.
Your Lordship, the council nowhere can state whether equity has to be granted or not. It depends on the Honorable Court's decision.
Can we, if we want, can we grant equity in criminal cases? No, we can't. Okay. Thank you. Next up we have phone. Next up we have Aditi Jallavar, who will be representing the state of Dakshinayan in the matter of Arav Mehta versus state of Dakshinayan. We have 4 more contestants to go now. Yes, only 4. 10 हो गए, ये 11. Aditi, you're fine this way? Okay, start.
Hello. I'll start. If it may please this honorable court, this is Counsel Aditi Jallavar arguing on the behalf of the respondent in the case of Arav Mehta versus State of Dakshinayan. If the Honorable Court would permit, the counsel would like to make submissions to the bench. If the court may permit, the counsel would like to state the facts of the case. If the court bench permits, I would like to state 3 most important facts. The counsel seeks permission to raise the issues of the case. Much obliged. So the issues raised are whether the conviction of the appellant under section 304 part 2 of the Indian Penal Code is legally sustainable. The counsel seeks permission to move towards the arguments of the case. Much obliged. So the first issue, which says that whether the conviction of the appellant under section 304 part 2 of the Indian Penal Code is legally sustainable. So I would start with saying the section 304 part 2 of IPC, which says that if the act is done with the knowledge that it is likely to cause death, but without any intention to cause death or cause such bodily injury as likely to cause death, then the person is punishable for a term which may extend to 10 years or with fine or both. I would like to state that the appellant possessed the requisite knowledge that his act was likely to cause death. Part 2 only applies when there was no intention to cause death, but there was knowledge. To establish knowledge, I would like to refer to the case of State of Andhra Pradesh versus Raya Varapu Punaya and another. The Supreme Court said that if the offender is aware of the likelihood of such injury resulting in death, the mental element required stands satisfied. The court said that the intention is not important, but if the accused has a slight knowledge that his act can cause death or such bodily injury, and his act has some fatal consequences, he is assumed to have knowledge of his act. In the present case, Arav installed and operated the system. He also retained control of the system. He was also aware of its limitation, yet he installed the system. The system may also not work when there was network issues and battery constraint. Him being a software consultant should be aware of the limitations of the act. He also was aware that there could be individuals who were confined in this apartment. And when there were such situations like emergency situation which happened, if he is not 100% accountable, it would lead to the death or like cause injury to the other person. Especially in cases of rentals, you never know what emergencies could the person have. There could be a heart attack, there could be a pregnancy lady. It is not important that it is only asthmatic patients, but rentals you always have a lot of other cases that can be taken care of. Also, the accused did not even provide with a spare key. He should know that in cases of emergency, he should provide them with a spare key. If there was no spare key provided, he should have at least given the remote app access to somebody else, like the neighbor or somebody that he could have trusted. So hence Arav had the knowledge that he could genuinely foresee what could come, but he genuinely did not take any actions towards it. Also, if he knows that the system was automatically logged after 12 AM, he should have informed the attendees who were there. The attendees in the evidence say that they were not informed that it was remotely logged. There was no alert that they could hear.
Counsel, but in the listing it's been written that remote access ensures maximum security and accountability. 0.5.
Sir, if he is taking 100% access to it, he should also be available 24/7 then. If he is taking 100% control to himself, he should also take 100% accountability. He put his phone on silent and slept. So he doesn't care what will happen next. If there was somebody else who was, so in this case it was a person who was having an asthma attack, but it would have been, had it been somebody else and it would have been an emergency situation. If say the house is on fire, what will he do? And he's sleeping. So all of them will die. The knowledge of specific victim is not important. Even in this case, when the person was intoxicated, he is also protected under basic this, that he should be had not held in the wrongful confinement. There also exists a clear and direct and proximate nexus between the act of the appellant and the death of the disease, thereby rendering the conviction of the accused legally sustainable. First, he created a dangerous and unsafe situation. He knew the risk, he still created the system, did not even provide with a spare key or did not even tell them that this would be locked. Had they been known, they would have gone out of the house before 12 a.m. This caused the victim to not exit the rental space, and which also delayed the rescue and medical assistance. There
Counsel,
was also
all of that you're saying is for 304 part 2 or is it for 304A?
304 part 2, knowledge.
If you come and tell me that because of all these reasons there was a duty of care and that duty was breached by Arav, I will accept it. But I still am not able to gather my mind around the fact that he had a knowledge that it may be fatal for somebody would get an asthmatic attack, and that is why it is culpable homicide not amounting to murder. There are a lot of mitigating factors, there are a lot of intervening factors which happened which contributed to this. So you can't just simply point it out and blame the owner of the house saying that because you locked us inside, that is why he died. He was drinking alcohol, there was a loud noise. When they were able to get him out of the house, they skipped the local government hospital and went to
private hospital. नहीं.
सही बोल रहे ना? Yeah. So there were सही तो बोल रहे. So there were a lot of intervening factors because of which I can very easily see that had these factors been in place or not gone wrong, probably this guy would have been saved.
I understand your concern, Lordship, but I wanted to say that first of all, when you said that they took him to the private hospital. So when you are in a state of panic, when you are in a state of medical emergency, you genuinely don't know which hospital to go to. Maybe geographically it was in the limits, like nearer to the private hospital, but in the case of panic, they might have trusted the private hospital more.
When somebody is collapsed, somebody has collapsed in front of you, what should be your priority? Getting good treatment or getting a basic treatment to keep them alive?
Sir, Your Lordship, I would like to say that we genuinely cannot infer the state of mind of the attendees who were there of why they took him to the private hospital. They would have trusted
no,
the
that is
private
okay.
hospital.
I'm not blaming them for taking him to the private hospital. What I'm saying is, can this fact that they skipped the government hospital and went to the private hospital, which was farther, could this have contributed to the delay that happened because of which this person died? Because the doctor said that timely intervention or earlier intervention could have saved him.
So the primary cause of all of this was him not being able to get out. He got a panic attack over there. Earlier also, in the fact sheet, it was mentioned that the victim suffered a panic-induced asthma attack and he was admitted in the hospital for 6 months. So when the fight took place between the victim and Nikhil, so at that time maybe his asthma attack was triggered.
Was
But
the fight because he wanted to go out?
No, no.
It was with respect to alcohol consumption and noise.
Yes, agreed. But then once the fight started and he got anxious, he wanted to step out. He couldn't step out. That is the reason he became panicked, and that is the reason the asthma attack was caused. So the main and primary cause of the attack was him not being able to get out of the house.
But the primary cause for death wasn't asthma attack. It was delay in treatment. Asthma attack by itself does not kill anybody. People come back normal.
But then till 1:30 they were there at the rental space and he collapsed there itself.
Yes.
So after that they took him to the hospital.
Yeah, that is because they didn't even call the emergency services before. Had they called the emergency services, they would have been able to take him to the hospital before only.
No, the timeline was Ritesh felt anxious during 12:10 and from 12:18 they started calling the owner. They called him various times. They've also messaged him. But after 12:30 they also tried breaking the door open. They couldn't do that. And at 12:50 when Ritesh finally collapsed, they knew how serious it was, and that is when they realized that it is very important to call the ambulance. पहले से ही एम्बुलेंस बुला के
पहले
क्या
से नहीं
करेंगे?
बुलाया, but he collapsed at 12:50 and they called the emergency after 1:05. So 15 minutes is 1/4 of an hour. Too much delay.
They were really panicked. They didn't know what to do. Maybe they can.
Because they were drunk?
Yeah, that can be a.
They were not allowed to drink. Still they were drunk. However, इस reason से भी हो सकता है delay.
So in a rental apartment, usually people call, like if there's a party, they can call anybody at home. Even though it was mentioned that only 4 people were allowed, even if 7 people came, the primary cause is they were not allowed to go out. All of that is secondary, that they couldn't call it was a 15-minute. No, sir. I have medical reports attached to my memo saying asthma, alcohol cannot directly affect asthma.
Your medical report says not everyone with asthma experiences the onset of an attack or worsening symptoms when drinking alcohol. But the next line says, in one 2000 study, about 33% of participants said alcohol was associated with an asthmatic event at least 2 times, which means 1/3 of the population of everybody who has asthma, for them alcohol is a trigger.
Sir, but here it was written that after drinking alcohol, they got into a fight and he just got anxious and he asked to step outside. When he's asking to step outside continuously and the door is not opening, that cause led him to a panic attack. And it is already mentioned in point 9 that he already had a panic-induced asthma attack before. So him telling ki I want to go out, and you not letting him go out, or you telling him that you are confined here, that led him to the panic mode, and that made him
Had the
situation even
owner
worse.
of the flat or Nikhil, somebody knew that Ritesh already had this problem, because it is clearly mentioned in fact number 9 that this information was known to at least 2 attendees but not disclosed to the host or the apartment owner. So here, as it is mentioned in the flat, Nikhil is the host and owner is Arav. So none of them knew, right? So had Ritesh already informed them, then maybe they could have done something about it, right?
No, but then today it was an asthma attack, but tomorrow, if suppose there's a lady who is supposed to
That
get
is
in-
okay, counsel. Let's not jump to what can happen, what cannot happen. Yeah. Let us be here at the present.
But then the host himself should not have made such a system where he has exclusive access. Suppose he did not have battery at that particular amount of time, or he was not available in the network system. Even if he knew if a person has asthma, he would have been aware, like he would have been careful. But then if he is not in the network range, then it's automatically leading to the same thing again. No, I would like to move to the prayer.
Yes.
In the lights of the facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly requested before this honorable court to dismiss the present appeal filed by the appellant and to pass any other order as the court may deem fit. Thank you so much.
Thank you. The next participant is Kirti Gupta. She'll be appearing from the appellant side. She is the last participant from the appellant side in the matter of Arav Mehta versus State of Dakshinayan. We'll take a quick 2 minutes ka susu break and then we'll start. Now we have Kirti Gupta. She'll be representing the appellant Arav Mehta in the matter of Arav Mehta versus State of Dakshinayan. This is the last speaker for appellant.
May it please this honorable court, I am Kirti Gupta appearing on behalf of appellant Arav Mehta in the matter of Arav Mehta versus State of Dakshinayan. The present appeal challenges the judgment of the learned trial court which convicted the appellant under section 304 part 2 IPC, holding him criminally liable for the death. The present appeal challenges the legality and correctness of the said conviction. Now, if the court may permit, counsel would like to make the submissions. With your lordship's permission, I would like to briefly summarize the facts of the case. Issue number 1. Conviction under section 304 part 2 IPC is unsustainable. It is respectfully submitted that section 304 part 2 IPC requires knowledge that the act is likely to cause death. Mere negligence or inadvertence does not satisfy this requirement. In Keshav Lal versus State of MP, the Honorable Supreme Court held that knowledge must be actual and conscious and not presumed. In the present case, the appellant was not present at the premises. He had no knowledge of any medical emergency. He was unaware of the deceased's asthmatic condition. He had no information regarding alcohol consumption or rule violations. The installation of a smart lock is a lawful and widely accepted security practice and cannot by itself be termed a dangerous act likely to cause death. Hence, the essential element of Section 304 Part 2 IPC are not fulfilled.
But what about installation of a lock whose exclusive access is with the owner, who's not even there on the premises?
Sir, it was just for the safety of
But that safety resulted in something being fatal, because had the lock problem not been there, these people would have been easily able to step out for air and the asthma attack would not have happened in the first place. So when you say that you cannot presume knowledge, I'm not talking about this particular incident, but when you lock a group of people in a confined space, then it can be assumed that you have knowledge that if at all an emergency situation comes up, they will be trapped inside.
But Your Honor, that would be a ordinary negligence. It would not lead to a criminal liability that has happened in the case.
So you're agreeing that it's negligence. Whether it's criminal or not, we'll discuss when you're talking about Section 304A.
Yeah.
But you are saying it's negligence.
Ordinary negligence.
Negligence.
Yeah.
Okay. But I still think that if I confine a group of people in an enclosed space, for any prudent man, that would be knowledge. They would know that if an emergency comes up, these people will not be able to do anything about it, and that might become fatal.
But Your Honors, the tenant also broke the rule. The rule was to invite 4 people maximum and he invited 7. So
It does not matter. When they broke the rule, it's a civil thing that happened. You can sue them for breach of contract. No problem over there. But them breaking the rule and inviting 7 people instead of 4 has nothing to do with the asthma attack and the death of the deceased.
but that doesn't lead to the knowledge that it will lead to a death of a person. Issue number 2, absence of gross or culpable negligence. Criminal negligence must be gross, showing reckless disregard for human life. In Jacob Matthew vs. State of Punjab, the Honorable Supreme Court held that criminal negligence must go beyond mere carelessness or error of judgment. The appellant installed a standard security device, clearly stated the SS method in the listing, was under no statutory obligation to provide round-the-clock SS.
There was guidelines issued by the state, no?
But it was not mandatory, it was recommendatory.
But it was a duty, it set a standard of care, no?
No, but it depends on Arab whether to follow it or not.
Agreed. Had it been mandatory, then it would have been a legal obligation. I'm not saying it's a legal obligation, but when the state issues a set of guidelines, they show you a standard of care. And that standard of care was breached by Arav. So it's negligence.
So
And because of that, a death has happened. Then it's criminal negligence.
Your Lordship, but he does not break any law, as it was just recommendatory that he wants to follow it or not.
Okay.
Thus, at best, the facts do not suggest it a criminal offense. Issue number 3, break in chain of causation, novus actus intervenis. The causal chain between the appellant's act and the death of the deceased was broken due to independent intervening acts, namely violation of occupancy rules by the tenant, consumption of alcohol by the deceased despite a known asthmatic condition, delay in contracting emergency services, transporting the victim to a distant private hospital. In Naresh Giri vs. State of MP, the Supreme Court held that where independent acts intervene, criminal liability cannot be fastened on the accused. Therefore, the appellant cannot be held responsible
Unless the accused's act remains the direct and proximate cause of death.
Yes.
In this instance, violation of occupancy rules has nothing to do with whatever has happened. Consumption of alcohol again has nothing to do, because alcohol and asthma, they do not have any relation amongst each other. Delay in contacting emergency services, had they even contacted emergency, it's not as if the moment he started saying that he's having problems, they were just sitting idle and waiting for RF to pick up his call. They were trying to call RF continuously, but at the same time somebody was trying to break the door. So it's not as if they were not trying to get him out. It's just that they were trying other measures, and all of them were drunk, right? You cannot expect them to be prudent and know what to do and what not to do. So delay in contacting emergency services is not it's not as if they didn't do anything. They tried to get him out of the house first. When they saw that they failed, then they called the emergency services, which I think is prudent enough. And last is transporting the victim to a distant private hospital. That, see, he started feeling breathlessness at around 12:10. He reached the hospital at 1:30. At 1:05 they called the emergency services, which means till 1:05 they were stuck in the house. Right? So from, let's just assume that they called the emergency services, they came instantly and opened the door at 1:05 only. So from 12:10 to 1:05, 55 minutes they were stuck in the room. And from 1:05 to 1:30, that is 25 minutes when they reached the hospital. By skipping the government hospital, how much time would they have saved? Or how much time would they have taken more? 5 minutes, 10 minutes? As against 55 minutes that they were stuck in the house because the door could not open. So even if this delay is there, it's a very marginal delay, I believe.
But Your Honors, like violating the occupancy rules by the tenant, he has to invite maximum 4 people, but he invited 7. They already made the room claustrophobic for a person who has asthma.
But he didn't know that they had asthma.
But Arav Mehta didn't have knowledge about it either. And consumption of alcohol by the deceased was also a negligence by his side. He knows that he have a condition and he was hospitalized 6 months before. So he should also carry a inhaler with him. That was also a point. That was negligence from his side.
So negligence on the side of, on the part of the other party, will that absolve your client from the liability? Because I think the primary liability comes on your client. The first instance, when he started feeling breathless, had he been able to get out of the room at that instance itself, he would have been saved. The reason why his asthma got aggravated and he fainted and all of that happened because he was stuck in that closed room.
Your Lordship, there was a negligence from Arav Mehta's side, but it cannot directly be called a criminal liability. There were intervening acts that break the chain. That's my point.
Okay.
So issue number 4, at most, section 304A IPC may apply. Without admitting liability, it is submitted that even if negligence is assumed, the facts do not disclose the mens rea required under section 304 part 2 IPC, that is knowledge. In Sushil Ansal versus State, the Honorable Supreme Court emphasized the distinction between negligence and knowledge. Accordingly, the conviction under section 304 part 2 IPC is disappropriate and legally erroneous.
Okay.
So in the light
So you are agreeing that we can convict your client for negligence, culpable, killing, causing death by negligence, but not under 304 part 2.
Your Lordship, this is just an alternate submission.
Yeah, we agree to this submission. We want to convict him under section 304A. Is that okay with you?
Yeah, it is an alternate submission.
So it is okay with you?
Yeah.
We want to convict him. We'll pass an order sending him to jail for causing death by negligence. That's okay with you?
Your Lordship, even if you assume some mistake, it was only an ordinary negligence and not the kind of knowledge required under section 304 part 2.
No. I understand it was not knowledge, but what about negligence? You just said in my alternative submission is, okay, at most this can be considered to be causing death by negligence, right?
Yes.
We agree to it. So we'll pass orders and we'll convict your client under section 304A under causing death by negligence. That works with you?
It depends on the court.
No, I'm telling you, we'll do that. Is it okay with you? You agree to it? Because right now also he has been imprisoned.
Yeah.
Under 304A also he'll get imprisoned.
But he is also, according to the previous judgment, he is also liable for culpable homicide. According to the previous judgment, he filed an appeal that he doesn't have any knowledge. That is
so
required.
When he hired you to file an appeal, did he want to get completely acquitted, or was he like किसी एक charge से मेरे को acquit करा दो दूसरा रहेगा तो चलेगा?
It was between me and my client.
Okay, ठीक है. तो we'll pass orders convicting him under section 304A, acquitting him under section 304 part 2. Works with you?
Again, I'll say it depends on.
नहीं, I'm telling you, is it okay with you?
Yeah.
Kind enough to take permission from you.
It was, my client doesn't have knowledge. So it was.
We agree he doesn't have knowledge.
Yeah.
We'll acquit under 304 part 2. Now talk about negligence. Do you agree that there was negligence on his side, on his part?
Ordinary negligence.
What is ordinary negligence?
It is not gross, not of a very high level.
Is there any case law that you have which says that negligence has to be gross, only then you can?
Yes. Just a moment. Jacob Matthew versus State of Punjab, page number 3. Court stated that while civil liability may arise from simple negligence leading to compensation, criminal liability requires proof of recklessness or indifference to the
So
consequence.
indifference to consequence, I think it works over here. Na? People were calling him and he didn't care to take the phone. I don't know for what reason, for whatever reason. He was indifferent. जो हो जाए भाड़ में जाए हम तो फोन नहीं उठाएंगे. That is what is indifference to consequences.
But it was midnight and he was sleeping, and on humanitarian grounds it is expected that any person would be sleeping at midnight.
But he is required only after 12 o'clock because only after 12 o'clock the door gets locked. उसके पहले तो कोई कॉल भी नहीं करेगा कि वो खुद ही डोर खोल के. And if he loved his sleep so much, why did he keep the access with himself?
But it was not his.
He must be getting disturbed so many times. His guests stay every day. He knows that every day he gets calls. Sometimes somebody would order something from Blinkit. Sometimes they'll have to go outside. ये सब तो चलता ही रहता है. Zomato. So he has this knowledge कि उसके पास calls आते हैं 12 बजे के बाद. कभी ना कभी ऐसा होता होगा, है ना? Not everybody who would come for a short stay would come, sleep at 10, wake up at 8.
But
right?
Arav was also drunk in a private party.
That was the indifference we are talking about.
And it was not his statutory duty to be available 24/7.
Then why did he keep complete control with himself? He would go to Baner and sleep then. If he has locked you here, he would take care that someone from the office knows that Kirti is locked in this room. If he goes to Baner, nobody knows, and just in case you get suffocated because of some gas or anything like that, he would be responsible, right?
But
so why not Arav?
But it was not his obligation. It depends on, like in your example, it depends on him whether he wants, whether he will be available for me after study hours or not.
After study hours, because my work hours are study hours, right?
Yeah.
But यहाँ पे you are taking money for him for 24 hours or for 12 hours?
For 24 hours.
So 24 hours you have to be available.
But it was, again, it was not his duty.
Of course it was his duty. It wasn't his legal duty probably, because the guidelines you are saying is not mandatory. But these guidelines set a standard of care, and by virtue of that standard of care, it was his duty to be available if he keeps exclusive access. Had he not had exclusive access, no, then it wouldn't be his duty. But he had exclusive access. It's like चिट भी अपनी पट भी अपना की exclusive access भी हम ही रखेंगे, लेकिन 12 बजे के बाद मेरे को disturb मत करो. ऐसे थोड़े होता है.
No, he didn't say कि 12 बजे के बाद disturb मत करो.
तो कौन सा बहुत काम आया?
तो कुछ नहीं हुआ.
But वो midnight था तो वो expected तो है ही कि वो सो रहा होगा, और
Again,
he was
midnight
also
के
drunk.
बाद ही तो उसका काम आता ना. See, the doors engage with the lock only after midnight.
Yeah.
तो midnight के पहले तो any which way उसका कोई काम नहीं था. उसने जब अपने पास exclusive access रखा तो उसको पता था कि अगर मेरा काम आएगा तो midnight के बाद ही आएगा. This he knew ना. तो now you can't take a defense कि आप midnight के बाद मेरे को कॉल करोगे तो हम थोड़े ना आपका फोन उठाएंगे.
But it didn't lead to criminal liability. The main point here is that he is not liable for section 304 part 2.
That I've agreed. We're talking about negligence now, 304A.
Yeah.
That's okay with you?
Yeah.
So we'll pass orders.
Depends on the bench.
Bench, what do you want? Bench. आप yes या no बोलो बस. What do you think? We should pass orders? Yes. So we'll pass orders convicting him under section 304A. Okay? अब तो वो जेल ही चला जाएगा तो फी कैसे पे करेगा? But that is between them, na? She said it's between me and my client. I'll not tell you. So that's between her and her client.
I will. बट उसकी तो पनिशमेंट ज्यादा होगी कल्पेबल होमिसाइड की.
तो कम चलेगा ना मतलब.
पहले आरब ने उन लोगों को एक रूम में बंद रखा, हम लोग आरब को जेल में बंद रखेंगे.
Okay. In the light of the facts stated, issues raised, arguments advanced and authority cited, it is most humbly prayed before this honorable court to set aside the conviction and sentence of the appellant under section 304 part 2 IPC, acquit the appellant of all charges, or in alternative, convert the conviction to section 304A IPC or any other order as this honorable court may deem fit.
In the interest of?
In the interest of justice.
बस.
Yeah.
और कुछ नहीं. Okay. Thank you. Our next participant, who's the second last participant, is Mohit Varyani. He'll be representing the state of Dakshinayan in the matter of Arav Mehta versus state of Dakshinayan. उसको बोलने दोगे नहीं बोलने दोगे? यहाँ पे 3 लोग का फोन है, किसने अपना फोन नहीं लिया है?
May it please the Honorable Court, this is Counsel Mohit Varyani on behalf of the respondent in the matter of Arav Mehta versus the state of Dakshinayan. Varyani. एक बार सर्टिफिकेट पे लिख दिया. Varyani. The counsel seeks permission to address the bench as your lordships. Much obliged, your lordship. The counsel seeks permission to approach the bench for submissions. Much obliged, your lordship. Are your lordships well versed with the facts of the case, or would they like a brief statement of facts? Much obliged, your lordship. In the present case, my approach to the case will be threefold, where I have advanced 3 issues. First issue is whether such an appeal shall be maintainable before this honorable court. The second issue is whether Arav Mehta was aware of his actions. And the third issue is whether there was wrongful confinement on behalf of Arav Mehta. Now, if your lordships permit, the council would like to move further with the first issue. Much obliged, your lordships. The first issue is that of whether this appeal shall be maintainable before this honorable court. Under section 384 of IPC of CRPC provides provisions for summary disposal of appeals, summary dismissal of appeals, where the subsection 1 subclause B provides that no appeal presented under section 383 shall be dismissed except after giving the appellant a reasonable opportunity of being heard in support of the same, unless the appellate court considers the appeal is frivolous. The council believes that this appeal has no merits, as there have been no new evidences, or the sessions court has not defected in its judgment, has used its wisdom. The same was held in the case of in Manumia versus State of Gujarat, where the learned court, where the Supreme Court held that the learned judgment of the Sessions Court shall be held, and the High Court was correct in dismissing the appeal. This case law is referred on page number 1. The council seeks permission to move to issue number 2. Much obliged, your lordship. Issue number 2 before this court is whether the appellant was aware of the results of his actions. The section 299 of IPC provides for culpable homicide, and it is punishable under section 304 part 2 of IPC, which clearly states any act done with the knowledge that is likely to cause death without any intention to cause death, or to cause bodily injury as is likely to cause death shall be punishable with section 304 part 2. The council believes that the appellant had full knowledge that his actions could lead to such a case, as the advisory guidelines issued by the state in 2024 made him aware that there could be emergencies in which manual exits were compulsory, and also advised them to provide 24-hour host availability, which Arav Mehta ignored, which provides that he had knowledge that such an emergency could occur, but he chose to ignore it. Arav's conduct was not a mere lapse, but a systematic, continuing, and a gross failure, which was indicated by his approach of not providing a manual exit even after the advisory guidelines. No physical spare key was provided even though he had one. Spare key, the word spare key indicates that he had an extra key, yet he did not provide it to the rentals.
But these advisory guidelines are not binding in nature, right? So even if he does not follow it, how does it matter?
Your lordship, I understand your consideration, but I beg to differ on the grounds that these advisory guidelines were not mandatory, but they provided Arav with the knowledge that such an emergency could happen, but he still chose to ignore it and did not provide any manual exits. 2 months prior to the case, a negative review had been posted on his listing, which listed that the smart lock system, which was controlled through remote access, could be delayed, which again made Arav sure, again gave Arav the knowledge that such an incident could happen where there is an emergency. Had it not been for this case, had there been any other emergency, what if there was a fire or any natural calamity where the manual exits were compulsory?
Delayed access is not an emergency. Delayed access, I think it just signifies that the guests couldn't enter the premises because of the smart locking system, right?
Your lordship, the lock needs to be open to enter and also leave the premises.
No, I mean the negative review would not, it is not expected that because of the negative review, Arav would be expected to foresee something like an urgency of a death situation.
But Arav could have foreseen that the access was delayed and could happen again. This would have given him the knowledge that in case if any emergency occurs, it could be the situation that access is delayed.
Yeah, but he must have thought ठीक है, it would be delayed तो भी हो जाता है 1 घंटे में आधे घंटे में, ठीक है, ये
That's
सोचा
his
होगा.
negligence. In cases of emergency, every seconds matter. And losing such an important half hour, because of which a engineering student, 25-year-old engineering student named Ritesh Kulkarni has lost his life.
I just want to point it out. You have quoted in your memo, right, that no physical spare key was provided despite having it. Page
Yes.
number 10.
Yes.
Right? So did your client inquired about the key?
No, your
Don't you
lordship.
think so? It is their responsibility as well to check for alternate option just in case of emergency.
Your lordship, my client was just attending a gathering. He had not booked the house for rental. The house was booked by a person named Nikhil Rao.
Absolutely.
It was not my client's responsibility to check whether the lock was working
So
on.
Ritesh came to whom?
I beg your pardon, your lordship.
Ritesh came to whom?
Ritesh came to this flat which was rented by Nikhil.
Why he was there?
He was called by Nikhil Rao. He was there for a gathering.
Right. So don't you think so it is the responsibility of Nikhil to check with the alternate keys if he knows that these kind of circumstances may come?
This was decided in a case law, in the case law of Sushil Kumar versus the state, Sushil Ansal versus the state, referred on page 3, where on page 5, para number, where on page 4, para number 96, it states that the highest degree of care was owed to owed by the occupier to one who entered the pursuance of a contract with him. So it was Nikhil Rao's responsibility, and Arav Mehta was responsible towards Nikhil Rao to provide reasonable care towards the renters.
See, reasonable care has been provided by Arav. How? By way of giving the security, right? Automated lock.
Your lordship, the lock was sometimes had faults, and also the review is evidence that the lock could be delayed.
So there is no evidence, right? Because the fact which you have again mentioned that prior negative reviews were ignored. Reviews were not ignored. I guess reviews were answered properly.
Reviews were ignored as he has responded, but he has not acted upon it.
How
the
can you
review
say
was because the lock wasn't changed, or there was no, in the factual matrix there is not given anything that suggests that the lock was maintained again, or someone was called to.
Frequent conduct, something like that, then there would have been more reviews. This was 2 months back.
Your lordship, the review is 2 months back, but the lock remains the same. It doesn't change in 2 months. The case law of Sushil Ansal versus the state. This case law refers to the Upahar cinema fire which happened in Delhi. Yes. Para 96 states as the highest degree of care was owed by the occupier to one who entered in pursuance of a contract with him. In case there was an implied warranty that the premises were as safe and as reasonable care and skill would make them. This shows that Arav Mehta had a legal duty to care and provide a safe and a reasonable house to Mr. Nikhil Rao, which he failed to do because the lock was malfunctioning and they could not exit the premises.
Okay.
Much obliged, your lordship. The fourth failure, gross failure, which indicates Arav's failures, is that he was drunk and his phone was silent and he was asleep during the whole incident. There is no offense over here, but he had a duty to care, and the guidelines also advised him that a host must be available 24 hours. It was advisory in nature, but Arav knew that the lock would lock itself automatically after 12 AM. And if the guest wanted to leave or go anywhere, they could not do so without his remote access.
So are you saying that this is something that would amount to negligence, or are you saying that this is something that would amount to him having knowledge that his actions would kill somebody?
This particular point refers to negligence. He knew full well that the guest couldn't leave without his approval, which opened the lock. The app was only registered on his phone, so it could not be operated by anybody else. Arav knew full well that without him the lock wouldn't open. This amounted to negligence, and the other points I stated would amount to knowledge.
So which one do you want us to convict him under? Knowledge or negligence?
Knowledge. 304 part 2. If your lordships are well versed with the issue number 2, council would like to move towards issue number 3. Issue number 3 is that was the wrongful confinement by the appellant. Section 340 of IPC reads that wrongful confinement is whoever wrongfully restrains any person in such a manner as to prevent that person from proceeding beyond certain circumscribing limits is said to wrongfully confine that person. As given in the factual matrix, Arav Mehta has confined the guest in his house, which they can't leave without his prior permission. The guests were unaware of this as stated in the factual matrix. So this fills all the essentials of section 340, and Arav must be held guilty and punished under section 342 of IPC, which states whoever wrongfully confines any person shall be punished with imprisonment of either description.
So you are adding another charge?
Yes, Your
in the appeal stage?
Yes, Your Lord.
Can you do that?
Yes, Your Lord. Apologies, Your Lordship, the council is not aware.
You can't, but it's a very creative thing that you've done. Legally, you cannot.
Apologies, Your Lordship.
Yeah, so let's come back to 299.
Yes,
now
sir.
tell me something. Was the fact that this person was not able to come out of the house the only factor responsible for the death of Ritesh?
It was the major factor responsible. As he
Were there other factors which also contributed to this?
No, Your Lordship.
So the fact that they did not call emergency services till 105, the fact that they skipped the nearer government hospital to go to the farther private hospital, these are of no consequence. इसके वजह से थोड़ी मरा.
I understand your consideration, Lordship, but I beg to differ that bronchial asthma, which Ritesh was suffering from, is a rare chronic disease. Please, I would request your Lordships to refer page number 33 of the compendium, in which I have attached a report which states the prevalence of bronchial asthma among urban school children in Bengaluru city. In the first para itself, it stated that estimated prevalence ranging from 3% to 38%. 3% is a very low number in which people could have bronchial asthma. So his friends, the council believes that his friends, the two attendees who knew about his condition and took him to a private hospital where he could get specialized care at the appropriate golden hour, which was missed due to the smart lock.
Council, it's 3% to 38%.
Your Lordship, the percentage has a huge gap, but it's of Bengaluru city, not of Dakshinayan. So we can't be sure, but
Yeah, but it will be somewhere between 3 to 38. It could be 3, it could be 37.
Yes, Your Lordship, it also could be 3, it also could be 38. But if it was 3 and the government trauma center did not have the appropriate medicine or the specialized care needed for Ritesh Kulkarni, his life could have been lost earlier. At least they tried.
On the next page, it is seen that as there's a chart with age.
Yes,
so as the age grows, the number and percentage is also growing for asthma, as you see.
Your Lordship,
kind of.
Your Lordship, the percent is growing very minutely. It's
But
not.
still, so we can say maybe 3% बच्चों में होता होगा, 38% बड़े होते होते हो जाता होगा.
That's an assumption that the council doesn't know.
No,
about.
that's a trend that I'm just trying to
The
analyze.
trend here is not clear. As in age 14, the percentage drops to 4.91. But in age 15, the percentage is up again by 6.51. And the age of 13, the percentage was 3.14. Yes, yes, Your Lordship. The pattern is not fixed, and his friends didn't knew. Only two of his attendees, two of the attendees knew out of 7 people, and they knew what kind of specialized care he needed.
Okay.
So, okay, let's for once accept that they took him to the private hospital because of such and such reason, because it's very rare and all of that. But still, that does not negate the fact that it was a factor which contributed to delay in his treatment, because of which he died.
Your Lordship, it can't be the factor that delayed the treatment. It was the factor that gave him the specialized care he needed. If they had gone to the government trauma center, and if he was denied the care he needed, his life could have been lost earlier.
Which he lost in any case.
At least they tried to save his life as much as they could. The doctor also noted that earlier intervention could have saved his life. Only if Arav had opened the lock earlier, his life could have been saved.
And what about high alcohol content in his blood? Alcohol does not trigger asthma.
Your Lordship, I am glad you asked that question. I would request your Lordships to refer page number 26, where I have attached a report by Asthma Plus Lung UK, which states that only some alcohols trigger the asthma, and some alcohols can even help the person control his asthma.
Do you have a list of which alcohols can control asthma?
Yes, your Lordship.
You would know.
Yes, your Lordship.
Oh, I thought. Yeah, okay. All right. हाँ, एक से मेरे को देखने दो. Acha, this guy knew he had asthma.
Yes, your Lordship.
Why did he not carry an inhaler with him?
Your Lordship, in the factual matrix, it's nowhere given that he used an inhaler regularly. Many patients who have been suffering from long-term asthma do not need the inhalers as frequently as others. And maybe sometimes the doctor recommends them to stop using them at all so that they can cure their asthma to some extent. Is it true? Oh. Your Lordship, it's nowhere given in the factual matrix that he used an inhaler at all. Yes, your Lordship. But the doctor, when he was hospitalized 6 months prior, it was nowhere given that he was prescribed an inhaler or he used an inhaler frequently.
When he knew that he cannot go to overcrowded places, should not be between people who smoke and drink, then why was he there in the first place?
Your Lordship, no one was smoking, and the council believes they have proven that alcohol cannot be a trigger of asthma. Some alcohols might, but some alcohol also might negate the effects of asthma.
Okay.
If your Lordships may, the council seeks permission from your Lordships to proceed with the prayer. Much obliged. In the lights of the facts stated, issues raised, arguments advanced, and authorities cited, it's most humbly prayed before this court to uphold the judgment of the trial court and pass any other order as it may deem fit in the interest of justice, equity, and good conscience.
What should we do with the appeal?
Dismiss the appeal.
तो वो कौन बोलेगा?
Apologies, your Lordship.
And can we pass other orders based on equity? Equity orders we want to pass. Is that okay with you in criminal cases? क्या? हाँ वही तो बोला. So is it okay if we pass equity orders in criminal cases?
No, Your Lordship.
Then why are you asking for equity orders?
Apologies, Your Lordship. The council pleads ignorance on that matter.
You plead ignorance.
Plead ignorance for the equity word used.
No, you apologize for that word.
Apologies, Your Lordship.
Thank you.
Thank you.
Chaliye. And now this brings us to the last performer, last participant of the day. Next up we have Bhumi Agarwal, the last participant of the final rounds of the 7th Year Moot Court Competition 2026. And Bhumi is gonna again appear from the respondent side in the matter of Arav Mehta versus State of Dakshinayan.
Hello. Hello. If it may please the Honorable Court, I am Counsel Bhumi Agrawal on behalf of plaintiff in the case of Arav Mehta versus State of Dakshinayan. If your lordships and ladyships may permit, I would like to present the submissions to the bench. If your lordship and ladyship may permit, I would like to state the facts of the case. Okay, noted. So, the first issue that was raised was whether a person who retained exclusively technological control over access to a rented premises assumes a heightened legal duty of care towards occupants and whether breach of such duty attracts criminal liability under the IPC. Issue number 2, whether prior warnings, product instructions and earlier complaints established that the appellant had knowledge that his conduct was likely to endanger human life, thereby attracting section 304 part 2 of IPC. Issue number 3, whether the appellant's failure to remain available despite being sole unlocking authority constitutes an illegal omission under section 32 and section 36 of IPC. Whether confinement caused by the appellant's lock system directly and proximately contributed to delayed medical interventions and resultant death. Whether actions of guests break the chain of causation initiated by appellant's conduct. Whether use of automated technology within adequate human safeguards in commercial premises can attract criminal liability where such design forcibly endangers life. If your lordships and ladyships may permit, I would like to proceed with the arguments of the case. So, the appellant's conduct attracts section 304 part 2 IPC due to knowledge of likely death. Section 304 part 2 of IBC applies where death is caused by an act done with the knowledge that is, it is likely to cause death. Intention to kill is unnecessary, but the awareness of probable consequences is sufficient. The appellant deliberately chose a locking system that auto-locked without warning, allowed no internal overrides, and made occupants wholly dependent on him. Knowledge is inferred from surrounding circumstances and prior warnings. For the same, I would like to refer the case of Alistair Anthony Pereira versus State of Maharashtra. The Supreme Court held that the reckless act undertaken with awareness of potential fatal consequences constitute culpable homicide, and Section 304 Part 2 similar reasoning applies here. The appellant created a high-risk situation and abandoned responsibility when emergency arose.
Are you arguing 304A or are you arguing 304 Part 2 right now?
304 Part 2.
Okay. So just by installing an automated lock, how do you prove that he had the knowledge that this would amount to somebody's death?
Okay. So culpable homicide, which is not amounting to murder, applies when death is caused by an act that is done with
No, we know what culpable homicide not amounting to murder is. How do you explain that by installing an automated lock, this person had knowledge that it might cause somebody's death?
Okay, so the appellant had exclusive control over the lock, and when he had the exclusive control, there comes a high responsibility of being available for the sake of the same.
Correct.
And during that time when the rentals are frequent, the risk is foreseeable, and the appellant didn't appear when it was necessary.
So he had a duty of care.
He had
a duty of care.
Yes.
And he breached that duty.
Yes.
Then that comes under 304A,
No,
causing
but-
death by negligence.
Yeah, but it also comes under the culpable, the 304 Part 2, because actually he had prior knowledge to the same thing, and without intention he did cause a death.
No, he didn't cause death. Asthma caused death.
Due to asthma, that was.
So he had no role to play in that. What role did he have to play in that?
He didn't pick the calls which were done to him. He didn't see the messages. He was unavailable.
He was unavailable, but that will amount to him not fulfilling his duty of taking care. It will not amount to him having the knowledge that if he is unavailable, then somebody will die. Na? 3042 will apply when you have a knowledge that your act or omission will result to somebody's death. When he was not picking up the calls, he did not know that by not picking up the call, somebody is going to die. So there was no knowledge.
Okay, so for the same, I would like to prove that there was illegal omission of the by the appellant. Just a second. Under section 32, the words referring that include illegal omission, that criminal liability is not only for doing something wrong, but it is also when you fail to do something that you are liable or you are bound to do.
Legally bound to do?
Legally as well as morally bound to do.
So if I am morally bound to do something and if I don't do it, I can be punished for that?
But here the situation is that due to his illegal omission, somebody's death.
When somebody omits doing something, you can call it illegal omission only when they are legally bound to do that. Was he legally bound to answer his phone calls?
Because he had the exclusive right.
Morally, yes.
Yes.
Ethically, yes. Was he legally bound? Is there any law which bound him to answer his phone calls as and when and wherever the guests called him?
In case of emergency, yes.
Which law is that?
No, there is, in the sense that there was the emergency, like they were calling him again and again.
Which law was that? Is there any law?
No.
If there is no law, then it's not an illegal omission. It's a moral omission. It's a ethical omission. It's an ethical omission, but it's not an illegal omission.
But it can also be included in section 36, where there is partly by act and partly by omission. That is, when the act of installing automatic locking system with exclusive control was done, and the omission was that he did not respond to the urgent calls to unlock during medical emergencies.
Do you have a text of section 36? IPC?
Yes.
Can you read it out?
You want me to read the section?
Yes.
So section 36, effect caused partly by act and partly by omission, person may still be liable as if the whole result was caused by their act.
What does it mean?
The person will be liable even if they were partly in it, but still their whole act will be considered.
See, the section says, wherever the causing of a certain effect or an attempt to cause that effect by an act or by an omission is an offense. So whenever you do or you omit doing something which is an offense, then you will be known to have committed that particular act, that particular offense. Here, not picking up a call is not an offense. So this section does not apply. 32, 36 will not apply in this case. But good effort.
Shall I proceed? So, under the section 299, whoever causes death by doing an act with the intention of causing death, with the intention of causing such bodily injury as in likely to cause death, or with the knowledge that the act is likely to cause death, commits culpable homicide. So, with respect to this, the appellant forms a mens rea, that is the guilty mind, because he had the knowledge that the act is likely to cause death.
That is for you to prove. How did he have knowledge?
Okay, so there was a prior complaint registered already, which stated that there was delayed in the access of locking system. Along with that,
There was prior complaint, right? There was proper reply to it. If the person who has filed the complaint is not satisfied, he might have again, raised that complaint कि नहीं, this is not satisfied, you are saying as it is, बस बोल रहे हो कुछ भी आप. Exactly, हाँ. So the earlier complaint which you are referring to, that already has been addressed, right? Satisfactorily addressed, if I am not wrong. Because there is no reopening of complaint, right? So what is to be done now?
And to continue this, if there was a reasonable person, he would have foreseen that the occupants would require urgent evacuation due to fire, health and emergency panics and other unforeseeable situations in the terms, because there was frequent rental changes in the apartment that he rented. So the appellant had greater awareness because of manual warnings and prior complaints in the same regard.
There is only one complaint, ma'am. It's not complaints.
Okay, sorry,
there is only one complaint.
And the manual warnings in the advertisement and the manual which was given to the appellant, there was already written that it might not, like there would be a delay if there is a network issue, or in the case where there is low network. So,
there is low network over here.
No.
Battery issues.
I am trying to prove that the awareness was there to the appellant regarding the same. That because there were warnings in the manual.
Awareness to
the appellant. Yes, Arav.
Regarding having party after 12, 7 people.
I would like to defend it by that the number of people would not matter if it is the case of somebody, like even if there are 7 people, they would still get the right to move and come and go. There should not be a proper restriction on the entry exits when it is necessary in the same regard.
Okay, but in the current case, I guess the death is for whom? Ritesh, right?
Sorry?
Death is for whom?
Death is of Ritesh.
Ritesh, right?
Yes.
Was he supposed to be there?
He was there, there was a gathering organized, so he just went.
So as far as gathering is concerned, how much maximum people were allowed to be there?
4.
4. How many were there?
7.
What were they doing?
They were actually having a party.
Was it allowed?
No. No.
Then?
But to this, I would like to say that the court, in the case, I would like to refer a case which is Qurban Hussain Muhammad Ali Rangwala versus State of Maharashtra, where the court held that the liability exists when the accused act as the direct cause of death. Here, the factual chain is clear and uninterrupted. That is, the death was caused because there was delayed access, and actually no response could be taken, or he couldn't reach the owner who had the access of coming in.
So in short, you are ignoring what is your mistake and you are just pointing out that, boss, you are responsible. That's it.
No, I would like to say that the direct cause here would be considered rather than the indirect cause.
What was the direct cause over here?
That the appellant who had the sole access or the exclusive access could not be reached. When because when there was an emergency, he was being called again and again, texted again and again, he couldn't be reached.
Acha, this case that you just referred to, Qurban Hussain Muhammad Ali Rangwala versus State of Maharashtra, the line that you have highlighted in your compendium. To impose criminal liability under section 304A IPC, it is necessary that the death should have been the direct result of rash and negligent act of the accused. And that act must be the proximate and efficient cause without intervention of another's negligence. So this case law says, दूसरे किसी के भी इंटरवेंशन के बगैर अगर किसी के वजह से डेथ होती है तो 304A में जाएगा. यहाँ पे there are n number of things wherein we can see that there was some amount of partial negligence or contributory negligence on behalf of Ritesh's friends also. They called the emergency services late. They took him to a hospital which was farther instead of a nearer hospital. So all these things, they overcrowded the place by inviting more people than was sanctioned. All these things are their interventions also. So because of a cumulative effect of not being able to go out, plus these 3-4 things, the death happened. It's not only because they were not able to go out. Had there been no noise, no overcrowding, asthma attack would not have started in the first place. Even after that, delay happened also because they took him to a further hospital. So there are intervening other causes also.
So between 18 a.m. to 12:42 a.m. there were constant tryings to reach the owner of the apartment, and there were messages that were sent to him which marked urgent. And after this long 24 minutes of trial, when they were unable to reach him, they tried the same moment. After a while, Ritesh was collapsed, and till the moment that they could reach the hospital, it took a little while.
Counsel, you marked the 24 minutes when they were continuously calling Arav. Now Ritesh collapsed at 12:50 and they called the emergency services at 1:05. Now what for these 15 minutes delay was? After he collapsed. इससे पहले 12:18 to 12:42 Ritesh was still, somehow managing the moment, है ना? उस टाइम तो वो सिर्फ कॉल्स कर रहे थे, and once he collapsed, then they waited for 15 minutes to call the emergency services.
They could
It was a society, there were private guards, CCTV footages. मतलब guards तो थे ही, थोड़ा बहुत balcony वगैरह से चिल्ला सकते थे, कुछ तो भी कर सकते थे.
So the time that they took to actually reach the hospital or call the emergency services could be because there would have been a panic amongst themselves.
After that, what?
After that, they were trying to open the door which wasn't being opened. They were trying to one of them tried to open the door with the help of the chair,
which was a failed attempt, which they understood nahi khulega.
Exactly. So they were trying to they were trying to open the door, and in the meanwhile it might have took them time, and then they would have realized that they can call emergency services. So the chain of causation is direct, continuous, and unbroken. The defense may argue that asthma, alcohol consumptions, or delayed ambulance calls cause death. However, criminal cases require identification of the proximate and efficient cause. The same that I referred the case before, which was that there was a factual chain that is clear and uninterrupted, that is the auto-lock engagement, which led to inability to exit, and then worsening respiratory disease, delayed medical intervention, which led to death. Medical evidence confirms that earlier intervention could have improved survival chances, thus the lock-induced confinement materially contributed to the fatal outcome. Even if other factors existed, they do not break causation when the accused act remains an operative and substantial cause. Next is electronic and circumstantial evidence fully support prosecution case, that is under section 65B Evidence Act, CDRs, that is call detailed reports, text messages and CCTV footage are admissible and establish the timeline of distress calls, that is the continuous calls were going, the messages were... Okay, noted. Section 106 that places the burden on the appellant to explain facts, especially with his knowledge, namely why no alternative access existed despite exclusive control. The principle in Trimukh Maruti Kirkan versus State of Maharashtra supports drawing adverse inference when such explanation is absent. I would like to refer the case Trimukh Maruti Kirkan versus State of Maharashtra. The Supreme Court discussed Section 106 of the Evidence Act when a fact, especially within the knowledge of the accused, the burden shifts to them to explain the circumstances. Failure to explain permits advice inference. Shall I proceed? Human consequence and public policy.
Counsel, proceed to the prayer.
Noted. Wherefore, in the lights of the facts stated, issues raised, and arguments advanced, and authorities cited, it is most respectfully prayed that the Honorable Court may be pleased to dismiss the appeal filed by the appellant and uphold the conviction under Section 304, Part 2 IPC. In the alternative, sustain conviction under Section 304 IPC. Affirm the sentence imposed by the trial court in the interest of justice and deference. Pass any other order deemed fit in the interest of justice, equity, and good conscience.
Thank you.
Thank you so much.
So guys, with that we come to an end of the final rounds of the 7th Yes Moot Court Competition 2026. 26 ही है ना? हाँ. So अब बारी आ रही है आपके रिजल्ट्स की. रिजल्ट्स के लिए ऑनलाइन वाले बच्चों, we'll come up with a new session. Give us 15-20 minutes because I think आज का discussion में results decide करने के लिए we'll need to discuss a few things. So we'll convene back at 7:15 for the results, prize distribution and felicitation for the 7th Yes Moot Court Competition and the 5th Yes Article Writing Competition 2026. ठीक है? ऑनलाइन वाले बच्चों, आप लोगों को नया लिंक मिल जाएगा, तो I'll see you guys at 7:15. तब तक के लिए अपने सारे दोस्तों को और जितने भी पार्टिसिपेंट्स बचे उन सारे पार्टिसिपेंट्स को बुला लो. बाय. चलो 7:15 गाइस. हाँ, चलो जल्दी नीचे चलो.